Brian Archer, and I'm an attorney member.
Commissioner Ashby Scott.
Good morning. My name is Terry Ashby Scott, and I'm a public member.
Commissioner Briggs. Commissioner Briggs. Oh, Commissioner Briggs, it looks like the mute was activated.
Good morning. I'm Wanda Briggs. I'm a public member of the commission.
Thank you. Commissioner Hedin. Commissioner Hedin.
Good morning. I'm Judge Christian Hedin. I represent the courts of limited jurisdiction. I'm a judge in Walla Walla District Court.
Commissioner Price.
Good morning. I'm Judge Eric Price. I'm the appellate judge member of the commission.
Commissioner Schley.
My name is Jerry Schley, and I'm a public member.
And Commissioner Smith Marshall.
Good morning. I'm LaWanda Smith Marshall, and I'm alternate public member.
And Commissioner Stanton.
Good morning. I'm Judy Stanton, a public member.
Great. Thank you, each of you, for your introductions and for being here today. I'd also like to introduce Connie Rekub, who will be our court reporter for today's proceedings, and also Christy Perry, who will be acting as clerk for the proceedings. Executive Director Reiko Kallner is also present, and she'll help facilitate, as is the IT manager Gareth Cooper. The staff and the court reporter will be generally off camera during the proceedings. And everyone else, I just invite you to the panelists, the lawyers, and the witnesses to keep your cameras on and activated while we're during the proceedings. Kind of just to get things started here this morning, I'd like to begin by asking the clerk to please file the finding of probable cause. And so I'm just double checking with Ms. Perry.
Yes, the finding of probable cause has been filed.
Okay, great. Thank you. For the information of the parties and observers, Commission of Judicial Conduct, or the CJC, the rules require that after a statement of the charges is served on a respondent judge, members cease to have contact with the investigative staff concerning substantive matters in the procedure. Excuse me. Investigative staff at that point assists disciplinary counsel and will do so in this case. Panel members are cautioned to keep incidental conversation with investigative staff to a minimum, and staff and members have been cautioned to guard against the appearance of substantive contact for the duration of this hearing. Panel members are also cautioned that they are not to discuss the substance of the case until the presentations have been concluded and deliberations have been begun. They are also cautioned not to discuss the case with anyone outside the commission while the hearing is pending. Questions about the process, this process may be referred to Executive Director Ms. Kallner. Just as a friendly reminder, please make sure your cell phones are silenced. A nice fail-proof way to do that is to shut them off just completely. That's a good way to go too, but if short of that, you can just make sure they're silenced. Counsel and others present at this hearing may be aware that at least some members of the panel participated in the preliminary investigative part of this case. At that time, the members relinquished all materials about the matter before them now for the hearing and have ceased having further contact with investigative staff about the matter. As the presiding officer, I remind the panel members that your duties in the earlier investigation are not the same as your duties in this fact-finding. To the extent you might retain any recollection of information from the investigative part of the proceeding, you're required to put such information aside and to rely solely on the evidence and the law presented to you at this hearing from disciplinary counsel and from respondents counsel. Disciplinary counsel has the burden of proof to prove facts and code rule violations by clear, cogent, and convincing evidence. Clear, cogent, and convincing evidence, as described in Commission on Judicial Conduct Rule of Procedure 7, following the definition enunciated by the Washington State Supreme Court, is the following. Clear, cogent, and convincing has been defined to mean highly likely. The contention has been proved by clear, cogent, and convincing evidence if it is established that it is highly likely to be true. This level of proof requires a greater weight of evidence than preponderance of the evidence, which has been defined to mean that a contention is simply more likely to be true than not true, but less than the evidence required by beyond a reasonable doubt, which has been defined to mean that a contention almost certainly is true. The commission's case will be presented by disciplinary counsel Paul Taylor and Victoria Molina, except as otherwise provided in the commission's rules of procedure, the rules of evidence applicable in civil proceedings before the superior courts of Washington will govern. Disciplinary counsel will present their case first, followed by the respondent's case, which will be presented by Mr. Gross and Ms. Bremner. Disciplinary counsel will be offered an opportunity to present any rebuttal evidence, and both parties will be permitted and are encouraged to provide the commission panel with closing argument and recommended disposition of the case. As part of the duties of the presiding officer, it is my duty to rule on the evidentiary and other procedural questions, and I'll make my rulings based upon the legal principles applicable in civil trials according to the rules of the commission. I may, under the commission's rules, refer any of these matters to the entire hearing panel. If the panel does confer on something during the proceeding, we will be placed in a breakout room by staff for that purpose. The witnesses in the case shall be subject to direct examination, then cross-examination, and reasonable redirect and recross examinations. In addition, the members of the hearing panel are permitted to examine any and all witnesses concerning their testimony, in which case counsel will be permitted an opportunity to object and also have opportunity for further inquiry respecting any such witness. Prior to this hearing, I issued an order which stated in part that the fact-finding hearing will begin on November 19, 2024 and scheduled to conclude on November 20th, 2024. The morning session will run from 9 a.m. until noon with a 15-minute break at or around 10:30 a.m. The afternoon session will run from 12:30 p.m. until 5 p.m. with a 15-minute break or around 3 p.m. Any witnesses in this matter other than the respondent are excluded from the hearing until they are excused from further testifying. So those are kind of the preliminary issues I wanted to go over. Thanks for your attention to that. At this time, I just would advise, ask counsel if they could please advise if there's any witnesses on the Zoom call currently. Maybe Mr. Taylor, do you see any witnesses on the Zoom call currently?
No, Your Honor.
Great. Ms. Bremner, Mr. Gross?
Don't give me an echo.
Nope, I got a.
No, Your Honor.
Great, I got a head shake no, and then an official no there. Great, thanks. Okay, there was excuse me, there were two motions filed yesterday by Respondents Counsel, and wanted to just take those up currently and address those, and then we could look at any other preliminary motions or procedural matters. So first off, there was a motion to interview Regina de los Santos, and that was filed yesterday. And I wanted to make sure that Mr. Taylor, it looks like you submitted a response to that. Is that correct?
Yes, Your Honor.
Okay, great. So let's address that one first, and then we can move next to the motion to add additional hearing exhibits. Mr. Gross, I think you were the author of the motion. Do you want to go ahead and proceed just with a short review of the motion and present your motion?
Yes, thank you, Your Honor. All right. Test. Sorry, Your Honor. Okay. I think this is better.
Yep.
Okay. So what we really are asking for is just a very short amount of time to interview Ms. De Los Santos. I know we mentioned a deposition, but that's sort of an alternative argument. We just want a chance to have a conversation with Ms. De Los Santos and figure out what she's going to say during this hearing. As Your Honor knows, that kind of thing happens all the time in these kinds of trials. In fact, we've conducted all of our witness interviews in the last 3 weeks, except for Ms. De Los Santos. At the readiness hearing, I mentioned there was one person remaining to be interviewed, but that I didn't anticipate. any issues because I knew she was reachable and she's a King County employee and she had been in good contact with disciplinary counsel. We also had, we knew that she had been cooperative throughout the King County District Court's investigation, as well as disciplinary counsel's interview of her. And we had absolutely no reason to think that she would not voluntarily submit to an interview or that we would need to be asking for an order to compel her to give an interview. We don't know why she's refusing to be interviewed. She's only refusing to be interviewed by our side. And that I think is all the more justification for this court to find there's to find that there's good cause to allow us a very short period of time, preferably during a break, to interview her. We could probably get it done in 15 minutes. Thank you.
Thank you, Mr. Gross. Mr. Taylor?
Yes, Your Honor, there are 4 reasons why the motion should be denied. First, they've known for months that she was a witness. Second, we gave them our interview memo of Ms. De Los Santos approximately 4 months ago, so they've known exactly what she was going to say. Third, the discovery cutoff was in July. And finally, Your Honor, it's just a matter of logistics. We have our witnesses scheduled in an order. She's the first witness, and we have everybody else blocked out at particular times. If we have to shuffle her as a witness, then all the other cards start falling. And I don't know that the other witnesses will be available at a different time if we have to reshuffle our witnesses. Finally, in terms of her not being willing to speak with defense counsel, I think, cutting to the chase, I think maybe they rubbed her the wrong way in trying to set up interviews with her. And she finally decided, as I understand it, she simply didn't want to talk to them, as is their right. And one last point, I'm not sure the commission has the authority to order an interview as opposed to a deposition, and there's not time for a deposition at this point.
Thank you, Mr. Taylor. Mr. Gross, just a couple questions of follow-up. It sounds like Ms. De Los Santos was first interviewed sometime in June of this year, and then with the discovery cutoff of about July. Prior to November 1st, when it's, according to your briefing, that you reached out to set up the interview, were there other attempts to reach out to set up some type of interview prior to November 1?
Prior to, not that I know of, that's about the time I joined the case, and as far as I know, there were not prior attempts.
Okay. And then at the readiness hearing on November 8th, I don't, correct me if I'm wrong, I don't remember there was a specific mention of Ms. De Los Santos, just there was in general a witness.
Correct. I didn't specifically identify her.
Okay. All right. Thank you. And then, Mr. Taylor, as far as well, let me back to Mr. Gross. Mr. Gross, as far as the content of her, the substance of her potential testimony, do you anticipate there's going to be any surprise testimony coming from her based on the investigative notes and the preparation that you've made for the trial?
Well, disciplinary counsel, as far as I know, it was Miss Molina who interviewed her, and I think she did ask her some of the questions I might ask, but as Your Honor knows, one side has a lot of different questions than the other side. I think there's a lot of information that we don't know that I would like to ask her about that's not contained in the interview memo by disciplinary counsel.
Thank you. And Mr. Taylor, as far as your witnesses, I think you've endorsed, I believe, several judges of the King County District Court. Are they scheduled for this morning?
Yes.
And do you have any witnesses scheduled for the afternoon?
We have at least Heather Dean, who's not available this morning. And depending on how long the crosses go, some of the witnesses, our case may spill into the afternoon.
Okay. All right. All right. Any further comment, Mr. Gross?
I just am somewhat interested in how we could have rubbed Miss De Los Santos the wrong way. I left her a very polite voicemail that I wanted to interview her and then left her alone for a week and a half. Our paralegal called and politely asked for her information. And then after that, I continued to leave voicemails, also very polite. And when I did talk to her, I just let her know who I was and that I wanted to interview her. Not sure what I did to rub her the wrong way, but I think that's another question that I would ask her during her interview.
Thanks. And then, and last question for Mr. Gross, as far as you know, with the reach out on November 1st and the follow-up call on the 7th and then on the 15th, at any time during that process, did you contemplate moving for a deposition of Ms. De Los Santos?
No, because about the time I called her, I was also contacting all the other witnesses, and all the other witnesses were cooperative. And then I spent my time preparing for and interviewing them. And then when I finished that process, that's when I reached back out to Ms. De Los Santos.
Okay, great. Thank you. Okay, so the motion is to allow an interview of Ms. De Los Santos prior to the hearing. My understanding from the briefing from Mr. Taylor is from his viewpoint is that that's the first up witness. That's the kind of the foundational piece related to the alleged letter that was submitted to the parking garage attendant, which in turn went to Ms. De Los Santos's hands. So there's that issue about, you know, potentially moving witnesses around and the like. I think the bigger issue is that this is a witness that's been well known for a very long time. The substance of her potential testimony is well known. There's not huge disputes as to what she's likely going to be testifying to, as that's been widely circulated, what she knows about the case. In addition, there was a discovery cutoff on July 6th of 2024. And even as late as November 8th at the readiness hearing, where there was potential indication that Ms. De Los Santos had not yet been interviewed. At that point in time, if she had not been interviewed and there was further concern that she may not be willing to be interviewed as was raised as a potential, there's potential for moving to have a deposition. I think because that there's no indication also that there's going to be some big surprise with her testimony. She's going to pull a rabbit out of a hat and it's going to shock everybody. I'm going to deny the motion for the interview of Ms. De Los Santos, and we'll proceed with her testimony today. The next motion is a motion to add exhibits. I've reviewed that, and I understand, Mr. Gross, that you are not moving to admit, but just list them as potential exhibits that could be addressed during the hearing and moved for admission if desired. Is that accurate?
Accurate.
Mr. Taylor or Ms. Molina, do you have any comments or objection to that?
No, we have no objections, Your Honor.
Okay, so I'll allow those exhibits. I believe it was exhibits 317 through 323 to be added to the exhibit list. And Mr. Gross, did I get those numbers correctly? The 317 to 323?
Yes, you did.
Okay, great. So any other preliminary motions that either party would bring at this time?
No, Your Honor.
Okay. Mr. Gross, Ms. Bremner?
Your Honor, can I ask for an update on the live stream chat, the live chat, whether that's enabled or what the status of that is?
Yeah, thank you. Thank you for that reminder. Let's maybe we could tap into Mr. Cooper, who's the IT manager. Could you just give us a brief update as to the YouTube comments? Mr. Gross, I believe at the last hearing had mentioned concern about comments being posted and on the live stream, and the ability potentially to either shut those off or limit that in some fashion.
Yes. So I am able to, the live chat is still enabled while the live stream is going, and I don't have a way to disable that. What I do have the ability to do is once the live stream is done and the video is saved, I can then remove the live chat from the saved video so that it's no longer viewable by anyone who wants to go back and view the recording.
So the live chat is active during the hearing, and then at the end of the hearing, once it's complete, then you can go back and disable that and remove the live chat.
That's true. And if I see anyone making comments in there, I can try to keep checking back and forth as I have time to remove any sort of disruptive comments or anything like that if they come up, but it's kind of limited to when I have time between watching what's going on with Zoom and being able to check back and forth.
Okay, thank you. Ms. Colliner has her hand raised. Ms. Colliner?
Thank you, Your Honor. For the information of the attorneys, and for the record, the panelists will not see the YouTube in any way, shape, or form, nor will they be privy to any of the information in the chat.
Thanks. Mr. Gross, any comments or thoughts?
And just to confirm that Mr. Cooper will, after this chat is, or this stream is over, go in and remove the live comments. That he'll do that as a matter of routine each day.
Yes, I will.
And then my other question is, the permanent comments are also disabled, is that right?
That is true. Yes, those are disabled during the live stream and on the saved video.
Okay.
Yeah.
All right. Thanks, Mr. Gross. Any comments, Mr. Taylor?
No, Your Honor.
Okay, very good. If there's no other preliminary issues, we can go ahead and get started. And I'll just ask the parties if you're ready for opening statements, Mr. Taylor.
Yes.
Okay, and Mr. Gross.
Your Honor, I have some very brief motions in limine.
Okay, go ahead.
I guess one thing to just advise, Your Honor, is that during my interview of disciplinary counsel witnesses, a substantial amount, I would say the vast majority, what each person had to say was not something that they knew from personal knowledge. It's probably not something that can be addressed wholesale pre-trial, but just to make the court aware of that and that there may be substantial objections as far as personal knowledge. There are two main topics that I think the court should address. Disciplinary counsel has, I think, listed as a summary of one of their witnesses that they intend to testify about a prior alleged event, I guess, at King County District Court involving Judge Razumna that is not related to this incident. And I think that is not relevant and is under 403, should be excluded during trial. I don't know if Mr. Taylor knows what I'm referring to.
I'm aware of what he's referring to, Your Honor.
Okay. So,
oh, sorry.
Go ahead, Mr. Gross.
And also, it's 404B, I guess, prior acts.
Okay, so you're making a motion in limine to have that excluded. Is that accurate? Okay. So I saw the mouth move and you muted it just perfectly, so I couldn't hear you.
Correct.
Okay. All right. Thanks. And Mr. Taylor, response?
Yes, Your Honor. As to the foundational matters he referred to, we can address those witness by witness. If we can't establish appropriate foundation, it can't come in. We understand that. As to the prior disciplinary action under the Deming factors and in the Commission's rules, any prior disciplinary action is relevant to determine the appropriate discipline if a violation is found. So it's not a 404B issue. It's not a relevance issue. It's a Deming factor issue.
Thank you. Mr. Gross?
No, this would be considered a disciplinary action. It was a administrative action with the King County District Court that I think had nothing to do with this commission or I guess what I would consider disciplinary action.
Mr. Taylor?
He was suspended as a pro tem judge based on certain actions he took.
Okay. And that particular topic would be coming through which witness, Mr. Taylor?
One or more of the judges.
One or more of the judges. Okay. I'm going to reserve ruling on that, and we'll take it up as we move during the hearing. So we'll just address that, and it can be an objection can be raised, and we can just I want to hear just a little more information, a little more context before I make a ruling on that. So that'll be reserved. As far as the personal knowledge, we'll take those as they come up. Any other?
Okay, and the other area that I'm seeking to exclude before we start is all of the post-incident administrative machinations at the King County District Court, especially involving the Personnel Committee and the Executive Committee. Also, none of that is relevant to what actually happened in this case.
Okay, so more precisely, what's your motion?
To exclude the administrative aftermath from the King County District Court regarding what happened in this case.
And that administrative aftermath, a little more detail on that.
Sure, and I guess I'm not seeking to exclude the investigation of Mr. Whitley, because he interviewed people and kind of gathered some information. What I'm seeking to exclude is what happened at the personnel committee level and the executive committee level afterwards, because those aren't relevant to the facts of this case.
Okay, thank you. Mr. Taylor, any comments on that?
Yeah, certainly. First of all, they addressed all those in their trial brief as evidence in mitigation. Second, what occurred after the event goes to the gravity of what occurred and the level of disruption to the court system as a result of what Judge Rozimna did.
Okay. All right. As far as the motion to exclude the executive committee and the personnel committee, I'm also going to just reserve on that, and we'll handle it in stream. So we'll reserve on that. Any other motions, Mr. Gross?
No, Your Honor.
Okay, Mr. Taylor, any more from you?
No, Your Honor.
Okay, great. I think that takes us to opening statements. So we'll turn the time to disciplinary counsel for their opening statement. Then we'll hear from respondents counsel for opening statement.
Thank you, Your Honor. Ladies and gentlemen of the commission, this is a simple case. Judge Rozimna exercised very poor judgment, extraordinarily poor judgment in creating and using a document. When what occurred came to light, he was dishonest about what had happened. That dishonesty continues to this day. So what happened? Let's all go back to February 16th, 2023. It's after 4:30. Judge Rozimna is done with his pro tem work for the day, and he's about to leave. His car is parked in the county parking garage, and he wants to get a $10 discount off the parking fee. He's tried several times in the past. Each time it's been denied because, according to him, he wasn't able to prove that he was a county employee. So what does he do? He sits down in his office and he types a letter. Can we have Exhibit 201 up, please? Sits down and he types up this letter. February 16th, 2023. David Rozimna is employed with the King County District Court as a judge pro tem. And then he was pro temping for Judge Robertson. So what does he do? He takes Judge Robertson's court stamp and endorses the letter with it. And it's hard to see on this version, but it's dated February 16th, 2023, her court stamp. And to do that, he had to take the stamp, and not only he had to adjust the date and the year to make it match the letter that he had created. When he was done with that, he then went out into the courtroom, out of chambers, and took the official King County seal and endorsed the letter with that as well. Judge Rozimna says that at that point then, he added between 3 and 5 additional stamps. According to him, these stamps were spread all over the letter in random fashion. The evidence is going to show that there were not 5 stamps or 7 stamps. There were 2 stamps. No more. What does Judge Rozimna say? He says it was a joke, a farce, and that's why he put these random stamps all over the document. Judge Rozimna took the document, got in his car, pulled up to the parking gate, gave it to the attendant. The attendant didn't know what to do with it, so he took it to the manager of the garage, Ms. De Los Santos, who will testify here today. She looked at it. She didn't know what to do with it, so she called the budget director at King County of the District Court. There was no answer. So she took a picture of it. That's the document you see in front of you. She took a picture of it and sent it off to the budget people. That's the last, well, after taking the picture, she gave it back to the parking attendant with the instruction that he he returned the document to Judge Razumna. That's the last anybody saw of the original of the document. So what happens next? The budget director sees the letter and she forwards it to the presiding judge because she thinks Judge Robertson doesn't understand that pro tem judges aren't entitled to the parking discount. Presiding Judge York then sends an instant message to Judge Robertson saying, hey, pro tem judges aren't entitled to a discount. Judge Robertson is puzzled. She doesn't know what Judge York is talking about. Well, then he tells her about the letter. And that's when she learned what Judge Razumna had done. She'll testify, and you'll hear what her reaction was. At that point, the district court started an investigation. And you'll hear from the HR director who interviewed Judge Razumna that he had two stories. One is the letter was a joke. It was a farce. He was kidding around as he always had with this particular parking attendant. The other explanation he'll give is, hey, I'm a King County employee. I was entitled to that discount. They can't both be true. So that's what brings us here today. I want to talk now about Judge Razumna's story that the letter was a farce, was covered with stamps. There's at least 4 problems with this. Go to the first slide, please. Ms. De Los Santos will testify in no uncertain terms there were 2 stamps, no others.
I object. I object to this. This has not been disclosed.
You're objecting to the PowerPoint? Ms. Bremner? Ms. Bremner, can you hear me?
I'm sorry.
Ms. Bremner, can you hear me?
Yes, I can now. Thank you. And I didn't hear what you just said, Your Honor.
Yeah, I'll repeat it. Are you objecting to the use of the PowerPoint?
Yes.
Mr. Taylor?
There was no pretrial order requiring disclosure of demonstratives to be used in opening statement. We haven't seen any of theirs either. I'm illustrating what I'm going to prove. If I can't prove it, that'll be my problem.
Your Honor, I think it's customary in my 40 years of practicing law and trying cases is we usually exchange these things as a courtesy. This has never been shown to us. We've had plenty of time to prepare, as what counsel has just argued with respect to the witness disclosure issue and interview. So I object to all of it. We've never seen it.
Mr. Taylor, besides this PowerPoint, the 1-pager with the 4 points, are there others?
There's one other that lists the witnesses who will testify.
Okay. All right. So the objection is use of a PowerPoint to list expected testimony that will be coming from the witnesses. So expected testimony and evidence can come through verbal means. Generally, that's done through opening statements. And at this point, I'm going to overrule the objection. It's just a different form and format of sharing expected evidence. Go ahead, Mr. Taylor.
Thank you.
Thank you, Your Honor. As I indicated, parking garage manager, Ms. De Los Santos, will testify that there were 2 stamps, no others. She took a picture of it, and that picture represents the totality of what was on the document. We have the next slide, please. Second, remember that when Judge Razumna picked up Judge Robertson's stamp, he had to adjust the date to match the date he had put on the letter. In his deposition, we asked, well, if this document was a farce and a joke, why did you need to reset the date stamp? His answer then speaks volumes. He said, I don't know what to say. Third, what I like to call statistics. What are the chances that just acting randomly, picking up one stamp, then another, what are the chances that we would first see Judge Robertson's stamp, and then right next to that, the King County seal? Well, if there were a total of 5 stamps, the chances that those 2 would appear as they do, chances are 1 in 20. How do we get there? Well, the first stamp he's going to use, he's got 5 different possibilities.
I object. This is argument, not opening statement.
Yeah, Mr. Taylor, it sounds like it's argument.
Very well.
So I'll sustain.
The evidence will show. The evidence will show that the chances he could only pick up I'll save it for closing argument. Go to number 4. The document, again, Judge Razumna says, was a farce and a joke. Well, he went out of his way, though, to get the King County seal. He had to leave Chambers, go out in the courtroom, find it in the clerk's desk, come back to the office, come back to Chambers, and then stamp it. So the notion that it was a random exercise doesn't square with the facts. Let me change now to the witnesses you're going to hear. Ms. De Los Santos, 2 stamps, not 5, not 7. She gave the letter back to the attendant to return to Judge Razumna. Judge Robertson, she'll testify about her confusion upon hearing about the letter that she supposedly endorsed. And she's going to talk about the gravity of what occurred. Third, Kevin Whitley, he's in charge of HR for the district court. He interviewed Judge Razumna, and he'll tell you the results of that interview and the 2 stories that Judge Razumna was telling. Judge O'Toole, she'll talk about a unanimous vote taken by the Personnel Committee about how to address what had occurred. And then finally, Heather Dean, she's the district court budget director. She'll testify. Pro tems don't get parking discounts. She'll also talk about the severity and the gravity of what occurred. Let me change gears now, Your Honor. What are we going to hear from the respondent? Well, he says he regrets what he did, and he made a mistake. The evidence is going to show that that hasn't always been his point of view. Let's go to Exhibit 313, page 3, please. This is a text, the top block in blue. This is a text that Judge Razumna sent to a different judge.
Objection. We have a pending objection on this, Your Honor.
The use of Exhibit 313?
Correct, Your Honor.
If I'm not mistaken, this part of the initial motion as to 313?
Yes.
Okay.
Yes, Your Honor. Thank you. We'd ask that it be taken down and ask that the panel be instructed to disregard.
I think my preference would be as far as exhibits that have not yet been admitted, while there's this is an expectation of what the evidence would show. There's some question whether it'll come in or not come in, and so I think it would be wise to hold off on the presentation of exhibits that have not yet been admitted during the opening statement. You can certainly verbally describe them, but I think the visual should wait. So I'll grant that.
Thank you, Your Honor. Can we take it down?
Well.
Yeah, it should be removed from this.
Upon being notified that there was going to be an investigation by the HR committee, Judge Razumna sent a text to a fellow judge. Could we take that down, please? He sent a text to a fellow judge saying, I just got a nutty letter from the weasel who told me there's going to be an investigation, and he misconstrued everything. The weasel he's referring to is the chief judge of the district court. Remember, when he says now that he made a mistake and he regrets it, think back then what he was telling people. Later, later, upon hearing that a bar complaint had been filed and dismissed because there was lack of jurisdiction, Judge Razumna complained to that same judge that, gee, there's likely going to be a CJC proceeding. And he was upset about the fact that this body was going to conduct an investigation. When he expresses regret now, remember what he said then. What else are you going to hear? He says he was simply trying to get a benefit to which he thought he was entitled. Well, except that is true. Does it change anything? No. There's a right way to go about it. He had been denied several times this discount. The right way would be to go to the administrator of the courts or the budget office. The wrong way is to phony up a document, endorse it with stamps without authority, without authorization, and try and blow it past a parking attendant. After multiple denials, you would have thought that that's what he would have done. He would have gone to the court administrator. He didn't. What else are you going to hear? Well, the trial brief suggests that he's already been punished enough. He was removed from the pro tem list of the King County District Court and the King County Superior Court. That's really just evidence of the fact that several judges looked at what had occurred and determined that he was no longer fit to serve as a judge. Snohomish County suspended him for a lengthy period of time. He complains about that, or he offers that in mitigation. Again, that's simply evidence that other judges looked at what occurred and deemed him unfit. He says in his trial brief that Snohomish County public defenders have been affidaviting him. Again, that's evidence that lawyers looked at what happened and determined that he was not fit to serve as a judge. So that's what this case is about. I said at the start, it's a simple case, and it is. I've made promises about what the evidence is going to show. I want you to hold me to those promises. At the end of the case, and based on the evidence, we're going to ask you to censure Judge Razumna and issue an appropriate disciplinary order. Thank you very much.
Right. Thank you, Mr. Taylor. We'll turn the time to respondent counsel for opening statement.
Thank you, Your Honor. Can everyone hear me all right?
I can hear you.
Thank you. Okay. This was a simple matter, members of the commission and Your Honor. And it's in looking at this case, it really went from sublime to the ridiculous. You know, counsel's made a lot about things that were in dispute, but also miscommunicated. And I want to start with that. Where is the parking attendant? All that happened in this case was the judge was entitled to the benefit, and he made a joke. Now, we've heard over and over again, there's two stories. He made these different stories. One was that it's a joke, and then the other is that he was entitled. Oh, those two things aren't mutually exclusive. He did say it was a joke, but he also said, and that's the charge from this commission and this lawyer, the private law firm appearing as disciplinary counsel, that he wasn't entitled to this. So he's saying he was. It's really simple. It is a simple case. He did make a joke, and guess what? He was entitled to the benefit. I want to start by talking about one of our witnesses. So I think this is very helpful in terms of framing this case, and that is Judge Hirakawa. He's been a King County District Court pro tem for years, and he knew he was an employee. And that's a big miscommunication in this case, too. It made me think of that game used to be called Telegraph or then Telephone, or I don't know what it would be called today, when something is stated to another person and then to another person it's whispered, and whatever was initially said, there's no resemblance to what the last person said they heard. This was a case where we don't even have the person that purportedly had this conversation with the judge. We don't know where he is, but we do have a witness that won't talk to us and will only talk to commission counsel. with certain opinions and a partial piece of paper, Exhibit 201. But I want to start with this Judge Hirakawa. Pro tem for years. He knew he was an employee of King County. And here's the question. Who else would our client work for other than King County? And that was even a question that Mr. Twitty, who was kind enough to meet with us early on with Ms. Colliner in an attempt to resolve this, that even then they were saying, well, he didn't work for King County. That was part of the charging in this case. I mean, I was there. We had that conversation. He definitely worked for King County. He was entitled to the discount. It was a discount for King County employees. Period. End of story. And that's what this judge would say. Now, also in certain committee meetings, I just need to hold on. In certain committee meetings, they couldn't talk about pro tems outside of the executive committee, which this judge was on. Because why? Because the pro tems were employees of King County. And he'll testify to that to you under oath. And here's another really important part of this very important witness's testimony. He said that during COVID, to get people into the office, Dow Constantine put a parking rate, cut it from $20 to $10. He cut the rate in half for King County employees. And they had stickers for, guess who? Pro tems for King County and other employees to pay for parking at Goat Hill. Again, he was entitled to the discount. They had stickers for the pro tems. And indeed, he worked for King County. And this is according to Judge Hirakawa. We asked him if he'd ever heard of a policy that pro tems were not entitled to a discount. You know what he'll testify to, again under oath? Absolutely not. He never heard of a policy that pro tems were not entitled to a discount. There's no written policy. And by the way, I asked Mr. Taylor for that in writing. I said, I would like to see in discovery, and we hereby demand to see any policy that excludes pro tems from the parking discount. And the answer was, there isn't one. There isn't one. And yet here sits our client going through all of this time, through these proceedings, through the committee in King County, through the Bar Association, through Snohomish County public defenders, all based on a misunderstanding or a lack of understanding is the better way to look at it. There's no, Dow Constantine said also, and of course he's the county executive up until the next one. Of course, he's not going to run again, but he's been there for quite a while, of course, for the county. All employees get discount parking. There's no asterisk. All King County employees get discount parking. That includes pro temps, and that includes our client. This judge does not have a particular close relationship with our client. He's just somebody stating the truth. He also said that something that's important in this case is that our client is funny. He's got a quirky sense of humor. He actually, I think at some point, wore a Batman belt buckle. I mean, he's a little quirky sense of humor, and that's okay. I mean, everybody has a different sense of what's funny. And I think all of our senses of humor, are different. And that's a great thing. I took a class in college called Humorous Communication, because the question is, what do you think is funny? And these are some things like a Batman belt, or what he did with this particular document he thought was funny. Now let's turn to that in terms of what actually happened. This counsel's never found this witness. Now I argued that, almost like with the missing witness instruction, they would have the best access to this person, right? And they haven't found them, because we need to know what that person would say about a conversation with the judge. At the time that this occurred, there was a full piece of paper. Exhibit 201 is partial, and we've objected to it on authenticity, excuse me. Why is it only a picture of like Like I can hold up a tablet here and it only shows the top. It only shows the top of the quote unquote document. You see nothing else. The judges said that there were stamps all over. Where did those go? You know, and we'd ask you to use your common sense. And we also thank you, of course, for your service on the commission on these important matters, and matters so important to the judge and his family. There was a full document. It never went back to him. Maybe someone was instructed to give it back to him, but it never went back to it. That document doesn't exist. It's gone. All we have is a partial picture that only shows two things. We submit to you that that's not the full document, and you'll hear from the judge about that. He has been most of his career a judge. He has been, and he loves it. He's really full-time in terms of pro tem up in Snow County, but he's also been in King County. He graduated law school from Seattle University in 1997 and had a private practice for some time. And he served as the chair on the Fitness and Character Committee for the State Bar. So he weighed in on, of course, and led that committee for some great length of time, dealing with character and fitness of lawyers. So he was put in that position of trust based upon his ethics, integrity, and reputation for his ethics, high ethics and integrity. And he had a lot of difficult decisions to make in that capacity about lawyers sitting for the bar, their relationship with the bar, their ability to practice. He has a family. He's in Finney Ridge, and he volunteers in the Finney legal clinic and has for a long time. He loves being a lawyer, but he really loves also being a judge. He's gotten a lot of letters and emails and texts from people that thank him for caring about them and their cases. Not just going through the motions every day when he goes into court, but really making a difference. And that's something that he's always treasured. He did say he made a mistake here, but here's why. I mean, because he's been through everything in this, meetings with the commission, with the executive director and with Mr. Twitty, and going through this at length. The exchanges he had with the parking attendant were kind of in fun. Like, you want to see my robe? Because what's the proof that you're a judge? You know, how do you prove you're a judge? In these days, you don't have the same paper trail that we had when I was in the prosecutor's office with the county, or any of us, you know, before the internet age. So he didn't have like physical paperwork to show to the parking attendant that he's a judge. And frankly, I don't know how many people showed documentation at the garage to get the discount when you think about it. We just don't know. I'm assuming it didn't always happen, or that people didn't go through the ringer like Judge Razumna did. So he said, "Do you want to see my robe?" And he shows him the robe. He actually put it in his car and said, I'm a judge. I'm a pro tem judge for King County. And then some other things over time. And then he just stamp, because all of those stamps are sitting in chambers when you're pro temping. Not as an official document, but as a joke. And he said, and he showed the parking attendant, "Look what I made for you." And he laughed and he said, "Would I have all of these if I weren't a judge?" I mean, I'm paraphrasing. "Would I have all of these if I weren't a judge?" He didn't attempt in any way to say, "These are signed by Judge Robertson or any other judge or anyone else who's endorsed me as a judge." Let's go back to what counsel just argued and has been the root of this case going forward. And that is, he said it was a joke. And it was a joke. He didn't mean it as something, as an official document. But part two is he was entitled to the discount. Why would he make something up like that to undermine his entire career and end up before you if he didn't believe he was entitled to it, the benefit? And he was clearly entitled. Disciplinary counsel says that the judge has been inconsistent and made conflicting statements, but he hasn't been about his intent in creating the letter. He's been completely consistent. It was a joke, and he was entitled to the benefit. He's always said that from the beginning until to this day, and that's what he's going to say when he testifies. And they're going to call him as a witness. At least that's what they say. With respect to his sense of humor, Judge Robertson, and we'll ask her about this, she'll testify that he's funny. He's witty. He has a very dry sense of humor. He's not one of those ultra serious judges. That's just who he is. And what happened in this case is in keeping with what he's always said consistently. He was just being funny. You have to think again, common sense. Why would he do this? Well, why would he do this? Throw everything away to get a discount at the Goat Hill garage at the county. I mean, why? When he's clearly entitled to it. And everybody knows that, including him. And common sense dictates this case should not be going forward. He thought it might make the parking attendant laugh. It was on plain computer paper. And it was, he wasn't creating anything that was official looking, or anything that would look like it was written by Judge Robertson. And again, would he put together a fraudulent document to get a $10 discount? I submit to you, no. And I don't, I'll strike that part. The star witness for the commission is Gina De Los Santos, who won't speak to us. So all she knows and all she can testify to is that she was given this note. Now we submit the note that was given to her had stamps all over it. She only took a picture of the top of it. Of course, the note's missing and gone, and that fact should be held against the commission counsel. And this is so important, when she was first asked, and this would have been about 3 weeks after she took the photo, when she was first asked about what she saw, she said she didn't recall seeing any other stamps. She said she didn't recall seeing any other stamps. She didn't say she was adamant there weren't any. That's what counsel's going to tell you now, or she won't talk to us. But she said she didn't recall seeing any other stamps. That's their entire case. It's their entire case. She's voluntarily given interviews to disciplinary counsel on a number of occasions, and has said that she looks like she's picked a side, although she's not going to tell us, and maybe she will, about how she was rubbed the wrong way, according to counsel, by my co-counsel, Mr. Gross, or our paralegal, Karina Martin. We know of nothing like that could have occurred or did occur. Now, again, looking back at the theme here of like misunderstanding and miscommunications, a lot of the reason that we're here today, I'd submit to you, is because of the misunderstanding that he was not a King County employee. That's what Mr. Twitty said to us, and that's what a number of the judges who will testify here for the commission and who were involved in any committee that's been described thought back then. So again, if you start with the assumption he wasn't entitled and he wasn't an employee, then you come to a completely different conclusion with respect to whether or not he did something wrong, which he didn't. But I think that was a very unfortunate conclusion that was erroneously reached by a number of people, including the office of the CJC. There's no ID card that a pro tem judge has. He was hired as a commissioner pro tem by King County. That validation is given to pro tems parking at the Goat Hill garage. But also, I don't know if any of you have been in the Goat Hill garage, but of course it's on a Goat Hill up from the courthouse. But it has a separate entrance underground that goes to the tunnel at the admin building, where you can go through security and then go through another tunnel into the courthouse. So again, it's meant to be used by King County employees by virtue of the way that it's set up. Of course, the disciplinary council has to prove this by clear and convincing evidence. And when you look at the history of this commission and rights afforded to judges as they go through these proceedings, that's an appropriate burden of proof. Submit to you that they can't. And some of the things not only that have been urged on you that are not correct, i.e. that he gave inconsistent statements, he didn't. That he was not entitled to the benefit, he was. That he had a fraudulent piece of paper with stamps on it, he didn't. They don't have the evidence at all anyway, and they don't have the witness. But let's turn to something else in this. And speaking of the Deming case and Deming factors, this has been going on for a long time. And I met with Counselor Mr. Twitty and Ms. Palmer a long time ago with the judge. And he wanted to resolve this.
Your Honor, we're getting into 408 territory and I object.
Sustained.
Part of the service and demeanor of the judge, and I think we just heard from counsel that he apologized or said that he regretted what had happened, and then counsel just argued that he didn't, based upon the way he acted back at the time. I submit to you the evidence in this case is going to show you that he always has shown regret. He's always shown remorse to this body and to the individuals I just talked about. In person, over time, in writing, wanting to take responsibility. Always. Reprimand, admonishment, those are the kinds of things we talked about. I just don't think it's not right. And again, from the sublime to the ridiculous, that he sits here today where he was told for the first time in a trial brief that the commission counsel wants him removed from the bench. That's not what this body's all about. And that's not what the history of your cases is all about. He made a simple mistake a long time ago. And he suffered greatly for it by virtue of the public defender's office, because they saw an article in the paper that mischaracterized the facts. The committee in King County acted against him. Why? Because they thought he wasn't entitled to benefit. Somebody reported him to the bar. He was cleared on that. And now he's before you here, and he's done everything he can do to resolve this. Everything and anything. At the end of this, we'll ask, after you listen to all the witnesses, including from our client himself, for him to be freed from this. This is his job. He's full-time pro tem. He's a judge. That's how he supports his family. That's what he loves to do, but it's also something, this has all interfered greatly in that. And we believe it should end. I mean, he's been punished enough for something that he really didn't do wrong. And he does acknowledge that he should have. If you go back in a million years, he'd never do that again. In a million years. And he will tell you that. But he should not be found to have violated the canons. And as we stated in our trial brief, he has no prior disciplinary actions. He's cooperated at length. He's complied with ethics advisory committee opinions, and he's evidenced an effort to change or modify conduct in any way that he can. He's done all of those things. He's an exemplary judge. He's done everything the commission could ask of him, and we'll ask you at the end of these proceedings to dismiss the case against him. Thank you so much for your kind attention.
Right. Thank you, Ms. Bremner. Mr. Taylor, would you like to call your first witness?
Yes. Ms. Molina will be handling it, Your Honor.
Ms. Molina, would you like to call your first witness?
We would like to call Regina de los Santos.
Do you want me to ask him?
Yeah, just honestly.
Your Honor, could we ask for a short comfort break for one of our individuals, just use the restroom?
Yeah, I'm fine with that. We can take our morning recess right now. So Ms. De Los Santos, you just came onto the Zoom call. We're just going to take our morning recess right now. I apologize for that. Got you all ready to go, but we're just going to take that. And by my clock, I have 10:08. So you add 15 to that. That puts us at 10:23. So back here at 10:23.
Thank you, Your Honor.
Thank you.
All right, we're close to the 15 minutes, so let's make sure all our panel members are present and everybody's back on the call with us. All right, looks like I think everybody's present. 1, 2, 3, 4. All right, by my count, looks like everybody's present. So we will go ahead and resume and turn the time to Ms. Molina.
Thank you, Your Honor.
I've just admitted the witness.
Great, thank you.
Yeah, we would like to call Ms. De Los Santos. Give me 1 second, sorry. Okay, and now. Sorry. There we go.
Okay, Ms. De Los Santos, there you are. Okay, great. Can you hear me okay? Ms. De Los Santos, can you hear me? Ms. De Los Santos, can you hear me? Can other people hear me?
Yes.
Okay. All right, good. All right. It looks like Ms. De Los Santos can't hear me. Ms. Molina, anything you can do to communicate with her to see if she's
Yeah.
adjustments? We'll just periodically check in with Ms. De Los Santos. Can you hear me?
I'm on the chat with her and she says that she can't hear anything.
Mr. Cooper, is it possible to suggest that she leave the meeting and rejoin?
That might work. It's worth a try.
I think if I may, she also just needs to join audio.
Okay, let me suggest that.
Oh. Okay.
All right, Ms. De Los Santos, can you hear me? All right, it looks like you're muted, so if you could take care of that, that would be helpful.
Okay, can you hear me now?
Yes, great.
can hear you.
Good morning to you. You've been called as a witness, Ms. De Los Santos. I'd like to offer the oath to you. So if you please raise your right hand.
Okay.
Do you solemnly swear or affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Will you please state your full name and spell your last name?
It's Regina De Los Santos. Last name is DE space LOS space SANTOS.
Thank you. Ms. Molina? All right, Ms. Molina, looks
I
like
can't hear you.
your audio is absent.
Can
Still no audio.
Can you hear me now?
Yes, I can hear you a little bit better.
Okay, great. Sorry about that. Ms. De Los Santos, can you please let us know what you do for a living?
So I'm a facility manager for SP Plus, a company of Metropolis, who's a contractor for King County. We manage their parking facility.
And how long have you been a manager?
So I've been a manager for 10 years.
At the same facility?
Yes.
And as a manager, do you know of any of their... 1 second, sorry.
Okay.
Okay,
Mhm.
we should be on now without echo. I apologize for that. Ms. De Los Santos, as the parking manager, do you know of any of their policies regarding parking discounts?
No, it's just straightforward. I mean, the
I'm sorry,
employee.
I'm sorry, I couldn't understand that question. Could it be repeated?
Sure.
Go ahead, please.
Do you know of the policies regarding parking discounts?
Yes, it's only King County employees with a King County ID, non-contractors that receive the King County employee rate.
And why is the ID necessary?
It's proof of employment. There's no way for us to verify if somebody's a county employee because we don't work for King County. We're just a contractor for them.
And how would the customers use that ID for the discount?
So there's two options. You can pay at the pay station where there's a reader, which is connected to the county system, which verifies that they are a county employee, and then it provides the discount at the pay by foot machine. The second way is to show the tenant their ID at the booth exit.
Okay. Is this information anywhere in the parking lot?
There's a sticker decal at the pay station. There's also one at the booth, no county discount without ID.
And what does the ID look like?
So it has the King County logo and then has their picture ID as well as their agency that they work for.
So is this a physical ID or
Yes,
can
it
you
is.
have it on the phone?
No, it has a physical ID. They have to have their ID to get into the buildings. So it's required to have your ID.
Okay. And are you in charge of checking the customers out when they want to pay as their cars are leaving, or someone else in charge of that?
So it's mainly a booth attendant. So we have AM and PM shift, and then I will cover if necessary.
Okay. And if any of the booth attendants have any questions regarding this discount, who can they ask?
It would be me.
And where's your office located?
It's on the same level as the booth attendant. So it's level P2 of the garage on the southeast corner.
Is that the only way that customers can get out of the parking lot?
They can also exit on level 6, but there's no discount provided because it's unattended and there's no way to verify their ID.
Okay. So now turning to February 16, 2023, were you working at Goat Hill Parking Garage?
Yes, I was.
And were you working the booth or were you working in your office?
In my office.
And not yet. And who was working the booth?
A former employee.
Did that former employee bring anything to you that day?
Yes, it was a piece of paper.
Did you look at it?
Yes, I did.
What was it?
It was just a piece of letter. It was a letter with no letterhead. It just said that the judge is employee of King County District Court, and it had the presiding judge's stamp and then the King County District Court stamp.
What did you do after looking at the letter?
Well, for one, I didn't accept it because of the fact that there was no letterhead. Normally, when they provide me some sort of proof of employment, usually it's from a division director or somebody higher up that proves that they're a county employee. But that didn't have anything. So I just took a picture of it as proof in case it was determined that he is a county employee and it was, an error on my part. So it's just more of proof.
Ms. De Los Santos, you have in front of you right now what has been previously marked as Exhibit 201. Is that the picture that you took of the letter?
Yes, that is the picture I took.
Okay. Did you leave any portion of the letter out when you took this picture?
No, whatever's in that picture is of what was on that letter.
Did you look at the letter front and back?
Yes, I did.
And how many stamps were on the letter?
It's just those two stamps, the seal and then the judge's stamp.
Okay. Why didn't you take a full, so, it's a kind of cropped up. Why didn't we see like the full picture of the page?
Well, it was blank the rest of the page. I mean, the bottom front portion was blank. The back side was blank, so I didn't feel like it was necessary. And also, too, it was just more for my backup. Because like I had stated, it's just in case it was determined that he was a county employee, I had proof, for myself that, hey, this is the reason why we didn't provide him the discount.
Okay. And the stamps that you mentioned, are those on the picture right now? Are those the ones that you see on the picture?
Yes, those were the only stamps that I saw.
Okay. And no other stamps in the back?
No, there was no other stamp.
Okay. Your Honor, we move to admit Exhibit 201.
Any objection?
Objection, authenticity.
Your Honor, may I be heard?
Objections overruled. 201 is admitted.
Okay, thank you. So you said that you took the picture to cover yourself because you didn't know if he was able to get the discount or not? What did you previously know about discounts before this letter was given to you?
So I had a prior email exchange with Heather Dean, who I have been in contact with the entire time that I've been working there. So she's been my contact for district court. So there was another situation where they had asked me about that. So then I knew from there that, pro tem judges do not receive a discount because, they don't have no ID. So that's why I reached out to her. So I sent that to her as just basically employment verification because, like I said, there's no way for me to verify whether or not they are a county employee because I don't know if he, might have forgotten ID or something. So that's why I took the picture and sent it to her for verification.
Okay. So you guys only give the discount if you have an ID?
If there's an ID and it doesn't say contractor on it, because there are IDs that say contractor. So as long as it says King County and there's, an agency listed, for example, like King County District Court, it will say that, then we'll accept it. There's a difference. It will tell you, it'll say contractor, temp, intern.
Is that information listed at the exit of the parking lot?
It just there's a sticker decal that does say, no discount provided without, valid King County ID.
Okay. And so you said you've contacted Miss Dean before. Who is she?
So she's the director of budget.
Okay. And after you took the picture, what did you do with that picture?
Well, first I tried to get a hold of her through phone, but I couldn't get a hold of her. So then I sent it to her and I just said, hey, just an FYI, another pro tem judge was inquiring about the discount.
Okay. And so you called her and did you ever send her a picture of the letter?
Yes, I did. I sent her a copy of the letter.
How did you send it to her?
Through email.
Okay. And what did you do with the physical letter after you took the picture?
As soon as I looked at it and told my attendant that I can accept that, I returned it back to the attendant.
In the ordinary course of business, what was the attendant supposed to do with the letter after you gave it to him?
He would have returned it to the customer who was the judge.
So
Objection, speculation, lack of personal knowledge.
Your Honor, may I be heard?
The objection is noted. The question was phrased in such a manner as what happens in the normal course of business. So based on that, I'll overrule the objection.
And you said what would your attendant would have done with the letter?
He would have returned it.
Objection, personal knowledge.
Could you repeat the question again, Ms. Molina?
In the ordinary course of business, what was the attendant supposed to do with it after you gave it back to him?
Return it to the customer.
Okay. And Ms. De Los Santos, Did you get any calls from Mr. Gross or anyone at his office regarding this matter?
Yes, recently, but not a year ago when this incident happened.
And do you know what the calls were about?
He wanted to interview me for this hearing today.
Did you interview with him?
No, I did not.
Why not?
I didn't feel like it was necessary.
No further questions.
Right, turn the time to Mr. Gross for cross-examination.
Thank you, Your Honor. Good morning, Ms. De Los Santos.
Good morning.
You didn't know Judge Razumna before this incident, correct?
No.
And you don't know Judge Razumna now, right?
No, I don't.
You never talked to or interacted with Judge Razumna for this incident, during this incident, or after this incident?
That is correct.
One of the parking attendants had told you that they had asked Judge Razumna to provide proof that he was a King County employee.
I'm sorry, can you repeat the question?
One of your parking attendants had told you that they had previously asked Judge Razumna to provide proof that he was a King County employee.
No, what had occurred was the judge was going there more frequently, and so he was, saying he was a King County employee. So then the employee had informed me that this judge is a county employee, and I was like, well, does he have an ID? And he said no. And I was like, well, then he needs to provide proof that he's a county employee for us to give him a county discount. That is what happened.
Okay, so you told your parking attendant if he didn't have an ID, he needed to provide some other type of proof that he was a county employee.
Yeah, and so that was, he didn't have an ID, so that's basically, he wasn't a county employee.
But did you just testify that you told your attendant if he didn't have an ID, he needed to provide some other kind of proof he was a county employee?
Yeah, so proof as in like it needed to come from the division director saying that this is a county employee. He doesn't currently have an ID because he's probably a temp or something, some sort of letter from a higher up that proves that he's a county employee.
You weren't present for any conversations between the parking attendant and Judge Razumna.
No, I was not.
And you don't know what the parking attendant told Judge Razumna about how he could prove he was a county employee.
No.
You've given 2 interviews regarding this incident. Is that right?
2 interviews? I've had one with Victoria. Who's the second interview?
Did you give an interview to the HR director of King County District Court, Kevin Whitley?
We had a email communication and he had asked for the letter.
Did you have a phone interview with Kevin Whitley before that email communication?
I'm trying to remember because that was like a year ago. I believe we did. I'm not 100% sure.
When you talked to Mr. Whitley and when you emailed with Mr. Whitley, was that on the same day?
I don't remember. That was a long time ago.
Was your conversation or email interaction with Kevin Whitley the first time that anyone had talked to you about this case after you finished emailing with Heather Dean?
Somebody else called me, but I don't remember if it was before or after Kevin.
Do you recall the date that you interviewed, that you talked to Kevin Whitley?
I don't recall. I'd have to go through my emails. I honestly don't recall. It's been like a while.
Recall emailing with Kevin Whitley on March 7th, 2023?
I know we emailed, but I don't know the exact date. I don't remember the exact date. I'd have to look through my emails.
Okay, Karina, can we have exhibit 204? Ms. De Los Santos, I'm showing you what's identified as Exhibit 204. Can you scroll down a little bit?
Mhm.
Okay. Do you see this email from Kevin Whitley?
Mhm.
And it says, I'm just going to read it out loud. It says, "Perfect. Thank you very much for your time. As far as you remember, there were no other stamps, signatures, etc. on the page than what you took a picture of. Is that accurate? Do you see that?
Yes, I do.
Do you remember getting that email from Kevin Whitley?
I mean, yeah, I do now. Now I remember, yes.
And the date here says March 7th, 2023. Do you have any reason to think that it's not the date that he sent this email?
No, it's clear. I mean, it's clear that it's March 7th, 2023.
Okay. Can you scroll up? And this is your response. And you forwarded this email to Victoria Molina with the disciplinary council, right?
Yes.
So you sent this email on March 7th, 2023 as well.
Mm-hmm.
Can you answer verbally?
Yes, I did send that email as it states March 7th, 2023 at 3:48 p.m.
And what you wrote was, I don't recall seeing any other stamp or signature that day. Correct?
Yes.
Okay, those are your words, right? You picked those words and typed them out.
Yes.
And what you wrote was that you don't recall seeing any other stamp or signature. Yes?
Yes.
Did anyone ask you before Mr. Whitley sent you this email, any questions about whether there were other stamps on that letter?
I think he was the only one, I believe. Like I said, I'm not 100% sure. I did speak to somebody else, but I don't remember if they asked me that.
Okay, so the first time that anyone asked you, as far as you remember, about whether there were other stamps was on March 7th, 2023.
Yes. I mean, as far as the email goes, yes, then he's probably the first one. But like I said, I did speak to somebody else over the phone, but I don't recall if he asked me about stamps.
You can take that down. And when Kevin Whitley wanted to talk to you and asked you some questions, did you do that voluntarily?
Yes.
And when he sent you the email, did you answer that email voluntarily?
Yes.
Why did you give Mr. Whitley a chance to ask you questions? Why did you voluntarily allow him to do that?
Because it was regarding a document that I had sent.
And the next time that anyone interviewed you about this incident was Victoria Molina, correct?
I believe, yeah. I mean, there was somebody else from Olympia, but I can't remember. I don't remember what the name, but he was with the judicial, I believe.
When Victoria Molina contacted you for an interview, did you agree to give her an interview voluntarily?
Eventually, yes.
Okay, why did you do that? Why did you voluntarily do that?
I mean, I just wanted to get the situation resolved because it had been an ongoing situation where I kept getting calls and I had been on leave. So I just wanted to make sure to get this resolved, or on my part at least.
Did the disciplinary council tell you that you didn't have to talk to us when we wanted to talk to you?
I'm sorry, repeat the question?
Did the disciplinary council's office tell you that you didn't have to talk to us if you didn't want to? Meaning me and Mr. Razumna's team?
She encouraged me to speak to you, but it was ultimately my choice. So I chose not to.
Why?
I just didn't feel like it was necessary. And also too, there was limited time, and I think you had called me Thursday or Friday, but I'm also going through a lot at work. I really didn't have time I've been busy nonstop.
So you said earlier that Judge Razumna was not the first.
I'm sorry,
You
what was
said
that?
earlier that Judge Rizomna was not the first pro tem to ask about the King County Goat Hill Garage discount. Is that true?
Yes, I mean, there's been another.
Was that Judge Heather Barker?
I'd have to go through my emails.
Yeah, so let's do that. Can we put up exhibit 322? Scroll all the way to the bottom. Ms. De Los Santos, I'm putting back up exhibit 322.
Mm-hmm.
This is an email exchange that you had with Heather Dean.
Yes, I do recall that.
Okay. Scroll up a little bit. This is an email that you sent to Heather Dean on January 19th, 2023. Is that right?
Yes,
And the subject is Judge Heather Barker,
yes.
right? You scroll down a little bit. And it says, hello, do pro tem judges get county IDs? I'm trying to find a solution for the judges that don't have an ID to show the cashier for a discount. Right?
Yes.
You wrote that? So on January 19th, 2023, you believe that pro tems at King County got the Goat Hill Garage discount.
I wasn't sure what a pro tem judge was, to be honest with you. And that's why I reached out to her, because like I said, the county ID, they don't have county IDs. So then that's why I reached out to Heather Dean.
But you had been with the manager of that garage for a decade, and you didn't know whether there was any policy about whether King County pro tems got the King County employee discount.
Well, so there's a difference. So this has been happening like most recently. We haven't had too many pro tem judges ask. They usually just pay the public rate because they know to pay the public rate. It's just these two incidents happen to occur within a couple of months of each other.
All right. So I'll just repeat my question. Even though you had been there, the manager, for more than a decade, on January 19th, 2023, you didn't know that of any policy that King County pro tems didn't get the King County employee parking discount.
No, there doesn't specify, because like I said, there's no way for us to find out that they're actually not county employees, even though if they were to provide a King County pay stub.
You've never seen any kind of written policy that says that pro tem judges at King County Court don't get the King County employee discount, right?
I personally have not seen.
The objection, Ms. Molina, was what?
Beyond the scope of what this witness has testified about and knows.
Objection noted, overruled. You can answer, Ms. De Los Santos.
I personally have not seen anything written about pro tem judges. That's why I reached out to Heather Dean.
You described the situation on February 16th where the parking attendant came to you with the letter that's at the center of this case, right?
Mm-hmm.
You didn't interact with or even see Judge Rizomna that day.
No, this is the first time I've seen him.
You were in your office, and from where you were in your office, you couldn't see even Judge Rizomna's car.
No.
You described that the parking attendant came into your office with the letter and showed it to you. What was the first thing you did?
I looked at the letter, and like I said earlier, there was no letterhead or anything. I just looked at the stamp, but it didn't prove anything. It just, like I said, it was just typed out that he was or whatever it said employee of district court.
So you knew it was not an official document.
I mean, I felt like it was not an official document.
And it was obvious from the way it looked that it was not an official document.
In my opinion, yes.
And once you assessed that it was not an official document, what's the next thing you did?
I gave it back to the attendant and said, no, you have to charge him the public rate. Then I believe I tried to call Heather and I couldn't get a hold of her. So then that's when I sent the email. I think I said, just a heads up, there's another pro tem judge trying to get the discount, something on the lines of that.
Okay, at what point in that did you take the picture?
So as soon as he gave it to me, I inspected it, I took the picture, and then I handed it back to the attendant, and then the attendant went out to the booth, and I don't know what was said between him and the judge.
Okay, so you had the letter in your hand for what, 10 seconds, less maybe?
I mean, I don't know, enough time to take a picture of it and to look at it and take a picture of it.
Okay, so potentially less than 10 seconds?
I mean, sure, potentially.
Miss Molina, did our office do anything to rub you the wrong way?
And you're posing the question to Ms. De Los Santos, correct?
I'm sorry, Miss De Los Santos.
Okay, I was confused. I'm sorry, repeat the question, please.
Miss De Los Santos, did our office do anything to rub you the wrong way?
No.
After you handed the letter back to the parking attendant, you don't know what happened to the letter, right?
That is correct.
You don't know if the parking attendant handed it to Judge Razumna?
That is correct, but I don't believe he would have kept it because he wouldn't have been able to do anything with it.
Did you ever ask the attendant what happened to the letter?
No, I did not.
Did you only take that one photo?
Yes.
If you know somebody to be a King County employee, but they don't have a badge, would they still get the discount?
No, they always have to show their ID.
Even if you personally know that person and you know they're a King County employee?
There's people that have been parking there as long as I've worked there and they still show me their ID when I'm in the booth. And that's part of the procedure for the employees as well. But I'm not always in the booth, but as far as when I'm in the booth covering, like I said, there's been employees there since I've been working at that location and they still show me their ID. There's over like 10,000 county employees. It's hard to remember everybody.
Understood. They do. Do they always have to swipe their card or can they show you their card at the booth?
So, okay, so they don't swipe are you talking about swiping their ID or swiping their credit card?
Their ID.
So they don't swipe their ID, they just show it. And then the employee is supposed to, actually look at it, not just, they can't just flash their ID. They have to actually look at it that it says King County, there has their ID, and it has an agency name on it.
Thank you very much, Ms. De Los Santos.
Ms. Molina, redirect.
Yes, Your Honor. Ms. De Los Santos, do you know what happened to the parking attendant that was working on February 16th, 2023?
What happened to him, like why he's not working?
Mm-hmm. Yes.
He resigned. He moved out of state.
Do you have a way of contacting him?
No, I don't.
And do you have any doubt that there was any other stamps on that letter besides the two we spoke about?
No, those were the only stamps that I saw.
Okay, thank you. Nothing further, Your Honor.
Recross, Mr. Gross.
We have Exhibit 222 again. Ms. De Los Santos, is this a true and accurate version of the email exchange that you had with Heather Dean? What's Exhibit 322?
With me contacting her and saying hello, or the entire email?
The entire email.
Yes.
We move to admit this Exhibit 322.
Oh, no objections, Your Honor.
Okay, without objection, 322 is admitted. Any additional questions, Mr. Gross?
Yes, can we also have Exhibit 204? Ms. De Los Santos, is this a true and accurate email version of the email exchange you had with Kevin Whitley that you provided to Ms. Molina?
Yes, that's correct.
We move to admit Exhibit 204.
No objections, Your Honor.
204 is admitted.
No further questions. Thank you.
All right, thank you. I'll turn to the panel members. Do panel members have any questions? If you do, just raise your hand. I'll call on you. All right, seeing none. Ms. De Los Santos, thank you for your time.
Thank you.
And any objections to excusing Ms. De Los Santos?
None, Your Honor.
Mr. Gross?
We would like to have her subject to recall, Your Honor.
Okay, so Ms. De Los Santos, what that means is that you could be recalled to testify. As a result, I'd ask that you not view any of the proceedings via YouTube or other means, and just keep yourself separate and apart from hearing anything about the case.
Okay.
Great. Thank you for your time this morning.
Thank you. All right. Bye.
All right, Ms. Molina, would you like to call your next witness?
Yes, we'd like to call Judge Rebecca Robertson.
Okay. All right, Ms. Robertson, can you hear me okay?
I can, thank you.
You've been called as a witness, so I'd ask to, if you'd please raise your right hand, I'll administer the oath. Do you solemnly swear or affirm under the penalty of perjury that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Will you please state your full name and spell your last name?
Rebecca Charlene Robertson, Robertson.
Thank you. Ms. Molina.
Thank you. Judge Robertson, how long have you served as a judge?
Almost 15 years. Actually, at 14 years, I'm going on my 15th year.
In all those 15 years, have you been a sitting elected judge, or have you ever served as a pro tem judge?
I served as a pro tem judge 2 years prior to my election in 2009 as a full-time sitting judge.
And do you know David Rusumna?
I do.
How do you know him?
He was a pro tem judge for King County District Court when I was a judge here.
Now, turning to the letter created by Judge Rusumna on February 16, 2023, when did you become aware of that letter?
Very close after the letter was sent to the presiding judge. I think maybe that day or the day after, I was having a conversation with then presiding Judge York over instant message about another subject. And he said, by the way, pro tems don't get discounted parking. And I replied, I know. And he sent me a screenshot of that letter.
Why did Judge York send you the screenshot of the letter?
Because the letter had my signature stamp on it, indicating that Pro Tem Razumna was an employee.
Did you write the letter?
I did not.
Did you give Judge Razumna permission to use your signature and stamp?
I did not.
What was your reaction when you first saw the letter? Or the
Objection,
picture of the letter?
relevance.
Oh.
Objection, relevance. Vague.
The objection is noted, overruled. You can answer.
I was confused and shocked and immediately said I did not sign that. I did not write that letter.
Why were you confused and shocked?
Because I hadn't written the letter and yet that was my signature stamp. And I recognized it as my a signature stamp I had made for me from Federal Way that had my signature and then a date that you could change the date so you could apply your signature and the date on an official document.
So you were shocked because your signature stamp was on there?
Correct.
And what was your reaction to knowing your signature stamp was used?
Shocked, incredulous. I didn't understand how or why that had happened. At that initial point, we didn't know who had done that. If we had thought it was either Pro Tem Razumna or my thought, is this a clerk who used my stamp? Because there was also the court seal stamp on there. So I was just confused and shocked.
Who is allowed to use your stamp?
Only I am allowed to use my stamp.
Do you know who is allowed to use the King County seal stamp?
From my understanding, only the clerks or administrative staff who are accepting documents use that seal stamp to indicate that it has been filed.
Have you ever used the King County seal stamp?
I have not.
So Judge York sent you the letter, or a picture of the letter. Do you know what happened afterwards?
He indicated he was, okay, I better look into this. I realized it was my signature stamp. I believe I looked at the signature stamp and made a stamp on a blank piece of paper and realized that it was in fact the signature stamp and the date, February 16th, 2023 was still on it. I think I may have then gone to look for the court seal stamp and it was in the court. And I stamped that on the piece of paper as well and sent it to Judge York and said, I think this is the same seal stamp.
What did Judge York do after?
I'm assuming he turned it over to HR to
Objection, personal knowledge.
Sustained.
Do you know if there was ever an investigation regarding the letter and the use of your stamp?
There was.
And who was the investigation by?
Kevin Whitley, our then HR director.
Do you know who directed Mr. Whitley to conduct the investigation?
Judge York did.
Objection, personal knowledge.
Overall, she can answer if she knows.
Judge York directed him to do that.
Did you have any contact with Judge Razumna while the investigation was being conducted?
He sent me an email, but I did not respond, and otherwise we did not have any contact.
So he sent you an email during the investigation that Mr. Whitley was conducting?
Objection, leading.
Sustained as to form.
When did Judge Razumna send you that email?
I'm not sure of the exact date. I believe in March. I'm not sure if the investigation was completed or not.
What was your reaction to receiving that email from him?
Objection, relevance. Relevance.
I'll allow a little leeway. Overruled.
I was sad because I really liked Pro Tem Razumna and we'd had a really good relationship and we're very friendly. And again, I was still shocked and incredulous that this had happened. I had understood that I should not be in contact with him during the investigation, so I did not respond. I forwarded it to Mr. Whitley.
During your time as a sitting judge, have you been part of any committees?
Yes.
What committees?
Well, in this court, I've been on the probation committee, on the executive committee as the West Division presiding judge. I'm currently the chief presiding judge of King County District Court. And then I've sat on various other committees as part of the District and Municipal Court Judges Association.
And during the time, so February 16, 2023, last year, what committees were you a part of?
At that time, I would have been on the executive committee and on the probation committee.
Do you know what happened, if anything, with the investigation regarding the use of your signature stamp?
Objection, relevance 403.
She can answer, she knows, overruled.
Because it dealt with personnel issues, it would have been sent to the personnel committee, who would have made a recommendation to the executive committee on what should happen.
Did that actually happen?
That did occur.
Were you, and at the time, were you sitting on the executive committee?
I was on the executive committee at the time.
Do you know what the decision by the executive committee was?
The
Objection,
decision,
relevance 403.
Objection noted, overruled.
the decision was to remove Pro Tem Razumna as a Pro Tem for King County District Court.
And how many judges were part of the committee?
5, actually, I'm trying to count, sorry. 5.
Do you know if all of them decided this, or were there any votes against that decision?
It was a unanimous vote, although the chief presiding judge does not vote unless it's to break a tie.
Do you know why it was a unanimous decision?
Objection, personal knowledge, hearsay.
Sustained.
Was there any conversations regarding the vote by the executive committee?
Yes,
Were you present for those conversations?
I was.
What were the conversations about regarding the
Objection,
use of the stamp?
objection, hearsay.
Ms. Molina?
Judge Robertson, did you have any input in the executive committee regarding the letter, the stamp that was used?
I did.
What was your input?
I explained to the committee how I felt about my signature stamp being used.
And what was that?
Objection, hearsay. Hearsay.
Well, objection is overruled. It's calling for her statement and thoughts. Overruled.
I explained that I was shocked and incredulous that it had happened, and sad again. And I felt I was concerned enough about the action that I'd taken my signature stamps and put them in another judge's chambers under lock and key, because I was so shocked that my signature stamp had been misused.
Why did it matter to you so much that your signature stamp was used?
Objection, relevance.
Ms. Molina, I'll allow little leeway on this, but probably this probably be the end of that inquiry. Go ahead.
My signature stamp is for me to use for official court documents, memorializing various orders of the court. It is only for me or for staff who I've, in each separate instance, given authorization to use a stamp, not this particular one. For an official court order, judges carry an exceeding amount of power and their court orders must be followed. So it was very concerning to me that someone could or did misuse that stamp, given the weight that it could carry.
And without telling us what was said in the committee, what was the general sentiment at the committee, the executive committee?
Objection, personal knowledge, hearsay.
I'll allow. Overruled.
Shock, anger, and people are just incredulous that it had happened.
Now turning to the actual parking discount. Do you know if pro tem judges are entitled to a discounted parking at the Goat Hill parking garage?
They are not.
How do you know this?
I know this because I've subsequent to this made very clear with the HR department what exactly the policies are. At the time, I didn't believe they were entitled to it, but I had exchanged messages with Pro Tem Razumna indicating I didn't think so, but I would ask. But now I'm very aware, especially since I'm chief presiding, that they are not allowed a discount.
But did you ever tell him point blank that he was entitled to the discount?
No.
Would you consider having Judge Razumna pro tem for you again?
We would not.
Why not?
Because of what we feel is a judgment lapse in misusing the stamp, both the court seal stamp and the signature stamp.
No further questions, Your Honor.
Cross-examination.
Thank you. Hello, Judge Robertson.
Hello.
You testified earlier that you and Judge Razumna had a really good relationship before this happened.
That's true.
I want to ask you about his sense of humor. Can you, I guess, describe a bit about his sense of humor as you knew him?
Sure. It was witty, dark, very funny. We got along, joked around a lot.
Did you reciprocate with a similar sense of humor with him?
I did.
And was your relationship, well, first of all, did you see Judge Razumna outside of work in like social settings?
No.
But would it be fair to describe you as work friends?
I would think so.
And you really liked him before this happened, obviously. And he was a reliable pro tem.
Yes.
You thought he was a good pro tem from what you knew.
Yes. From what I knew, yes.
There were pro tems that had covered for you that afterwards you'd have to clean up mistakes they made, and you didn't have to do that with him.
That's correct.
And Judge Razumna, did he have a dry sense of humor?
Yes, he did.
You didn't treat Judge Razumna as if he was your subordinate.
No.
You never acted towards him or tried to make it clear to him that he was on a different level than you because he was a pro tem and you were an elected judge.
No.
And you weren't present during any of Judge Razumna's interactions with the Goat Hill garage parking attendants.
No.
You don't know what the parking attendants told Judge Razumna about as far as him getting an employee discount.
I do not.
But pro tems are King County employees, correct?
They're employees in terms of payroll, but not for benefits.
If you're talking about healthcare, etc.
Correct. Healthcare, retirement benefits, parking, that sort of thing. They don't have they don't have an employee badge. They use a temporary badge.
You don't know what Judge Razumna had been told by anyone about whether or not he got a parking discount at Goat Hill Garage.
At the time, no.
Okay. You described, so before this incident, you had only had one conversation with Judge Razumna about parking, correct?
One that I recall.
And that was over text message?
Correct.
Okay, can we have exhibit 314? And can you go to Bates 44? Right. If you could take a look at this text message, does it look familiar to you?
It does.
And it's labeled January 10th, 2023 at 19:09. Is this a text message exchange that you had with Judge Rizumna?
Yes, it is.
Are your text messages appearing in gray and his in blue?
Yes.
All right, I'll just read from it. Hey, any chance you could pro tem for me all day in the jail tomorrow? That's what you said, right?
Correct.
He said yes. You said awesome sauce, thank you. And he said I got. Good so far?
Yep.
Okay, scroll down. And then you said yay. I've been called into DMCJA action. I really appreciate it.
Yep.
Keep scrolling. And then on January 10th at 20:55, Judge Rizumna asks you, where do you usually park? Just curious. And you said Goat Hill Garage, it's closest. And he gave it a thumbs up. That's all correct?
As far as I recall, yes.
Okay. Is there so far, do you see any text messages missing from this
Not
record?
that I'm aware of.
And then he texted, if there's any way you can get me validated for parking, that'd be awesome. I'll be there either way, but validated parking would be nice. $30 otherwise. You said that, right?
Correct.
You scroll down. Okay, and then this is you. You said, I'll ask, but I don't think so. We only get reduced parking. So we only get reduced parking, but I did hear that there are spots reserved for state patrol under the freeway in that park and ride that they never use and never check. Okay. My question to you is when you said we only get reduced parking, who is the we that you were referring to?
I was referring to the judges, the sitting elected judges.
Okay, but that's not made clear in this text exchange, correct?
Correct.
And did you ever make it clear outside of this text exchange to Judge Rizumna that when you said we only get discounted parking, you were referring to sitting judges?
No, I never realized there was any confusion about it.
Okay, but it would be reasonable if Judge Rizumna had interpreted we to include him. Do you agree with that?
That's possible.
Thank you. So that's the only conversation you had with Judge Rizumna about parking before this incident.
The only one I recall, correct.
You mentioned during your direct testimony that you had a text exchange with Judge Rizumna where you had said you didn't know whether pro tems got a discount, but you would ask. Did I
correct.
Did I mischaracterize that?
No, I was just going to say that's about the text exchange that we just discussed.
Somewhere in that text exchange that I didn't show, did you say that you would ask about that?
No, you did show that part. And I did say I would ask about it.
Oh, I'm sorry. Can you put it back up for a second? Okay. So when you're saying I'll ask, but I don't think so, you're talking about validated parking?
I took it to mean validated parking. I'm not quite sure what I was thinking at the time, if I thought discount or free parking, but I said I'll ask about the parking situation. I mean, that in my mind, that's what I was asking about.
Okay, thank you. You can take it down. On the date that Judge Rizumna created the letter, February 16th, 2023, he was covering for you as a pro tem, correct?
Correct.
The stamp that he used that had your signature on it, that stamp was in your office.
Correct.
And it was on your desk, right?
Correct.
And since Judge Rizumna was covering for you, he was allowed to be in your office and working at your desk.
Correct.
Judge Robertson, you never saw the actual letter that Judge Rizumna created. That's at the heart of this case.
The physical copy?
Correct.
No, I did not.
You don't know how many stamps were on that letter?
I've only seen the photos.
Okay. And you don't know Judge Rizomno's intent in creating the letter?
No.
1 second, Judge. That's all I have. Thank you, Judge.
Okay, redirect examination, Ms. Molina.
Nothing, Your Honor. Thank you.
Okay, Judge Robertson, thank you very much for your time. I appreciate that. I'll touch base with the attorneys. Any objection to excusing Judge Robertson?
It's me. I'm sorry, Your Honor. The panel has the opportunity to ask questions. I know it's not traditional.
Thank you. Panel members, pardon my oversight. Do any of you have any questions for Judge Robertson? Looks like Commissioner Smith Marshall does. Go ahead, Commissioner. And it looks like I can't hear you. Maybe others can, but I can't hear you. So I still can't hear you. I saw your mouth moving.
There was a problem with a witness earlier today. There is a little icon at the bottom of your screen that looks like a microphone. You have to be sure there's no red slash through it. If there is a red slash through it, check it so the red slash goes away.
Still not coming through. I guess one other option that we tried was having somebody had that problem earlier. One of the witnesses, I think, they just logged out and logged back in. Do you want to give that a try?
Next to the microphone audio too, there's a little caret on top. It looks like a little arrow. You can click on that arrow and that should give you some more audio settings to see if you've accepted the audio for the Zoom.
While Commissioner Smith Marshall's working on that, could we just pivot? We won't forget you. Pivot to Commissioner Stanton. Looks like Commissioner Stanton has a question.
Thank you. Judge Robertson, do you and the other full-time elected judges have King County ID issued to you?
We do.
Thank you.
Does that raise any issues for that you would like to explore, Ms. Molina?
None, Your Honor.
Mr. Gross or Ms. Bremner?
No, thank you. No, thank you, Your Honor.
Okay, all right, thank you. And it looks like, let's double circle back to Commissioner Smith Marshall. Okay, can't hear anything. And then it looks like just double checking with Commissioner Stanton, your hand is still raised. Do you have any additional questions? No? Okay, okay, great. And then Commissioner Smith Marshall, I want to, if you have a question, I want to make sure that you have that opportunity. So would you like to log out and log back in to see if that fixes the audio issue? Okay, so it looks like she's giving me a thumbs up, so she's going to be doing that. So let's just pause for a moment, and I appreciate everybody's patience.
Your Honor, I have Ms. Smith Marshall on my speakerphone, and she thought she'd try to ask her question through the speakerphone. Ms. Smith Marshall, could you speak so that we could see if the panel can hear you?
Yes, good morning.
Is that audible to everyone? Okay, go ahead.
Yes, my question is for Judge Robinson. Did you give permission to Judge, I'm sorry if I mispronounced your last name, Rizoma, to write the letter on February 16th?
No, I did not.
Okay. My second question is, how would someone gain access to your stamp?
At the time, just being in my office.
And then my third question was the judge in your office on February 16th with your permission?
Yes, he was there with my permission. He was sitting for me.
Okay, thank you.
All right, thank you. Ms. Molina, does that raise any issues for you? Any questions you'd like to pose?
None, Your Honor.
Okay, Mr. Gross?
Yeah, I guess I just want to make it perfectly clear that Judge Razumna didn't do anything wrong to be in the place where he could use your stamp. Just, I understand he used your stamp without your permission, but he was somewhere he was allowed to be when he did use your stamp.
He was allowed to be in my chambers. Yes.
Okay, thank you.
Okay, any additional questions from panel members? Okay, all right, seeing none. Any objection to excusing Judge Robertson, Ms. Molina?
None.
Mr. Gross? All right, Judge Robertson, thank you very much for your time this morning. You're free to exit. All right, Ms. Molina, would you like to call your next witness?
Your Honor.
Oh, go ahead.
You're muted, Mr. Taylor.
Your Honor, we call Judge Razumna.
Okay, all right. Mr. Razumna, if you'll go ahead and unmute and then raise your right hand,
May I have a comfort break very briefly? Here, I'll turn up the volume on mine.
Sure, let's take a 3-minute break. We'll be back at,
thank you.
At 11:31.
And there was reverberation when Mr. Razumna was speaking, so if that could please get addressed before he starts his testimony, that would be helpful. Thank you.
We'll take care of it, sorry.
Thanks. All right, 3 minutes. Let's go ahead and proceed. Okay, Ms. Bremner's here, Mr. Gross is here, Mr. Razumna's great. All right, Mr. Razumna, you've been called as a witness, so I'd like to administer the oath to you, please, if you raise your right hand. Do you solemnly swear or affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
You.
Thank you. Will you please state your full name and spell your last name?
David Razumna, last name R-U-Z like zebra, U, M as in Mary, N as in Nancy, A.
Thank you. Mr. Taylor.
Thank you, Your Honor. Good morning, Your Honor. You heard your counsel say in opening statement that pro-temming is how you make your livelihood,
Yes, I heard her say that.
and it's how you support your family.
I object to what my opening statement is not evidence. I got asked that just a proper question be asked. Objection.
Objections noted, overruled. He can answer.
It's how you support your family, Your Honor.
It's part of how I support them, yeah.
Isn't it true that you don't pro-tem for the money?
Yeah, that is true. I make a lot more money in doing private counsel stuff, but I do serve, I pro tem quite a bit, not for the money, because, yeah, that's true.
And in fact, pro-temming is a net loss monetarily for you, is it not?
That is true. If you're comparing that to what I could bill hourly in a private practice.
Okay, and you don't pro-tem for the money by any means, do you?
Objections asked and answered, argumentative, and also 403.
Sustained.
I want to talk to you about the letter. Can we have Exhibit 201 up, please? According to you, there were between 5 and 7 stamps on the letter.
Paul, how many stamps were on the letter?
Why don't we take a look at your deposition, page 21, lines 3 to 7.
Right, line 21, 3 to 7.
Oh, I'm sorry, page 21, lines 3 to 7.
Because 5 says I don't recall.
Can we have that blown up, please?
I don't recall, but I can tell you there were at least 3, maybe as many as 5, in addition to the 2 that you see there.
Okay, so there were between 5 and 7 stamps on the letter, true?
Objection. Asked and answered, mischaracterizes.
Objections overruled. He can answer.
To the best of my memory, yes, that's what I tried to explain in the deposition as well, that I didn't recall how many stamps, but drawing on my memory.
And in fact, according to you, the letter was covered with various random stamps, true?
Objection unless the document shown to him for impeachment, improper impeachment.
Objections noted, overruled.
And I'm sorry, what are you asking me?
According to you, the letter was covered with various random stamps, true?
I can see from the picture that it was not literally covered in random stamps.
Why don't we look at Exhibit 203, please? I'm sorry, that's the wrong exhibit. I'll give it to you correctly in just a minute. No, I'm sorry, it is Exhibit 203. We have the first page. This is an email that you wrote to Judge Robertson.
Be able to zoom in on the letter. I think I'm looking at the same document on paper form, but yeah, that was my email to Judge Rebecca Robertson.
About the Goat Hill Garage kerfuffle.
I'm sorry. I did have another objection, Your Honor, and that is this is a very lengthy email, and maybe if counsel could direct us to a paragraph, it might expedite things. And it's also hearsay.
Your Honor, I'm just trying to lay the foundation to get it admitted.
So if the objection was as to hearsay, the objection is noted, overruled.
And I also objected it should not be admitted if it's just used for impeachment. But I'll be quiet now and listen. Thank you, Your Honor.
Your Honor, I move the admission of 203.
I object. I don't know what's offered for impeachment. If it is, it shouldn't be offered as substantive evidence. And it hasn't been directed. There's no part of it directed to the witness that I've heard.
Okay, so I believe that Judge Razumna indicated that that was his email that he authored it to Judge Robertson. So the objection's noted, overruled. Go ahead. It's admitted. 203 is admitted.
We turn to the second page, please, of Exhibit 203. And can we go to the second full paragraph, 4 lines from the bottom? We have 4 lines from the bottom blown up, please. Include the immediate upper line too, please. What I created was a piece of paper covered in multiple random stamps. Do you see that?
I do.
The document was covered with multiple random stamps, according to you, true?
What I created was a piece of paper covered in multiple random stamps to create an absurd document that cannot reasonably have been mistaken for any kind of legitimate formal court document. And I did this as a joke, knowing that I'd be going through the same routine with the parking attendant when I left the garage after work that day.
Multiple random stamps, okay.
Objection, that's answered, argumentative.
So it was a stray comment, no question. So that stray comment is stricken.
Thank you, Your Honor.
And according to you, there wasn't much thought process in applying the stamps?
I think that's a fair statement. There was not a lot of thought process in applying the stamps. I think the whole exercise was not well thought out.
But there was enough of a thought process that you, when you picked up Judge Robertson's stamp, you had to change the date, right?
Correct.
And you had to change the month, right?
Yes.
And the year.
Yes, these are all elements of the date. Yes.
If the letter was a joke, a farce, why did you need to change the dates to match the letter you had written?
What I picked up was what I would regard that as more of a date/signature stamp. And it didn't make sense to have a date other than February 16th, 2023 on there.
Why don't we look at your deposition, page 14, lines 14 through 25.
I object unless it's shown in context.
I'm sorry, I couldn't understand counsel's
Oh,
objection.
I'm sorry. I'll repeat it. I object unless it's shown in context. If the question and answer answers are shown in context. Thank you.
So I'm not quite sure what the objection is, Ms. Bremner. You're objecting for him to review the deposition unless there's some context? I'm not quite
Yeah,
sure.
I'm objecting because last time that we dealt with the deposition, just showed it up there without going through the proper impeachment by deposition. And so I guess I'm a little premature, but I'm asking that it be read in context if it's going to be shown to the jury or read aloud to the jury.
Okay. Mr. Taylor, do you want to lay the foundation?
Your Honor, I'm trying to read the question and the answer if we can get to it.
Do we have a page in line again, please?
Again, page 14, lines 14 through 25. We have that up on the screen, please. Blow it up, please.
That's my objection. I mean, it needs to be read by the witness first, not shown to the commission.
So I believe Judge Razumna has a copy of the deposition in front of him. Is that accurate?
Yes, he does.
And then Mr. Taylor, maybe you could ask questions related to that and then see if he has a copy of it and proceed.
Yeah, you've got a copy of your deposition, don't you, Your
I'm
Honor?
looking at a paper copy of the deposition, yes.
Okay, and you can see page 14?
I can.
You can see lines 14 through 25.
I can see all the lines, yes.
Okay, and you were asked back then, if it was a joke, why did you need to have the two dates together? And you said, hypothetically, I'm making up this date, but if the stamp at the moment I picked it up said January 1st, 2022, it seemed like it wouldn't make, I don't know what to say.
I object unless the part question is read and shown to the commission as this is being shown out of context.
Objections overruled. He can answer.
I'm sorry. So can you repeat your question, Mr. Taylor? Were you just asking me to confirm that that was my testimony, that you read it accurately?
Yes.
Yes, you read it accurately.
And back when I asked you then, why did you need to have the two dates together? You said, I don't know.
Well, if you scroll up, if you can also just show the jury line 3 through 5, where you were asking me a different iteration of the same question.
Certainly.
If the letter was a joke, why did you need to adjust the month and date and the year? And then I said, Paul, it had a date on it, so it didn't make sense to have a stamp. That didn't make sense to have that stamp a date other than the actual date. And then later on down the page, you say again, well, if it was a joke, why did you need to have the two dates together? So I'm just trying to find more and more detailed ways to answer the same question that you're asking.
So as I understand it, then it was a joke, but you wanted to have the two dates the same?
Yes.
Okay.
It's not a joke like two men walk into a bar and one says, it's not that kind of joke. It was, what I meant by joke is like that it was lighthearted. It wasn't intended to be taken as a formal, court document. It was being irreverent.
Now we talked about the fact the letter was covered with various random stamps. In this random exercise then, was it just a coincidence that Judge Robertson's stamp appeared first?
No.
So you intentionally put her stamp first?
I put the date/signature stamp and the court seal stamp in a more prominent place near the text that I had written, because those were the stamps that demonstrated my ability to access things that only a pro tem judge or other King County employee could access. So the idea was to tell the parking attendant, like, look what I made. Like, how else am I going to have access to all these stamps if I don't work there?
Well, let's look at your deposition, page 12, lines 7 through 9. We were talking about Judge Robertson's stamps, and I asked you, but of the various stamps, why did you put that one most proximate to the text? Your answer then was, I don't know. Do you see that?
I do.
Okay, so did you do it on purpose? Putting Judge Robertson's stamp closest to the text?
I mean, I stand by, yes, there wasn't a thought process to it, but that, as between the court seal stamp and Rebecca's stamp, that was just a random determination. Those were the two more formalistic, stamps that would show my affiliation with the King County District Court. It's not something that a member of the public could just put in front of somebody.
So you chose to put those first, right?
Objection, that's asked and answered, argumentative 403.
I'll allow a little leeway, overruled.
Help me out. In your deposition, you said, I don't know. Now you're saying you did it on purpose. Which one?
Objection, characterization, proper, 403, argumentative. You can answer.
Overruled.
Which one, Your Honor?
I did. No, I'm not stalling. You don't have to keep badgering me like that. Yeah, the Rebecca Robertson and the court seal stamp were placed closest to the text. And I did that on purpose. When you asked me the question that culminated in I don't know, that was like, you would ask me several iterations of the same question, and I was just exasperated at that point.
So you put them first to add an additional layer of authenticity to the letter?
I wouldn't quite put it that way. Those were the two stamps that would accomplish my objective, which is I handed the document to the parking attendant, and I said, look what I made for you, or something like that. Words to that effect. How else would I have access to these stamps? So those were the stamps that I think would have tougher, members of the public would have a tougher time accessing. All I was trying to do was corroborate my truthful statement that I was working as a pro tem that day.
Didn't you tell us in your deposition that the stamps were, in your words, quote, randomly dispersed? Remember that testimony?
Oh, I'm sorry. Objection unless the deposition is shown to him, page and line.
Page 70, lines 12 through 14.
Sorry, 70, you said?
Yes, page 70, lines 12 through 14.
Yeah, I said my memory is that they would have been more randomly dispersed throughout the document and higher up.
Thank you.
That was in the context of a larger question that I was trying to elaborate on, and I know I was quite verbose during the deposition.
I want to change gears on you now. And I want to talk about, there was reference to you accepting responsibility in counsel's opening statement. Can we look at Exhibit 313, please? Page 2. In blue, that's a text that you sent.
Correct.
Your Honor, I'd move Exhibit 313, move its admission.
Any objection?
This was the one that's supposed to be redacted. I mean, I was trying to redact.
So I need to hear from counsel on that, not.
Oh,
Judge.
I'm sorry, Your Honor. I was conferring with my attorney.
Any objection?
This was to be redacted.
I think it's the ship has sailed. It's fine. They can.
I got it. And also it's a full exhibit starting with my mother passed 2 nights ago.
So, okay, so we're looking at exhibit 313, which is one, let's see, it starts at bait stamp 31 and goes to bait stamp 5. And then, Mr. Taylor, are you moving for the admission of the full exhibit or just that portion that was shown on the screen?
The full exhibit, Your Honor. I was just trying to lay a foundation by going to at the start.
Okay. I apologize. Let me just, I kind of lost track a little bit where we were at, if there was a motion for admission or if there was an objection to it being shown. So help me clarify that.
I have moved for its admission, Your Honor.
I'm sorry. I was starting to say, Your Honor, that what he tried to publish was just dealing with the second page of it, dealing with, do you know who's on the current executive committee, without, under the rule of completeness, at least having the first page of it talking about our clients. I think your mother passed.
Well, he was talking about his mother, but
Yeah.
yeah.
It starts with my mother passed.
Yeah, I mean, if the whole
All right,
exchange.
so I just need to hear from counsel on this. I apologize, Judge Resumda.
All right, I'm sorry.
So there's a motion for the admission of the full exhibit of 313. Ms. Colliner has a hand raised.
I'm just noting this may be an artifact of the fact that we're remote, but I want to advise respondent and counsel that we can hear them talking to each other, and presumably their conferences between them are privileged and confidential.
I appreciate it, but we understand that, but we had to confer a little bit. We understand that part was heard, but we're not waiving any privilege. I think I would stipulate that exhibit 313, the first 2 pages could be admitted. That's front and back. Doesn't it? Okay, actually, the whole exhibit. No objection. If it's the whole exhibit, no completeness.
Okay.
Your Honor, I'm having a hard time understanding respondents' counsel.
Yeah, I had to turn up my volume really loud to hear Ms. Bremner. I was at about 50%, and then just recently I had to move it up to 100% so I could hear her more clearly. It sounds a bit muffled and like you're far away from a microphone. So maybe, I don't know if it could be, there's an adjustment there, but that...
So you can unmute yourself.
Okay, so now it's muted.
I'm actually.
Go back to that.
Okay.
I'll try to speak more loudly. I'm not using my microphone. I'm using my client's microphone, so we're not this problem.
Yeah, that works better if you speak loudly. Yeah, when you speak loudly, that helps. Great. So there's been a motion to admit exhibit 313 in its entirety. 313 in its entirety is admitted.
Thank you, Your Honor.
Thank you, Your Honor.
Carry on.
Could we move to the next block? Okay. Upper block in blue. That's a text you sent?
Correct.
And you sent it to Judge Hirakawa?
Correct.
You friend of yours?
Work friend. I mean, we're not personal friends. He's somebody that I've judged with and for, and we've chatted here and there.
Okay. And you say, I got a nutty letter from the Weasel. The Weasel, is that the presiding judge, Judge York?
Yes, I was using the same terminology that Judge Hirakawa had used in the preceding text exchange.
So you both refer to Judge York as the Weasel?
I believe Judge Hirakawa referred to Judge York as a Dick Weasel, and I shortened it to Weasel.
Very well. I got a nutty letter from the Weasel misconstruing everything. Do you see that?
I do.
Okay, then let's take a look at the letter you got from Judge York. Go to exhibit 310, please.
There were,
This is the letter you were referring to?
can you tell me the date of the weasel text?
Yeah, the date of the weasel text was March 18th, 2023, the same as the received.
Yeah, then that would be this letter that I'm referring to. There were 2 iterations of this letter that were sent to me, but this is the one that I would have been aware of in March.
And this is the letter where you say he misconstrued everything?
Correct.
Okay, let's turn to the second page, please. Fifth paragraph down. Let's talk about what he misconstrued or did not misconstrue. This is the conclusion paragraph, right? In conclusion?
This wasn't all I was referring to, Paul or Mr. Taylor.
I understand. In conclusion, the findings were that you created the letter. That was true, right?
Objection, it's hearsay, not the document he was referring to in the weasel email, but it's all hearsay. And I believe it's offered for the truth. That's my objection.
So the objections noted related to possible misconstruction, and so I'll allow that overruled.
Okay, this is the letter where you say Judge York misconstrued everything. First of all, the finding was that you created the letter. That was true, was it not?
I'm sorry, you have highlighted a portion of the letter that I was referring to as the letter that he misconstrued everything in.
I'm sorry, Your Honor, if you could please focus on my question and answer it.
You said this is the letter, and I am focusing on your question. That is a portion of the letter that you have blown up there for me.
Was it true, as Judge York says, that you created the letter?
Objection, rule of completeness as well.
Oh, Ms. Bremer, again, the volume was low.
Okay, objection, rule. I'm going to scoot down a little bit.
You can sit right here.
Right here. Is this better, Your Honor?
Yeah, that is a
Okay.
slight improvement.
Objection, rule of completeness in addition to the hearsay objection.
Okay.
Thank you.
Objections noted, overruled.
Try it again, Your Honor. Is it true that as stated in the letter, as stated in Judge York's letter, that you created the letter?
If that's your question, yes, absolutely.
Thank you.
Maintain that.
Thank you. And is it true, as stated in Judge York's letter, that you used Judge Rebecca Robinson's signature stamp?
I've always been candid and forthright about that. Yes, that is accurate.
And you used the official seal without authorization?
Same answer. These are all from me, yes.
Okay. And you attempted to gain up to a $10 parking discount?
That is true. I don't know about the up to. I mean, it was either $20 or $30. So.
Well, which part of these events did he misconstrue, Your Honor?
Portion that you have blown up there is the part that I actually have underlined, which is to which you were not entitled. And there were other aspects of the. I mean, I can talk about what's in this letter and why I referred to it as misconstruing things that I had said.
No, Your Honor, if you could just point out which things in the letter he misconstrued.
Are you asking me the part that you have blown up or anywhere in this exhibit?
Your Honor, if you, I apologize, but if you could let me finish my questions, I think this will go smoother.
I'm sorry.
I got a nutty letter from the weasel misconstruing everything. My question is, what did he misconstrue?
And I do apologize for interrupting you earlier. This is only the second time in my life I've been under oath. What was misconstrued in the portion that you have blown up is the to which you were not entitled. There are other things in the letter that I was referring to also as having misconstrued.
And my question is a simple one. What else, if anything, is misconstrued?
Sure. There's let's see, the fourth paragraph down, he says, further, you stated this was a silly thing to prove I was a King County employee, end quote. You compared it to the use of the stamps as the same way as using someone's school identification card to get a student discount at the movie theater. That was exactly diametrically opposite of what I had told Mr. Whitley, who I think gave Matt York the information that formed the basis for this letter. I had said something quite different than that. And do you want me to, it'll take me just a second, but I can go through other parts of the letter as well.
Well, let's back up. You did talk with Mr. Whitley about the school ID issue, did you not?
What I said was that it would be my daughter, who is a student. I used as an example, I said this would be analogous to my daughter using somebody else's student ID to get a student discount at the theater. They flipped that on its head and said that would be the same as me using somebody's student ID to get a discount at a theater.
Okay.
Okay, so that is misconstruing what I said about student IDs.
Anything else that's misconstrued in this letter?
He mentioned several times about to which you're not entitled. He makes that statement several times. Second paragraph down on that same page, incidentally, he mentions Miss De Los Santos, who took the picture, stated she only recalls the 2 stamps. And bottom of the first page, again, Judge Pro Tems are not entitled to discounts for parking. So on this the letter March 15th, which I received on March 18th, that underlined portion, yeah, down there at the bottom, you can blow that up if you want. That was the first time anybody had ever told me that Judge Pro Tems are not entitled to discounts for parking. And I told Matt York that at the name clearing hearing. And apparently everybody knew that but me, based on some unwritten policy.
Let's go back to Exhibit 313.
Let me just interject here, Mr. Taylor. We're about the noon hour, and I want to stay fairly close to our time frames. And I wanted to allow that segment of the testimony to finish up. Is this a continuation of it, or is it delving into a new arena?
No, this is a good time to break, Your Honor.
Okay.
All right, Your Honor, we offered 310. It hasn't been offered.
Your Honor, I couldn't understand Respondent's counsel.
We need to offer 310.
You don't want it?
I mean, this is
all right.
York's
Nothing further.
Okay. All right. So we're going to keep ourselves on a tight timeline. It's 12:03. After I finish speaking, it'll probably be 12:04. So we'll go ahead and take our lunch break until 12:34. All right, we should be coming back into the hearing. All right, 30 minutes has elapsed. Thanks everybody for your punctuality. Appreciate that. Hopefully you had a good short lunch. Looking at panel members, making sure we have everybody here. Looks like we're missing, at least by virtue of cameras not being turned on, 3 panel members at this point. We have all counsel present. And Judge Razumna is here, so we're great there. Thank you.
Judge Evans, can you hear me?
Yes, I can.
When I try to remove the video, it says the host has asked you to start your video. So what does that mean?
Maybe press the video icon.
I did.
Okay, and you're still not, you're still
Correct.
coming through.
Correct.
Oh, there you go.
Wait a minute. Got it. Thank you. Thank
Great,
you.
thanks. Great. And then it looks like Commissioner Archer's present, and then we're just waiting, looks like just one commissioner at this point. All right, looks like I think everybody's here ready to go. I wanted just to circle back before we continue with the examination of Judge Razumna, related to exhibit number 313, 313. Just want to make sure that we're talking about the same thing. There was a bit of confusion whether it was the redacted version or the unredacted version. And this, we're talking about Bates stamps 31 through 35 of exhibit 13. I was under the impression that it was the unredacted version. Mr. Taylor, is that your understanding?
Yes, Your Honor.
Okay, and Ms. Bremner?
Say it again.
Let's see. I saw you speak.
Say it again, yeah.
That's fine, Your Honor. Can you hear me now, Your Honor?
Yeah, that's perfect. Thank you.
Thank you.
Thanks for the extra effort getting up.
Thanks.
All right, so hopefully that's clear for the clerk that the exhibit 313, Bates 31 through 35, unredacted, is the one that was admitted by the presiding officer. Okay.
Yes, thank you very much for clearing that up.
Perfect. Thank you. All right, we were left off for lunch with Judge Razumna under direct, and we'll continue on.
Your Honor, there is one preliminary matter.
Okay.
We received a call from Ms. De Los Santos wanting to know if she needs to schedule a vacation day for tomorrow, given that she's technically not being released, and perhaps we could get some indication as to whether she might really be called tomorrow.
Okay. Let's see. Mr. Gross, do you have any input?
I have no current intent to call her back, but I can't say for sure. I think maybe if we needed her tomorrow, we could try to work around her schedule, maybe one of her breaks or her lunchtime.
I guess we got to tell her she needs to schedule a vacation day then.
Yeah, I think that's probably the safer course.
Okay.
All right. Thanks. Any other preliminary issues before the continuation of the direct exam?
No, Your Honor.
Yes, Your Honor. So one of our concerns has been realized in the live chat, and it seems like there's potentially several disruptive individuals, and I know that Mr. Cooper had indicated that if that were to happen, he had some ability to remove individuals. So I wonder if that exercise could be taken now.
Are there specific names associated with those that are deemed disruptive?
I just have a screenshot. Dale M, NJ, and Pierce County Probate.
Okay. Mr. Taylor, have you looked at any of those items?
No, we don't have the that feed going, Your Honor.
Okay, so Mr. Gross, your request then would be those individuals that you mentioned, those three names or titles, would be excluded from the live chat?
Correct.
Okay. Mr. Taylor, any objection or concerns related to that?
No, Your Honor.
Mr. Gross, could you repeat those names? I'm not sure we heard them properly. N as in Nancy, J as in Jane, Daniel, M as in Mary, and Pierce County Probate. Are those the correct names?
Gale M, GALE,
Okay.
NJ, and Pierce County Probate.
Okay, I'm making the assumption that Mr. Cooper will assist with that and take action to that end.
I'll do that right now.
Great, thank you. All right, any additional items related to that? Okay.
No.
All right, if not, then we'll continue with the direct examination of Judge Razumna. All right, go ahead.
Thank you, Your Honor. While you were a pro tem judge in the district court and Superior Court in King County, I want to talk about benefits you did or didn't receive, okay?
I was not a pro tem judge for Superior Court.
Very well. Pro tem commissioner. Okay. During those 10 years, correct that you did not receive, for example, paid time off?
Correct.
No vacation pay?
Correct.
No vacation at all?
Not paid. I mean,
Okay. No sick leave?
No.
No health benefits?
Nope.
No dental?
Nope.
I don't have any other questions. Thank you for your time.
Okay, cross-examination.
You get up one more time, Your Honor. Nothing at this time, and we reserve the right to call our client and our case in chief. Thank you.
So noted. Thank you. All right. Thank you, Judge Rizuma. All right.
I'm sorry again, Your Honor. The panel does have the option of asking questions at this point.
So grateful for that reminder. Thank you. Panel members, if you have questions for Judge Rizuma at this time, please raise your hand and make that known. Okay, seeing no hands or no movement, we'll make that assumption that there's no questions from the panel members. We'll now turn time to disciplinary counsel for your next witness.
How to make yourself.
Yeah.
At this time, we'd like to call Kevin Whitley.
Okay.
Kevin Whitley is not in the waiting room at this time. Will he be calling in? That I see.
Let's see, Ms. Molina, any updates? See, Ms. Molina, do you have any updates as to the whereabouts of Mr. Whitley? And maybe Ms. Molina can't hear me. I think that's a pretty fair assumption at this point. She's not responding.
Sorry, Your Honor, I can't. hear you.
Oh, Ms.
One
Molina,
second.
can you hear me okay? Let's see, Mr. Taylor, can you hear me? Okay.
Okay.
Not sure how to do hand
He-
signals at this point.
He just, Mr. Whitley was in the waiting room for just a moment, but now okay, it looks like he's been admitted.
Okay, great.
The additional issue is that Mr. Taylor and Ms. Molina don't seem to be able to hear the presiding officer.
I can now, I'm sorry.
Okay, and Mr. Taylor, can you hear me okay?
Loud and clear, Your Honor.
Perfect. All right, Kevin Whitley, are you on the line?
Yes, sir.
All right. Right now, I don't see your image. So could you
Working
turn
on
your
that here.
video?
How's that?
That's great. We can see you now. You've been called as a witness, so I'd like to administer the oath to you. So if you please raise your right hand. Do you solemnly swear or affirm under the penalty of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. All right, if you'll please state your full name and spell your last name.
Sure. Kevin Whitley, W-H-I-T-L-E-Y.
Great, thank you. Ms. Molina.
Thank you. Good afternoon, Mr. Whitley. What do you do for a living?
Good afternoon. I am the Central Services Director for King County District Court.
How long have you been in that role?
So I have been with District Court for 12 years, and I've been in this specific role since about August of 19.
What was the previous role that you were in?
So I've been with District Court since February of 13. I've been with the county since June of 2006. So about 18 years. And I started with District Court back in 2013 and started as an HR manager. I was promoted as the District Court Director sometime in August of 2019. And here we are.
Mr. Whitley, I'm going to encourage you to get closer to the microphone. How's
that?
Oh, so much better.
Okay, perfect. Sorry, my mic was up.
Thanks.
Between February and March of 2023, what was your role at King County?
I was the let's see. I was the HR director at that time.
And in your role as HR director, did you know if pro tem judges are King County employees?
To my knowledge, no, they were not county employees.
How do they get paid?
So they are paid through payroll.
Does that make them King County employees?
So there are many different kinds of, or I'm sorry, there are a few types of employees within King County. There are regular employees, there are term limited temporaries. Both of those are fully benefited employees. Then there are short-term temporary employees. Those are non-benefited employees. So pro tem temporaries are non-temporary, or I'm sorry, are short-term temp employees who are non-benefited employees. So they are not employees so much as they're not benefited employees.
And when you say benefited, what sort of benefits are you referring to?
Sure. So they don't get medical, dental, vision, life, all of those sorts of things. They don't get the Orca Pass, which is included in an ID badge, etc.
Do they receive ID cards?
So no, the pro tems do not get an ID badge, and the reason for that is because of security. So
Objection, personal knowledge.
Why don't you go ahead and rephrase the question, Ms. Molina?
As an HR director, do you know if pro tem judges are issued King County employee cards?
They are not.
So, and then going back to the benefits, is a parking discount considered a benefit?
I would say yes.
Personal knowledge.
Sustained, you can lay a foundation.
Do you know of the benefits that King County employees received?
Yes, I do.
How do you know about those benefits?
So I've been an employee for 18 years. When I started with the county, I was hired with King County benefits. I helped employees get signed up for their benefits as part of my role. And I went through open enrollment with employees, so I have a pretty good knowledge of King County benefits.
Are you a King County employee?
Yes.
Do you receive benefits?
Yes.
Have you ever parked at the Goat Hill Garage parking
Many
lot?
times.
Do you receive a parking discount when you park there?
Yes.
Okay. Do you consider that parking discount a benefit?
Yes.
Okay.
Objection, relevance.
Objections noted, overruled.
So as part of the benefits, the parking discount at the Goat Hill Garage would be considered a benefit.
Objection, personal knowledge. Valid.
Objections noted, overruled. You can answer.
Could you say it one more time, Ms. Molina?
Yes. Is the parking discount considered an employee benefit?
Yes.
And pro tem judges did not receive employee benefits.
Correct.
Now, regarding the letter that Judge Rusumna wrote on February 16, 2023, were you asked to conduct an HR investigation?
Yes.
By who?
So the Personnel Committee and the Executive Committee asked me to do an investigation with because of this letter to figure out if Mr. Razumna created the letter. Did he present the letter to the attendant to get a discount? And if yes, then
Non-responsive.
So the question, I'll allow a follow-up question. So it was a bit of a narrative.
Why were you asked to conduct the interview?
Objection, personal knowledge. Hearsay.
Sustained.
So, Mr. Whitley, you testified that the personnel committee asked you to conduct this interview, correct? Or conduct this investigation?
That's correct.
Do you know why what was the directive you received for conducting the HR investigation?
The directive was to figure out how the letter was created. Was the letter presented to the attendant? If yes, who created the letter? How was the stamp accessed? And did the person have authorization to utilize the stamps?
And as part of this HR investigation, did you interview Judge Rasumna?
I did.
And what happened during that interview?
Objection.
What was the objection?
Vague.
Overruled. Go ahead.
Could you repeat the question, Ms. Molina?
Sure. What happened during this interview with Judge Rasumna?
So I provided Mr. Razumna the garrity rights, which protects public employees from being compelled to incriminate themselves during an investigative interview, which is conducted by an employer. And so I provided that garrity right. I then interviewed Mr. Razumna regarding the letter, regarding he admitted that he wrote the letter, and I'm not sure if that's what you're looking for, if you're looking for more.
Did Judge Rasumna tell you why he wrote the letter? What was the purpose of the letter?
He did. He said there were a couple of
non-responsive.
Overruled. You can answer.
So he said that the letter first was a joke. Second, the letter was due to trying to get a discount on the parking because it was, quote, killing him to pay $30 for parking.
How was the letter a joke? How did you understand for the letter to be a joke?
So his
Objection. I'm sorry. Can you repeat the question? I just didn't understand it.
So as part of the interview with Judge Rasumna, he said that the letter was a joke. Correct?
Yes.
How did he say that? Why was the letter a joke?
He said that he had a
Objection, personal knowledge.
Overruled.
He said that he had a rapport going with the parking attendant where he was trying to get a discount by showing the parking attendant that he was an employee, by showing his robe, by showing his name placard, his pro tem name placard. And he still wasn't able to get the discount. He then created this letter as a joke. That's a quote. And he says that there were multiple stamps on this page.
Did he say if there's any other purpose for the letter besides being a joke?
To get a discount on parking.
And were you able to verify that there were only 2 stamps on the document?
There were 2 stamps visible. The parking attendant indicated that she only saw 2 stamps. And then in my analysis, there was about 7.5 inches of the picture.
Objection. And permission for a speaking objection.
Well, at this point, I'll sustain the objection, and there can be follow-up question and any follow-up objection.
As part of your investigation, did you try to determine whether there were more than 2 stamps on the letter?
I did.
How?
I asked Ms. De Los Santos if she had seen any additional stamps on the page. She indicated she did not.
Did you do anything else to try to determine whether there were more than 2 stamps on the letter?
I did.
What did you do?
So I measured.
objection. Permission for a speaking objection, Your Honor.
Go ahead.
Mr. Whitley is about to explain some mathematical calculations he did using the photograph of the letter to try to determine how much of the letter is not shown in the photograph, and he lacks the expertise, at least foundationally, to, I guess, discuss those calculations in this hearing.
Your Honor, may I be heard?
Please.
Mr. Willie had access to the paper. He had access to the King County stamp, the seal stamp, and he had access to Judge Robertson's stamp. From those tools that he had access to, he tried to figure out how much of the paper was left over that the other random stamps could have been placed on. So he doesn't need to be an expert when he had the tools, and this was something that he was trying to figure out as part of his investigation to know whether what Judge Rasumna was telling to him was credible or not.
Okay. So I guess I got a little preview of what the potential answer would be regarding a measurement, and it sounded like it was a measurement of paper. I think that's well within the ken of an average person and doesn't require any expertise nor mathematical acumen to determine. Everybody's pretty well aware of 8.5 by 11. I guess it could be a 9 by 14 or something like that, but 11 by 12, what have you. But so the objection is noted, it's overruled. He can address it. If there's any continuing concerns, objections can be noted.
Go ahead, Mr. Whitley. Or do you need me to repeat the question?
So there were 7.5 inches. And I can go into how I measured it if that's important.
Please do. Tell us
Okay.
what tools you had at your disposal and what you used.
Okay, so I had Judge Robertson's stamp. I measured the stamp. It was 2 inches wide and 1 1/16 inch high. And then on the actual picture, it was 5/8 inch high. And so for every 5/8 inch, I made it 1 1/16 inch high. And so that comes out to 7.56-ish inches high. And so that leaves about 3.43 inches remaining on the page for all of the other alleged stamps to be placed.
And
At this point, I'm going to renew my objection and move to strike that testimony.
Overruled.
And as someone that really doesn't understand measurements and math, can you give me an idea of how much is the 3.5 inches or that you're telling that was left on the page? Can you give me a description?
Yes.
Or a hand gesture just to tell me?
Yeah, I mean, it's about that much.
Okay. And is this from the bottom of the page or from the top of the letter?
So I measured from the top down.
Okay. So that's how much is left
3.5 or 3.43.
From the bottom of the page.
Correct.
Okay.
That is
Why was
not
it-
shown.
Right. And why was it important, as part of the investigation, why did you feel like this was important to do, to know if there was this much space left?
Because a lot of Mr. Razumna's information was that there were multiple stamps included on this letter, and that we were only seeing a very small portion of what this picture was.
Thank you. Nothing else from me.
Okay, cross-examination.
Thank you. Good afternoon, Mr. Whitley.
Good afternoon.
You testified earlier that pro tems are not King County employees. Is that correct?
That is correct.
Did you tell me during my interview of you that pro tems are King County employees?
Yeah, and I actually thought about that, and it's for the purposes of payroll, they are employees. For the purposes, I mean, we can argue that they're employees or not employees, but like I said, there are a few types of employees. There are regular employees, there are term limited employees, there are short-term temporary employees. some of which are benefited, some of which are not benefited. And short-term temporary employees are not benefited, and that falls into the category of Mr. Rizumna.
Short-term temporary employees are not benefited, but they are employees, correct?
Sure.
Okay. You also testified that Judge Rizumna was read as Garrity rights, right?
Correct.
And that those rights are read to employees in situations like this?
Correct.
Can we have Exhibit 201? Mr. Whitley, I'm going to show you what's been previously admitted as Exhibit 201. Do you recognize this?
Sure do.
What is that?
That is the picture of the letter that was submitted by Mr. Rizumna.
Can you increase the size a little bit? That's good. Mr. Whitley, I'm going to read the letter out loud. 2/16/23. David Rizumna is employed with the King County District Court as a judge pro tem. Is that statement true on the date that it was written, February 16th, 2023?
That statement is true, yes.
Okay, thank you. You're not aware of any written policy that King County District Court has that would indicate that pro tem judges don't get the employee discount at Goat Hill Garage, correct?
I'm sorry, could you repeat that?
You're not aware of any written policy of the King County District Court indicating pro tem judges are not entitled to the parking discount at Goat Hill Garage?
Not to my knowledge, no.
As part of your investigation, you tried to find whether there was a written policy that said that.
Is that a question?
It is.
We did look for if there was a policy related to it, but what we looked at was the King County Code 3.12, and in that it talks about benefits, and so that is related to a benefit, and so that's where it's related to not getting that benefit.
I'm not sure I follow that, but what you were not able to find any policy of the King County District Court indicating pro tem judges weren't entitled to that discount.
So in the King County Code under 3.12 talks about benefits. And in those benefits, that is a King County benefit. And so short-term temporaries are not eligible for benefits. And so parking is a benefit. Parking discount is a benefit.
You are not aware of any evidence that Judge Rizumna was put on notice that he was not entitled to the parking discount at the Goat Hill Garage, correct?
I can't speak to that.
My question is, you're not aware of any evidence
No.
that would indicate, I'll just make sure that this is completely clear. You're not aware of any evidence that would indicate that Judge Rizumna was on any notice that he was not entitled to the Goat Hill Garage discount on February 16th, 2023.
I can speak to in our new employee orientation, as far as our paperwork that we do.
Objection, non-responsive.
Sustained.
You want me to ask again?
Sure.
You're not aware of any evidence that Judge Rizumna was put on notice that he was not eligible for the parking discount at Goat Hill Garage on February 16th, 2023.
So that's not a yes or no question. So would you like me to give you the answer, or would you like me to How would you like me to do that?
Okay, so it sounds like you're saying you are aware of evidence that he was put on notice?
I'm saying that I do not know if he was.
You don't know that you're not aware of any evidence that he was.
Again, I'm not saying that I'm not aware of any evidence. I just don't know if it was given to Mr. Razumna.
Okay, why don't you go ahead. What are you gonna say?
So the pro tems go through training, and in that training, there may be information provided during that pro tem training. But as far as the human resources area, we do not provide information about specifically parking. We provide that they're non-benefited, but we do not provide anything about specifically parking discounts.
You're not saying that there is training that pro temps get that tells them they're not eligible for that discount. You're saying you don't know if the training exists.
No, I'm not saying that training doesn't exist. I'm saying that there is pro tem training, and it is possible that the pro tem trainers, the judicial trainers, provide that information.
Okay, but you don't know that they do.
That's exactly right. I'm just saying I do not know what is provided at that training.
You never saw the actual letter that was created by Judge Razumna, correct?
No, I did not, because the parking attendant said that they gave it back to him specifically.
You talked to the parking attendant?
I talked to the manager who was right there with the parking attendant. Yes.
Okay, and are you saying that the manager said that she gave the letter back to Judge Razumna?
That the parking attendant gave it back to Mr. Razumna.
And are you saying that the parking manager witnessed the parking attendant give the letter back to Judge Razumna?
That is what I understand.
You interviewed the parking manager, Regina de los Santos, on March 7th, 2023.
Sounds right.
That was 3 weeks after the letter was created.
Sure.
And after the interview, you emailed Ms. de los Santos asking her whether she had seen any other stamps.
Correct.
And her answer was, I don't recall seeing any other stamps or signatures that day.
I believe that's correct.
Did you have any other conversation with Ms. de los Santos about whether she had seen stamps other than what's in that email?
I do not believe so. I believe I got it through email, and I think you pointed out the email that I received that information.
As far as you know, that email to Ms. de los Santos on March 7th, 2023 was the first time anyone had asked Ms. de los Santos whether there were other stamps on that letter.
I'm sorry, my connection broke up. Could you repeat that?
As far as you know, that email where you asked Ms. de los Santos whether she had seen any other stamps, as far as you know, that was the first time anyone had asked Ms. de los Santos whether there were other stamps on that paper.
I don't have any idea if anyone had asked. So yes.
Do you know the length and width of Judge Razumna's stamps that he said he used on the letter?
He said that he used a signature stamp, a notary stamp, his own signature stamp, his own notary stamp, and there were a bunch of other, quote, there were a bunch of other stamps to make it look, I would have to look at the specific descriptor word, ridiculous, but I think it was another specific word.
How big were those stamps?
Well, I do not know, but I can, if it's a normal signature stamp, I would say it's in the area of 1x2.
Did you ask to see his stamps?
Did not.
You asked him to do an in-person interview, correct?
I did.
And he cooperated with that request, correct?
I did.
He promptly responded to you and then actually came to you to do the interview, correct?
I asked him to come in person, yes.
When you talked to him in person, did you ask him if you could see the stamps that he was referring to?
No.
Why not?
Because the space was too small.
The space was too small. What space?
The 3.4 inches. I
The
mean,
space was
we're
too small to
seeing
fit.
over 3/4 of the page. The alignment of the signature plus the seal, the changing the date to the exact date of the letter. It wasn't meant to be a joke. It wasn't meant to be a goof, as Mr. Razumna says. It was intended to get the discount that he was not eligible to receive.
I'll move to strike that as non-responsive, Your Honor.
The question I think was related to the space for the other stamps, and he was giving an explanation of why he felt that he differed with that. So overall,
My question to you is, why didn't you ask him to see the stamps he was referring to?
I didn't at that time. I
But
don't
you
recall.
you don't know the size of those stamps.
No.
Do you know the size of the paper that was used?
Based on what I see, I would say it's a standard piece of paper.
Why do you say that?
Because if he was printing something out at the courthouse, he would need to change the settings in order to get the 9x14 or whatever that is. And it's not easy, and it would have to be the settings would have to be changed.
How do you know he would have to change the settings?
Well, the normal everyday printer prints on 8.5 by 11. And if you want to make change to 9.5 by 11 or 14, whatever, sorry, I don't remember what it is right offhand, then you have to make a change to this printer settings in order to go to that specific paper size.
How do you know that was the case with the printer in question?
So again, I'm saying that is what you would have to do.
What size font was the letter written in?
Don't know. I can do some measurements.
Did you look into that question?
No, because I am able to do the measurements based on the stamp. So I didn't think it was needed.
We have exhibit 201 again. So it's not the whole. Sorry, Mr. Whitley, bear with me. We're trying to get a bigger view on this photograph. Sorry, my question depends on seeing this whole letter, so if you just give me a second. So, Mr. Whitley, do you see that horizontal fold near the bottom of that photograph of the partial letter?
It's even smaller than it was before, so no.
Underneath the district court seal, do you see the horizontal fold underneath that?
Sure.
Is that the approximate halfway point of the paper?
If we're seeing, let's see, I would say it's probably the last third of the page. Or, yeah, the last third of the page.
Okay, you don't know, but you don't know, right?
I'm pretty confident, yeah.
You can take it down. In your investigation, you found no evidence that would contradict what Judge Razumna told you about his conversation with the parking attendants over time, did you?
I'm not sure I understand what you're asking.
Well, you didn't talk to the parking attendant, did you?
No.
So, and Judge Razumna told you about his conversations with the parking attendants, you know, over time, multiple conversations.
That wasn't part of my investigation.
Okay. My question is, you're not aware of any evidence that would contradict anything Judge Razumna told you about the tone and nature of his conversations with that parking attendant?
Again, that wasn't part of my investigation, no.
You didn't audio record your interview with Judge Razumna, did you?
We don't record interviews for investigations.
You didn't audio record your interview with Judge Razumna, though?
No.
Right? And you didn't write down everything that was said between you verbatim either?
I would say I came pretty close.
Did you tell me during my interview of you that you wrote down a summary of what you understood to have happened in that interview?
I'm not sure as far as what?
That these notes, your notes of the interview, are not verbatim.
Sure. I would say they're not verbatim, but I would say they're probably 85 to 95%.
And you were the first person to question, as far as you know, you were the first person to question Judge Razumna about that letter.
I wouldn't be able to say, but I would assume so.
And when you showed him the photograph of the letter, he immediately told you that it was only a partial photograph of the letter, right?
I don't believe so. I think you said this was all just a joke.
No, my question is, when you showed him the letter and asked him if this was the letter, he said that's only part of it, right?
During the interview, yes, he did say that.
And he said at that time there are a bunch of other stamps on there.
Correct.
He said that as soon as you showed it to him.
I don't know if it was as soon as he showed it to me.
And he also told you that you could get the letter from the parking attendants, the actual letter.
Correct. And that's when I followed up with the parking manager, who said they provided
Objection,
it to him.
non-responsive.
They were a little bit late overruled.
Are there any witnesses present for your interview with any of the witnesses in this case? Any third
No,
parties?
I don't typically need a third party for interviews.
No further questions. Thank you.
Right. Redirect examination, Ms. Molina.
No, thank you, Your Honor.
Okay, I'll ask the panel members if you have any questions of Mr. Whitley. All right, I see no hands raised, and so any objection to excusing Mr. Whitley?
None, Your Honor.
No, Your Honor.
All right, Mr. Whitley, you're free to go. Thank you for your time.
Thank you so much.
All right, we'll turn to disciplinary counsel for the calling of your next witness.
Yes, Your Honor, would like to call Heather Dean.
Okay. Okay, Ms. Dean, can you hear me?
I can.
All right, you've been called as a witness. I'd like to administer the oath of a witness to you. If you'll please raise your right hand. Do you solemnly swear or affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Will you please state your full name and spell your last name?
My full name is Heather Dean, last name Dean.
Thank you. We'll turn the time to Ms. Molina.
Good afternoon, Ms. Dean. What do you do for a living?
I am the King County District Court Budget Director.
How long have you been in that role?
I've been with the court district court since 2007. I've been in the role probably over 10 years.
And just a little short summary of what budget director entails.
So I oversee the accounts payable, accounts receivable, interfund or intergovernmental costs, and procurement and payroll.
And as part of account payable, do you deal with paying any sort of bills that come in from the Goat Hill parking garage, for example?
We interact with the Goat Hill garage. We purchase parking tickets for our employees, and then we work with them on weekend parking for our judges.
Do you know who Gina de los Santos is?
Yes, Regina is the facilities director or manager of the parking garage. So I've interacted with her via email quite a few times.
Why have you interacted with her?
She'll get a hold of me if there's something going on in the parking garage that she has a question for, or if my staff is buying parking stickers for our employees, she'll get a hold of us. So she creates an invoice and tells us when the stickers are available to pick up.
Okay. And does the budget director, are you in charge of issuing signature stamps?
I'm sorry to interrupt, but we have an emergency on our side. Can we have a couple minutes?
What's the emergency?
A minute.
What's the emergency?
There's the person in the live chat is now manipulating my pro tem calendar online. This was one of the reasons I was concerned. So
nobody
is digitally altering my pro tem calendar while we speak. So I was going to maybe take a break so I could password protect it. This is, I believe, one of the individuals in the comment section.
Meaning that your calendar is being displayed on the live chat function?
No. I have, here, I'll turn my volume on. I'm sorry, Your Honor, I have an online calendar where court managers can schedule my pro tem assignments. There's somebody who is in the live chat who I believe is now manipulating the online calendar because I just got a notification that there was a change made and the change is referring to this hearing. And that's consistent with what the same individual had previously done. So if I can have a moment just to password protect my online calendar so that this person can stop maliciously.
Do you think that'll take 30 seconds, a minute?
It might take more than 30 seconds. That might have been ambitious. It'll take we're talking about a 2-minute process and I can start it now.
Is that something that you can work on that while the questioning continues?
I suppose so. It just caught me off guard. So I'm sorry to interrupt. We can, I suppose, continue.
Okay, we'll continue. Thank you. Go ahead, Ms. Molina.
Ms. Dean, the question was, how do you know Ms. de los Santos?
So I know her from interacting with her when she has questions regarding anything related to district court at the Goat Hill Garage. She will get a hold of me as the budget director for district court.
Okay. And as the budget director for district court, are you in charge of issuing any signature stamp to judges?
I wouldn't say issue. My team oversees the purchasing of signature stamps for the judges.
Is this just for sitting judges, or are pro tem judges also included?
No, we just purchase judicial stamps for our sitting judges, and the sitting judge has to sign on a piece of paper. They send it to my team. My team then works with the court manager to get the stamp for that sitting judge.
And as a budget director, do you issue the employee badges?
I do not.
Who is in charge of that?
I believe the HR department issues them.
Got it. Okay. But your department doesn't have to pay to create them or any sort of that stuff.
Well, if you lose your ID badge, we are charged depending on the situation. The employee can be charged. Sometimes we have been charged, but I don't deal with that often because it doesn't happen that often.
So now turning to the letter at issue in this case, on February 16, 2023, when did you first learn about it?
I got an email from Regina, but it was on a trail of emails that had been going, that she had started back in January 19th of 2023.
Why did she email you?
So on January 29th of 2023, she emailed me asking, do pro tems get county ID? That she was trying to find a solution for judges who don't have a county, who don't get county discounts. I responded to her the next day and let her know that pro tems are not employees, that they don't get a badge. She then asked me a clarifying question. This is still in January 20th of 2023. She asked me a clarifying question of, well, do they get a discount for parking? And my response was no. Then from that trail of emails, she sent me an email on February 16th saying that David Razumna was a pro tem and that he was asking for a discount, that they charged him the public rate.
So this was the purpose of her email to ask you if he was entitled to the discount?
It was at that point she was telling me she didn't give him the discount, and she was sending me a letter showing me that he had presented a letter saying he was an employee.
What was your response to her?
Well, first I clarified with her when she asked me if about the David Razumna, and I clarified, was he a district court pro tem or was she asking me about somebody related to Superior Court? She clarified through the letter that she sent me a photo of, that the letter said, it was saying David Razumna, something along the lines, is an employee of King County District Court. It had our judge's stamp, Judge Robertson, who's a judge at our Seattle location. And then next to that stamp, it had the seal, the court seal. So my response to Gina was, I would have to get back to her. I was going to need to talk to our presiding judge.
Why was that?
Because we have a letter that was written by a presiding, well, at that time, I thought it was a letter that was written by Judge Robertson, allowing or telling a pro tem that they could get discounted parking by writing a letter. And so I was extremely concerned because that's not a practice we've done since I've been with the court since 2005. So I was contacting our presiding judge to say, I think we've got a problem. We have a judge in Seattle writing letters for a pro tem saying they're an employee. So that's why I contacted our presiding judge.
Did you show him the letter?
I did. I sent him the letter. It was in an email, so I just forwarded him the email trail.
And who was the presiding judge at the time?
At that time, it was Matthew York, Judge Matthew York.
Do you know what happened after you forwarded the picture of the letter to Judge York?
Yeah, I got a call from Judge Robertson. I don't know how far after that, indicating that she wanted to see a copy of the letter, that she was on vacation and she hadn't written the letter. I also got an email from Judge O'Toole. Judge O'Toole at the time was our judge who taught the pro tem course, and she was also in charge of our personnel committee. She asked me for the emails so that she could look at them also.
So from the first time that you saw the picture of the letter, you thought it was Judge Robertson who had written the letter?
And stamped it, correct. Well, typed it and stamped it, correct.
Okay. Did you believe it was a legitimate letter?
Yes, that's why I got a hold of our presiding judge and sent him a copy.
Okay. Nothing further, Your Honor.
Cross-examination.
Thank you, Your Honor. Good afternoon, Ms. Dean.
Good afternoon.
Pro tem judges are in-county employees, correct?
Not to my knowledge, pro tem judges do not get the same benefits that we do as King County employees. We get a badge. We get discount access to Metro. We get benefits. We get vacation leave. We have access to certain websites. So pro tem judges are not employees.
What are they then?
I can't answer that. I'm the budget director, and as the budget director, we don't see them as employees, so they don't get any of the benefits. So we don't buy them the same things we pay for and buy for our judges.
Do you know whether they're considered by the federal government to be employees?
That's not my role. My role is to just be concerned about district court's budget and how we spend our public funds. And since 2005, we have not paid for pro tem parking for our pro tems.
Are you aware of any communications that would have gone to Judge Rizomna to let him know that he would not be allowed the parking discount at Goat Hill Garage?
You'd have to ask others, and then you'd have to check with Regina because her email alluded to the fact that she had spoken to him before. So you'll have to check with her.
The rule or idea that pro tems don't get that parking discount, that's not a written policy, correct?
I can't answer that. I can tell you it's been past practice since 2005 that pro tem judges have not been given discounts for employee parking and or stickers to park and Goat Hill garages if they're an employee. So since 2005, I would say past practice. I can't tell you if it's written down.
As far as you know, that past practice is essentially a word of mouth policy, right?
I'm not sure what you mean by word of mouth. It's well known. The parking garage knows, all the staff know. So I'm not sure what you mean by word of mouth.
Meaning the policy is known because people verbally tell each other that it's the policy, as far as you know.
I can't speculate to that. I can only tell you that since 2005, my team and I are very aware we don't pay for pro tem parking and or they don't get employee discounts.
You never saw the actual letter, correct?
I saw a photo of it that was, I think, taken probably with an iPhone or something and emailed to me.
You've never met Judge Rizomna?
Not to my knowledge. The name rings a bell, but I have not. To my knowledge, I've not met him.
One moment. What was the policy regarding pro tems getting parking prior to 2005?
I don't know. I can't answer that.
Why did you identify 2005 as the time that policy started?
Because that's when I started with the court.
Okay. So you don't know why that policy was put in place?
Because they're not employees. So we don't spend public funds on employees. So these are public funds. So we do not spend public funds on non-employees. And we're very careful about what we can purchase with public funds for employees. So employees, when they go to Goat Hill Garage, they're showing their ID to get a discount. We're not spending public funds on it. So I'm just telling you past practice.
Who issues paychecks to pro tems?
I can't answer that. I'm not involved. I have a payroll manager, but I don't know how that process works. I'm assuming King County does it, but I don't really know the full process of payroll.
Does King County own the Goat Hill Garage?
I don't know for sure. I can't, I can speculate, but I don't know for sure.
No further questions. Thank you.
Redirect, Ms. Molina.
Just two quick questions, Ms. Dean. Do you park at the Goat Hill parking garage?
I have once in a great while during COVID when I'd come into the building when the buses weren't running.
Did you have to pay full parking or did you get the discount?
When you leave, there's a sign when you leave the parking garage that says employees must show their badge. So we would show our badge and then we'd hand them our parking ticket. And sometimes during COVID, the county was paying for employees to park because it was COVID and a pandemic. So they had federal dollars. So we would get a sticker on a parking badge or parking card, and we'd leave the garage and show our badge and then give them the parking sticker.
No further questions. Thank you.
Recross, Mr. Gross.
Were pro tems given those COVID era validation stickers?
No, not from district court.
No further questions. Thank you.
All right, I'll turn to the hearing panel. Do any of you have any questions for Ms. Dean? All right, I'm not seeing any hands raised. So let me double check with the parties regarding releasing Ms. Dean as a witness. Ms. Molina, any objection?
No objection, Your Honor.
Okay, Mr. Gross?
No objection.
Okay, Ms. Dean, thank you very much for your participation this afternoon. You're free to go.
Thank you.
Okay, I'll turn to disciplinary counsel if you'd like to call your next witness.
Yes, Your Honor. We would like to call Judge Lisa O'Toole.
All right, very good.
Your Honor, can we get a 2-minute bathroom break?
Can hear you.
Yeah, I think that's okay. Judge O'Toole, can you hear me?
Yes, I sure can. Thank you.
You've been called as a witness, and just as we called you as a witness, there is a request for just a brief restroom break. So I'm fine to accommodate that. So if you wouldn't mind just pausing, let's do it. We're kind of pushing things along, so let's say a 2-minute restroom break, and we'll adjourn until that time. And just if Ms. Judge O'Toole, if you don't mind just staying on the line, 2 minutes, I think we'll be back pretty quick. Great, thank you.
Thank you.
Thank you.
Present and accounted for. Screens are coming on. All right, we've got both disciplinary counsel, we've both respondent counsel. Still waiting for a couple panel members. Judge Resume this here, great. Commissioner Briggs just came in. And then just waiting on one more panel member. Great, looks like everybody's present. All right, so Judge O'Toole, you've been called as a witness. I'd like to administer the oath to you. If you'd please raise your right hand. Do you solemnly swear or affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Will you please state your full name and spell your last name?
Sure. Lisa Napoli O'Toole. Last name is O''T OOLE.
Thank you. Ms. Molina?
Yeah. Good afternoon, Judge O'Toole.
Good afternoon.
How long have you been a judge?
I was elected in 2014, so coming up on 10 years.
And as part of your judgeship, are you involved with any committees?
Yes.
Which committees?
Gosh, over the years, the Rules Committee, the Probation Committee, both at King County District Court, the Personnel Committee, I'm presently the Chair of Personnel Committee, all at King County District Court. And then I've been involved in a number of DMCJA, so District and Municipal Court Judges Association committees as well, the Diversity Committee and the Education Committee. I've been on the Education Committee for about 10 years.
How long have you been the chair for the Personnel Committee?
You know, I can't remember exactly when I took it over, but it was when Judge K2 Shaw left King County District Court and was elevated to King County Superior Court. I took his spot as East Division presiding judge at that time. And then each presiding judge of our divisions chairs a committee, and I was assigned to Personnel Committee because I was the judge for more than 8 years total, who ran our pro tem training program. So I don't remember the year, but it was whenever Judge Shaw left our court.
Okay. And are you also part of the executive committee?
Yes, each of our division presiding judges is a member of the executive committee.
Okay. And how long have you been a part of that committee?
The same time frame. When Judge Shaw left, I replaced him. So whatever year that was.
And you mentioned that as part of the Personnel Committee, you oversee the pro tem training?
I did for 8 years.
Okay.
I was the person who facilitated our training class about 2 years ago, I think 2023, maybe a year and a half ago. I transitioned that to Judge Kling, who now runs the class, but I'm still the head of the personnel committee. So issues related to pro tem judges come to our committee.
Got it. Okay. And do you know Judge David Rosuna?
I do, as a pro tem judge here in King County District Court.
Did you know him the entire time that he was a pro tem at King County District Court?
Did I know him prior to that time?
During the entire time that he was a pro tem? Or how long have you known him as a pro tem judge?
Well, I was a pro tem judge myself before I was elected. I trained myself. I had training in 2008. I sat regularly beginning in 2011. I think he and I may have overlapped and been at the same court at some point when we were both pro tem judges. I'm not certain of that, but that would have been after he became a pro tem judge, and I think he became a pro tem judge with our court in 2013. So I may have known him before I became a judge, having just been fellow pro tems, because some of our courtrooms or courthouses are large and have multiple pro tems at the same time. So I may have met him then, or I may have met him once I was elected. I'm unsure.
Okay. And now turning to the letter in question from February 16, 2023, did you know if there was an HR investigation into that letter?
I'm aware there was, yes.
Do you know who, how the HR investigation came about?
As I understand it, the
Objection, personal knowledge.
Sustained, why don't you rephrase the question?
As part of the personnel committee, did the committee ask HR to conduct an investigation into the letter?
Executive committee did.
Oh, executive committee, so not personnel committee.
Correct.
And were you part of the executive committee at the time?
I was.
Okay. So do you know why the executive committee asked for the HR investigation into the letter?
Yes.
And why was that?
The folks who run the Goat Hill Garage, as it's called, which is a King County parking facility, have received a letter from Pro Tem Razumna indicating that he was an employee of King County District Court. It bore the purported signature of Judge Rebecca Robertson and an official court seal stamp. The parking garage forwarded that to our budget director, who then in turn forwarded it to our presiding judge, who at the time was Judge Matt York, who alerted executive committee and of course Kevin Whitley, who at the time was the director running HR, and an investigation ensued.
And do you know, did Mr. Whitley write a report for the executive committee regarding his investigation?
Yes.
Did you see the report?
I did.
And did anybody else, do you know if anyone else at the executive committee saw the report?
I'm assuming everyone on the executive committee saw the report.
And did the executive committee make a decision based on that report?
Yes, based on that report and the information from Heather Dean, information from Judge Robertson, in the letter itself that was forwarded to us, not the actual letter, but a photograph or facsimile of it that came via email. So based on all those things.
Sorry. What was the committee's decision?
Objection, objection, relevance.
Objections noted, overruled.
That he should be removed from our pro tem roles and not serve anymore as a King County District Court pro tem judge.
I will ask about the reason. Did you vote for that decision?
I did.
Why did you vote for that decision?
Objection, relevance.
Overruled, you can answer.
So the letter that we were provided purported to have Judge Robertson's signature on it by way of her signature stamp and an official court seal, which was also a stamp. And whether Mr. Razumna was entitled to an employee discount or not was not the concern. The concern was the incredible lack of judgment in preparing this letter and affixing a judge's signature to it and then passing it off as true to the parking officials was shocking, to say the least. And having spent decades in the prosecutor's office and having one
Objection,
be
non-responsive, narrative answer, improper opinion, relevance.
So the objection is noted, overruled. She's answering the question.
And as someone who spent decades in the King County Prosecutor's Office, one of my rotations was in the felony filing unit. In addition to doing felony trials and felony appeals, it meets the textbook definition of forgery. Taking a document.
Objection. Well, first of all, 403, relevance, legal conclusion, non-responsive.
Sustained as to forgery.
So you voted.
Can we move to, I asked that be stricken and the panel be instructed to disregard that.
That's accurate. With the sustaining of objection, the jury or the panel is instructed to disregard the conclusion as to forgery.
So you voted. So as part of the executive committee, you were one of the members that voted to remove Judge Razumna.
I'm one of the members who voted
to remove Judge Razumna.
Yes, based on the unauthorized use of the judge's signature and the unauthorized use of the court seal.
Are you aware of any other times that Judge Razumna has been removed as a pro tem judge?
Yes.
Do you know why he was removed?
Yes.
Objection. Sorry, Your Honor, I think I missed the introductory question. Are we asking about other courts?
Ms. Molina, I think the question was that, are you aware of any prior removal as a pro tem judge?
Correct.
Objection, relevance, 403.
What's the time frame, Ms. Molina?
2015.
2015. What's the relevance?
Deming factors.
In particular, the Deming factor you're pointing to?
If this is the first time that Judge Razumna has been removed as a pro tem judge, or if there's been other disciplinary actions taken.
So the disciplinary action under Deming, does that refer to disciplinary action by the Commission on Judicial Conduct?
Give me 1 second, Your Honor.
Okay.
So under C, under mitigation, capital D says whether there has been prior disciplinary action concerning the judge. It does not have any specifics as to the commission.
So this is under section Rule 6 under discipline, under section, I'm looking at the webpage. So you're looking at 6C. So first off, under 6A, it's talking about any conduct that violates the Code of Judicial Conduct as grounds for discipline. And then it talks about discipline. It talks about different authorities, admonish, reprimand, and censure, and beyond.
Right. And I'm looking at 6C.
Right. Right. You're looking at 6C to
1D.
Right.
Right. And I'm looking at 6C, mitigating aggravating factors. Under 1, characteristics of misconduct, capital D, whether there has been prior disciplinary actions concerning the judge.
So then that takes me to Rule 6A at the top where it says any conduct that violates the code is grounds for discipline that shall be issued or admonished in open session, which is talking about the commission. And so then when it talks about under C, under 6C, whenever the commission finds grounds for discipline, it shall consider the following non-exclusive factors in determining appropriate discipline to be ordered. Characteristics of misconduct is section 1, section 2 is service and demeanor of judge. And then it's talking about whether there's a recognition or acknowledgement of the acts occurring, whether the judge's evidence effort to change or modify the judge's length of service in a judicial capacity, whether there's been prior disciplinary action concerning the judge, whether the judge cooperated, whether the judge compliance with an ethics advisory opinion. It goes on to talk about under D as in David, under Rule 6, the sanction imposed shall be of the appropriate level of culpability. Sanction should be sufficient to restore and maintain dignity, and it goes on. So your reading of that, Ms. Molina, is that discipline is any discipline concerning the judge, whether it's through any body other than the Commission on Judicial Conduct?
Yes, Your Honor.
Okay, Mr. Gross.
Your Honor, Rule 1 of the Commission of Judicial Conduct Rules of Procedure is entitled Disciplinary Authority. It says the disciplinary authority of the Commission extends to every judge subject to the Washington State Constitution and the CJC. Ms. Molina and Mr. Taylor are disciplinary counsel. Disciplinary action is a term of art, meaning action by the CJC. And I think to allow this type of conduct would be a serious appellate issue in this case, and I'd ask the court to exclude it, especially from 2015.
Additional comments, Ms. Molina?
Only that the authority deals, Rule 1 specifically says who is under the authority of the commission. And this goes to talk about, and the question is specific to if Judge O'Toole is aware of any other times Judge Resumna was removed as a pro tem judge. It goes to if I could go into the detail of why he was removed, but it actually goes to the larger question of if the reason why he was removed is why Judge O'Toole did not use him as a pro tem.
Okay, all right, thank you. Ms. Collner has her hand raised.
Thank you. I was just going to note to remind the presiding officer that you do have the ability, if you believe it is a I want to say something other than gnarling. If it's a challenging question, you do have the right to confer with your panel members if you wish.
I think since it's an interpretation of the rules of procedure for the CJC, I do want to take a moment to consult with the panel members. So everybody could just hang tight. We'll invite the panel to be placed into a breakout room with the assistance of, I guess, Mr. Cooper or Ms. Perry. Don't anticipate will be longer than, well, I hate to guess, but I'm saying probably 5 to 10 minutes. So don't go away too far, and then we'll reconvene in just a bit. So I appreciate everybody's patience.
I just want to make sure that Ms. Perry understands that the request is to put the panel and commission counsel into a breakout room.
Yes, I am assigning everyone to a room at this moment.
Thank you so much.
Okay, I'm back. Famous last words, 5 to 10 minutes. So I appreciate your patience. Let's make sure everybody's here. Got both disciplinary counsel, both respondent counsel, and Judge Resumna. Wonderful. Okay, I just had a relatively brief discussion with the panel. What I wanted to do is ask Ms. Molina as to an offer of proof regarding the 2015 issue.
For the record, I just want to note that the rest of the panel remains in the breakout room and is not exposed to the offer of proof.
Thank you.
The offer of proof from Judge O'Toole's testimony, Your Honor?
Yes, that which you were seeking to admit through her testimony, that something that occurred in 2015, the removal issue.
So the removal happened in 2015 while Judge Rasumna was a pro tem judge, and it was he was removed. I believe it was for half a year or a year because he had ex parte communications with that witness before the hearing, in which the witness was in which the person was going to be a witness for the hearing.
Okay, so the offer of proof that when Judge Razumno back in 2015 was Judge Pro Tem, there was some ex parte contact with the witness, either prior to or during some type of evidentiary proceeding.
Yes, prior to, and then the witness came on the hearing.
Okay, and then shared information, and then that was that. And then was there an investigation, and was there any follow-up? Was there, I guess what I want to know.
He was removed by the presiding judge at the time.
Mhm.
It is our understanding that he was removed at the time, and that he was not a pro tem judge. I believe it was either 6 months or a year, and that he later came back, and it wasn't a unanimous decision by the executive committee for him to come back as a pro tem judge or to be back on the list as a pro tem judge, but rather the presiding judge at that time decided to bring him back based on another judge vouching for him.
So I guess in this particular hearing, one of the issues is veracity, truthfulness, related to the use of stamps and the like. Does the issue that you've pinpointed regarding the ex parte contact, does that touch upon veracity, honesty?
Yes, Your Honor. What it touches on, so the question before the panel today is whether Judge Rasumna should be removed as a judge. And evidence of prior removal of him as a judge or a suspension by anybody goes towards any the aggravating factors.
Okay, so there's no representation or offer of proof that Judge Razumna in 2015 was dishonest or tried to cover up any ex parte contact, anything of that nature?
As to covering up the ex parte contact, no, but he had the ex parte contact with the witness before a hearing in which the witness was set to testify.
And then when it was brought to light, was it brought to light during the evidentiary proceeding or afterwards?
Afterwards.
Okay, and then an investigation occurred, and was Judge Razumna presented with that information, and did he indicate that did occur?
I believe there wasn't a full investigation that occurred. I believe he was presented with the information and he was removed from the pro tem list.
So in other words, didn't really ask for his input, just made a decision and then removed from the list.
Correct.
And so it came to light of the ex parte contact through the witness that was contacted, and then that was reported to somebody. Kind of give me a little more detail on that.
I believe it was reported. I'm not completely sure, so I would have to check in with Judge O'Toole, but I believe it was reported by the other party that was of the hearing.
The other party meaning opposing.
Yeah. So this was for a bail hearing. So whether the defendant should have received bail or not, and the ex parte contact was with a police officer, which the police officer was going to testify as part of this hearing. And it was brought to light, I believe, by the defense counsel's attorney or the defendant's attorney.
Okay. All right, thank you. Let me just ask some questions of counsel, both sides. When you look at the Deming factors, we're looking at a non-exclusive list. Then there's some specified things that we're to look at in case there is a violation, and then Deming comes into play as far as a potential sanction. So one of the factors is to look at whether it's an isolated incident, and you look at kind of the service as a judge as a whole. So it tends to be a little more inclusive, but yet then we weigh that against maybe kind of 404B type of evidence, whether the probative value overcomes the prejudicial impact. So I guess what I want to know from you all is if it were to come in, I think it would potentially come in for only a limited purpose, for purposes of sanction, as opposed, if there were to be a violation, as opposed to going to whether there's a violation. So I just want to get your thoughts regarding that. So we'll hear from Ms. Molina and then either Mr. Gross or Ms. Bremner.
No, that is correct, Your Honor. It would go towards if it's decided whether there will be a sanction, what sort of sanction should be imposed.
Okay. All right. Mr. Gross or Ms. Bremner?
Your Honor, first of all, I don't know that Judge O'Toole should be here for this discussion as she's the witness. So I'll leave that to you. But I think Ms. Molina is.
I mean, maybe just as a safeguard, maybe we could invite Ms. Perry and Judge O'Toole. Thanks for your patience. We could just place you in an isolated meeting breakout room. Okay, looks like Mr. Cooper's going to help with that. And then once we're finished, we'll bring you right back. Okay, thank you.
I think Ms. Molina's recitation of what happens illustrates one of the problems here, is that Judge O'Toole has no knowledge of what happened. She wasn't at the court at the time. Ms. Molina suggested, and I don't know where she got this information, that the defense counsel in the case reported the situation. That is not at all what happened. Judge Razumna basically it's a very long story, and it's essentially like a bit of a trial within a trial here about what happened, but he was sort of whistleblowing on what happened with this officer being let into his chambers to talk to him, saying, hey, telling other judges, hey, this shouldn't happen. This is improper ex parte contact. And eventually, one of the judges told the presiding judge, there's no investigation. He was never dishonest. I think at some point he self-reported to the CJC. Right. So I don't know where Ms. Molina got information that this was started by defense counsel. It was not. He was essentially attempting to whistleblow on something that was happening in the court. It is so out of field of what we're dealing with here. It's not evidence of any pattern of conduct. It's 10 years old, and Judge O'Toole has no knowledge of what happened. So I don't know what she would offer. She wasn't even at the court at the time. It's only relevant if it is relevant to one of these Deming factors, but she does not have the background experience or personal knowledge of what happened that would allow her to provide any relevant information. It's also not relevant because it doesn't demonstrate any similar pattern or similar conduct. So, and again, prior disciplinary action is relevant, but this is not prior disciplinary action.
Thanks. Ms. Molina, any response?
Yes,
I apologize. Could I hear first from Ms. Callner, then I'll give you an opportunity, Ms. Molina. Ms. Callner?
I can confirm that commission records show that then Pro Tem Razumna did report this incident to the commission.
Okay, thank you. Ms. Molina?
One second. Based on the fact that he self-reported to the CJC, we'll leave this, and I won't continue with this line of question.
Okay, so we'll just skip over the 2015 issue.
Yes.
Okay. All right, any questions before we bring the panel back in?
None, Your Honor.
Okay. Mr. Gross, any further?
One moment. Yeah, I'd ask, so because the panel was present during sort of a bit of a back and forth where Ms. Molina said a few times that he had been removed. I just asked that they be instructed to disregard any comments from counsel about what had happened and that the objection is being sustained.
Ms. Molina, any response to that?
None, Your Honor.
Okay, I'll do that once we bring the panel back. I'll ask them to disregard any comment regarding any removal as a judge. Great. All right. Thanks everybody for your assistance. Appreciate that. We'll bring the panel back in. Ms. Perry, if you're there, if you could help bring the panel back in, and we'll continue. And also bring in Judge O'Toole, please. Okay, let's double check, make sure we have all our panel members. Thanks everybody for your patience. I see that Judge O'Toole's here. So we've got, it looks like we have everybody here. So I appreciate everybody's input, from the panel members to counsel on both sides of the equation. So panel members, earlier there was you may have heard some discussion or comment from counsel regarding Judge Razumna being removed as a pro tem judge or as a judge. There was an objection to anything that happened in 2015. I'm sustaining that objection. So any reference to him being removed previously as a judge is you're ordered and instructed not to consider that and to disregard it. All right. So with that said, I'm trying to remember where we're at with Judge O'Toole. She was during the direct examination. I think we're still at direct examination, and we'll turn the time to Ms. Molina to continue. Thanks everybody again for your input and patience.
And I have no further questions for Judge O'Toole.
Okay. All right, and then we'll turn the time to respondent counsel. Mr. Gross, are you handling this?
Yes, Your Honor, thank you.
Great, go ahead, please, Cross.
Thank you. Good afternoon, Judge O'Toole.
Good afternoon.
So Judge Razumna was a longtime pro tem for the King County District Court before this happened.
True.
And you didn't know Judge Razumna on a personal level before this happened?
Not at all.
You had no knowledge or sense of his personality or sense of humor?
No, I mean, I'd certainly met him in the hallways in some court or another. I don't remember if it was Seattle or Redmond or where it was. I'd met him before, but I certainly didn't know him in any capacity other than as a fellow pro tem. And then when I was a judge, he was a pro tem.
And you don't know whether Judge Razumna, sorry, you don't have any personal knowledge that Judge Razumna was informed at any point that pro tems were not allowed to get the discount at the Goat Hill Garage prior to this incident?
I guess you'll have to define personal knowledge. I mean, I'm aware that he was told no.
So in your opinion, or sorry, you said that you have personal knowledge that he was told he was not allowed to have that discount before this incident?
My understanding was that Judge Robertson had told him no, that pro tems don't get the discount, but I didn't tell him that.
And are you referring to the text message exchange between Judge Robertson and Judge Razumna?
Well, that and discussions we had in our executive committee meetings.
I guess what I'm saying, I'm talking about notice before the incident. You're saying that Judge Robertson had a conversation. Is that the text message conversation you're referring to?
The text message and then in our executive committee meetings. So it didn't come to my attention before this incident. I was never asked or involved in any discussion about it. He certainly didn't inquire of me, if that's what you're asking.
No further questions.
Thank you. Redirect examination, Ms. Molina.
No, Your Honor. Thank you.
All right, I'll turn to the panel members to inquire if you have any questions of Judge O'Toole. Okay, I'm not seeing any hands raised. I'll ask counsel if any objections to excusing Judge O'Toole.
No, Your Honor.
No, no objection.
All right, Judge O'Toole, thank you very much for your time. Appreciate that.
Thank you. Thank you. Take care.
All right. I'm just taking a look at the time. It's 2:30. You know, this afternoon's portion of the day is a little bit longer than the morning session. We've had some periodic breaks and just checking in with anybody. My plan is to have a break at 3. If everybody's okay with that, we'll just move forward to that time frame. Okay, great. Ms. Molina, if you'd like to call your next witness.
Okay,
Or Mr. Taylor.
Your Honor, on behalf of disciplinary counsel, we have no further witnesses. We would move the admission of Exhibit 202, which is the respondent's answer to the statement of charges.
Okay, Ms. Bremner, Mr. Gross, any objection to that admission?
Yeah, you know, I guess we'll object as far as I know, pleadings aren't normally admitted in trials, but I'll admit some ignorance of the CJC proceedings, but we'll object.
Okay. Ms. Callner has her hand raised. I'll hear from her, please.
Historically, the commission panel has always had access to both the statement of charges and the answer, just for your information.
Okay, thanks. So I think as a general idea, there's an allegations. I think the panel is aware of what the allegations or the charges are, as is everybody. And then there's an answer to that, and that answer to the allegations is signed by Judge Razumna. So it's an adoption. So I'll admit 202.
Thank you, Your Honor. Other than that, we rest.
Okay, very good. Thank you. We'll turn the time to respondent counsel for the calling of your first witness, please.
We will do that, Your Honor, but first we want to raise again what's going on in the live chat of the YouTube comments. I'm assuming what's happening is people are just creating new identities and entering, but the disruption is continuing and I think even getting worse. I don't know if there's any monitoring going on of that, but it's very concerning. Judge Razumna has children, he has family, and you know, this obviously wouldn't happen if this was a live proceeding. No one would have the ability to do that, and we would continue to urge that there be monitoring of the live chat and that disruptive individuals be.
Earlier, you specified 3 individuals, or at least monikers or names that cause some concern. Do you have identification of individuals that we could potentially look for and maybe exit?
I do. Elsie Lincoln Benedict. Brianna Bree Jovi. Yes, that's all I have in this screenshot I have access to. And I guess I'll re-raise my request that maybe a caution be given that people live stream. I don't know exactly how you would word it, but maybe something from you would prevent this from continuing to happen.
Well, it's you know, first off, when I you know, there's concern expressed for that, and if understanding Judge Razumna's viewpoint, that's of concern. If this were, say, in a traditional setting with brick and mortar, individuals could be present and citizens could be present during the hearing, and there's nothing that would prevent them from going out into the hallway and posting something either on Facebook or on Instagram or on Blue Sky or X or what have you, where they could express their feelings or thoughts about a particular public hearing. I guess the difference here in this case is that it's kind of a live reaction, and there's live comments that happen right when somebody shares information. I don't know, in some courts in traditional settings, they will limit reporters or individuals from having phones and texting simultaneously. Other courts, I've seen that has happened, where people will be in the courtroom and just texting live and saying, this is what's going on right here and now. So it poses kind of similar concerns. The one thing that's good about this setting is that the panel members are prohibited from seeing it. They're not exposed to that. The greater concern is, I guess, reputational concerns or safety concerns, or kind of public portrayal of an individual through those comments. Because there's a corollary between traditional brick and mortar proceedings and here is a online proceeding, I think you do the best you can do. And if there's somebody in the brick and mortar that's maybe posting things that are maybe causing people to gather outside in front of the courthouse or cause some extraordinary disruption, that person would probably their phone would be taken away or something of that nature. Outside of the courtroom, I don't know what more a judge could do to kind of tamp that down, unless there's some public safety risk or crimes being alleged to have been committed through those words or those postings. So I think at this stage of the game, with the assurance that the panel members are not being exposed to any of that, and the effort to provide a fair hearing in this setting, and the efforts by our IT manager to remove disrupted individuals, I'll ask the IT manager to do his best to remove those individuals that were listed. And I think you said LC Lincoln Benedict was one individual. It wasn't like three, correct? Looks like the mute was on when you spoke, Mr. Gross.
Elsie, yes, Elsie Lincoln Benedict is one person.
And then Brianna Brijovi was one individual too.
Yes, and citizen law.
Citizen law. Okay. All right. And then Mr. Cooper, our IT manager, just indicated he removed those comments for those two individuals. He posted that at about 2:40. He direct messaged me that. Okay, thank you. Appreciate your conscientiousness with that. All right, so now we'll turn to respondent counsel. Looks like Ms. Bremner, you're up. Would you like to tell your situation?
I have some issues. Thank you, Your Honor. And we call Judge Hirakawa, who's in the waiting room.
Okay, very good. All right, Judge Hirakawa, can you hear me okay?
Yes, I can. Can you hear me?
Yes, I can. Thank you. You've been called as a witness, and so I'd like to administer the oath of a witness. If you'd please raise your right hand.
Yes.
Do you solemnly swear or affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Will you please state your full name and spell your last name?
Greg Hirakawa, Hirakawa.
Thank you. Ms. Bremner.
Thank you, Your Honor. Good afternoon, Your Honor. And are we pronouncing your name correctly, Hirakawa? Is that right?
Yes.
Can you tell the panel, please, just a little bit about yourself, where you went to school, where you went to law school, and what your current occupation is, please?
I'll start with the last. I'm currently a district court judge, West Division, King County District Court. I went to law school at the Seattle University Law School and graduated undergrad from the currently #1 ranked University of Oregon.
Oh, I don't know if you want to say that so soon. Go Ducks, but okay. And how long have you been a judge in the West Division?
I was appointed in May of 2019 or 16, so I'm on my 8th or 9th year, depending how you calculate it.
Okay, and is the West Division in downtown Seattle or elsewhere?
It's wholly within the city of Seattle. It's the downtown Seattle King County Courthouse is its main location.
Okay, is that on, what floor is that on, the district court?
Third floor.
Okay, and it's just, And does it basically occupy one side of the third floor in the courthouse?
Yeah, pretty much the entire west side.
West side. Okay.
I'm sorry, east side.
East side. I started with that. Okay.
Yeah.
And did you pro tem in any court before you became a judge in the West Division?
Yes, I did. I pro tem for the King County District Court for approximately 2 years prior to my appointment in 2016.
Okay, so that would have been 2 years. So you starting out about in 2014 that you started pro temming in King County?
Yeah, about there. Actually started a little bit before that, but it was quite sporadic. So I'll say 2 years prior to my appointment.
And what did you do before you started pro temming?
I was an attorney, primarily in civil litigation, trust and estate litigation for approximately, I don't know, 10, 12 years or so.
Mm-hmm.
Also a contract public defense lawyer and King County deputy prosecuting attorney.
Okay, and what years were you a prosecutor or deputy prosecutor?
2000, it's just after I got out of law school, so it must have been 2003 or 4, around there, 5 maybe.
And how about when you did contract work for the PD's office?
It was
about
2010, I want to say, 2009, 2010. A friend of mine was ill, cancer patient, and so we helped take her load, some of us, our friends.
Do you know our client, David Razumna?
I do.
And how do you know him?
He is or was a pro tem judge on King County District Court.
And did you overlap with him at all as a pro tem, as he pro tem'd in the King County District Court?
I don't think so. We might have, but I know him primarily when I was a judge, or since I've been a judge, and he would either cover my calendar or serve as a pro tem for the King County District Court.
And can you tell the panel how you feel about how he performed as a pro tem for you in your courtroom?
Fine, I had no problems. He covered my calendar as well. You know, did I ever disagree with one of his holdings or rulings? Sure, but that could be said about any judge in this country.
Right.
But he covered it adequately, and actually better than adequately. I was always happy to have him cover my calendars for me.
And can you tell us anything that you know about his sense of humor?
Well, when somebody always asks me, or if I ask somebody, says, well, Judge Razumna is covering the calendar, you may have noticed him. He has a Batman belt that he always wears. And so I say, take it from there if you want to know how to approach him.
Would it be fair to say he has kind of a dry sense of humor too?
He does. Yes, that'll be a fair statement.
Okay. So I wanted to ask you a few specific things that would germane to this hearing, if I could. And let me start with this, Your Honor. Are pro tems in King County District Court, are they employees?
Absolutely.
Okay. And how can you say that?
So I've held a number of positions on the King County District Court. I've served as the West presiding judge. I've served as the assistant presiding judge for the entire court. And so we regularly come up with employee issues, contractual, disciplinary, whatever. And we are always reminded that pro tem judges are employees and have to be treated as such with regards to any investigation, due process, public benefits, retirement benefits, sick leave benefits, and those types of considerations.
And just so we're clear, when you say pro tems are employees, are you saying that pro tems are employees of King County?
Yes.
And absolutely, is that right?
Yes.
When you say that you were the presiding judge of the entire court, are you talking about the West Division or something else?
Two things. One, I was the West Division presiding judge, which means that I oversee or, am the judge for the West Division. We're all independently elected, but we designate one judge to sort of be the representative of the bench as a whole for that division. And I was also the assistant chief presiding judge for the entire court for about one term.
When you say entire court, what do you mean?
The entire district court for King County. There's the office of presiding judge encompasses the presiding judge and the assistant presiding judge for the court.
Okay. And so is there some restriction on the hours that you can use pro tems? Because if a certain amount of hours are exceeded, there's an entitlement to benefits.
Yes.
Can you tell us about that, please?
I couldn't tell you the exact hours. Our counsel probably could, and certainly our accounting or managerial section could. But at a certain time, a certain number of hours that our pro tem works in a particular calendar year, we have been advised that they accrue public benefits such as sick leave and retirement. And so those are costs that the district court has to set aside resources or funds for, just as we would for any other employee.
So during the time that you were King County District Court pro tem for years, you knew that you were an employee of King County, is that right?
It may not have been expressly told to me, but that was my understanding. I got a W-2 form. I didn't get a 1099. I have worked as a contractor, and I got a 1099. But with King County, I got a W-2.
Okay, and who issued the W-2? Was it King County?
King County.
Okay. And that was consistent throughout the time of your pro temping work, is that right? You got W-2s from King County?
Yes.
And you were King County pro tem judge, just like David Razumna. Is that right? Okay.
That's absolutely right.
Okay. Now, during COVID, and during the time of COVID, were you a pro tem judge?
No, I was a member of the King County District Court bench. I was in the leadership team for some part. I was West Division presiding judge for some part.
Okay, during COVID. Now, I want to ask you to think back to that time. Did Dow Constantine, who's the King County executive, was then and is now, did he put a change of parking rate for the Goat Hill Garage from $20 to $10 to get people to come back into the courthouse?
I don't know if that was the specific reason, but yes, there was multiple meetings and notices handed out by his staff that showed a reduction of 20 or a half price reduction in employee parking essentially from 20 to 10. The full rate I think is 30. It might have changed, but there's a full rate for people to pay. 30, I think it's $30. There's an employee rate of $20. So if I wanted to park, I could pay $20 today if I wanted to.
Right.
And then there was a half price discount during COVID for that rate to go down to $10.
So it's basically half of the discount rate during COVID per the directive of the King County executive, Dow Constantine.
For employees.
For employees.
If you're a civilian, it doesn't apply to you. You have to pay the full $30.
Okay. And were there stickers for employees during that?
Yes, there were two types of stickers, a pink one and a green one, and there were different values. And those would be any discount rate that was given to you because you were an employee that actually took off the 50% or the half price allotment.
Where were they affixed to vehicles?
At this point, I'm going to object on relevance. We're talking about stickers on cars in 2019. Seems a little far afield.
Object to speaking object.
So I'll overrule objection. I'll allow it.
Thank you, Your Honor. Go ahead. Do you want me to ask you again, Your Honor?
No, it actually wasn't on the car. What happened was each individual, whether it's a staff employee or a judge or any employee, you park your car, assuming you didn't pay for a monthly parking pass, on a daily rate, you drive into the Goat Hill Garage, as you would in any parking garage. You get a ticket, the machine spits out a ticket. You keep that ticket, you take it to your your staff, in our case, King County District Court staff, and they will place the pink ticket or the green ticket on that ticket, and that reflects the discount. And then you give that ticket to the parking attendant, and that discount is subtracted at that time when you leave.
All right, and were these, you said these stickers were given to employees during that time. Were they given to pro tem judges during that time?
My understanding is yes.
No difference between given and pro tem judges or any other employees, is that right?
That's correct.
Okay, and with respect to pro tem judges having the right to that benefit, which would be discounted parking, is it your understanding during the whole time that you were pro tem up until now, when you of course served as a judge and on the as the executive and also executive committee, that is consistently been the case that pro tem judges have the right to that discount?
Foundation.
Did I hear an objection?
Foundation, Your Honor.
If you know.
So let me think about that for a quick second. So the question was, since he's started working there as a pro tem until now, has there been a discount for pro tem judges?
Yes.
And the objection is foundation. I'm fine with the question as posed, overruled.
Thank you, Your Honor. And Your Honor, the witness, can you go ahead and answer? Thank you.
So I typically didn't use the Goat Hill Garage when I was a pro tem. I either, because my office was either downtown or I would have access to the bus because I live on the bus line at home.
Mm-hmm.
So I couldn't tell you as a pro tem whether that discount was offered. All I can tell you right now is that the discount was offered to employees of King County, and King County District Court considers pro tem judges as employees.
You answered my question. Thank you. Mine was a little inartfully phrased. Is and was the Goat Hill Garage an employees only parking garage?
No, anybody can park there. There's just different rates for employees.
And is there any kind of connection underground from the Goat Hill Garage to the admin building and or through the admin building to the courthouse, if you know?
Yes, there are a series of tunnels that go to various King County buildings.
Okay. Because it does rain a little bit around here, right?
It does. It's also for security purposes.
Sure. And individuals can go through security through the tunnel before they come in the admin building, or they used to be able to. Is that true?
Yes and no. You can do it during normal business hours. During after hours, you would probably need a card. Matter of fact, I know you need a card key.
Okay, to come in through the tunnel entrance. Security, I mean, it's security that's at the tunnel.
Well, one of the tunnels has locks on it. The one between Goat Hill Garage and the admin building and Chinook building. There's magnetic locks on it.
Okay, and that's for security. Did that change during the pandemic at all?
You have to leave pretty late. I mean, it's open at least until 6:30, if not later. You know, at 10 o'clock it might be locked, but certainly between 4:35, 5:30 it was open. Just go through it.
When there were any kind of meetings on an executive level during your tenure as a judge, did you not talk about pro tems outside of executive session because pro tems are considered employees?
So yes and no. We would talk about pro tem sometimes outside of executive sessions, and we would be reminded not to do that because pro tems are employees.
Okay.
Ordered to actually by the office of the presiding judge at one point.
Your Honor, have you ever heard of a policy that pro tems are not entitled to the discount in the garage?
I've never heard of a policy. I've never seen a policy to that extent.
And so if there's no written policy, I assume there's no policy at all. Is that fair to say?
That would be fair to say.
And Del Constantine has said that all employees get discount parking, no asterisk. Is that right?
That's what the meetings, that's what have always been my understanding through the meetings. That's what all the publications have said. There's no asterisk on those publications.
Thank you. That's all I have.
Okay, cross-examination.
No questions.
Okay, I'll turn to the
You have anything else?
panel members to see if they have any questions of Judge Hirakawa. Okay, in my scan, I don't see any hands raised from the panel, so I'll turn to the attorneys if there's any objection to excusing Judge Hirakawa.
I'm just gonna, if I could just double check, Your Honor.
Okay.
Anything else we have for him? No, no. No objection, Your Honor. And thank you, Your Honor.
No objection here, Your Honor.
Okay, great. Judge Hirakawa, thank you very much for carving out time and sharing your time with us today.
Thank you very much.
You're free to leave. Thank you. All right, with his exit, then we'll turn to disciplinary counsel. Ms. Bremner, would you like to tell your next witness?
She's not disciplinary counsel.
Oh, I'm not disciplinary counsel.
It all kind of flows out and gets a little, especially when it's 3 o'clock. So let's take our afternoon break.
Thank you.
So we will be in recess for 15 minutes. We'll be back at 3:15.
Thank you, Your Honor.
All right, we're pretty close to the 15 minutes expiring, so we'll invite everybody to come back into the panel. Great. Appreciate everybody's timeliness. All right, it looks like we have both respondent counsel here, both disciplinary counsel, Judge Rizuma is present, and we have all panel members, so we are ready to go. Great, thank you. We'll turn the time to Ms. Bremner for the calling of the next witness, please.
Thank you, Your Honor. We call Judge Rizuma.
Right, Judge, I guess I could just indicate that you're still under oath. So I'll just remind you that you're still under oath, and if you just state your name for the record, please.
Yeah, I acknowledge that I remain under oath. David Rizumna, Ruzumna.
Thank you. Ms. Bremner.
Thank you. And I want to make sure that everyone can hear me clearly. I'm using the microphone of my client. Is this loud enough?
Panel members, any concerns?
I can move a little closer too. And it's a little awkward because he's right next to me. So I'm going to talk to him this way and also toward the panel. But as long as everyone can hear me okay, and if not, please let me know because I don't want to have any feedback. So may I proceed, Your Honor?
Please do.
Thank you. Good morning. Can you please state your name and spell your last name for the record?
David Rizumna, Ruzumna.
And how are you currently employed?
Part-time as a pro tem judge and part-time as a practicing attorney. And doing a lot of both, so almost 2 full-time jobs.
Okay. I'd like to start by asking you about your background, if I could. Where did you grow up?
I was born and raised in Los Angeles, California, but I've been here in Seattle since 94 when I to go to law school, and I've remained here ever since. So I like to consider myself a native Northwesterner, even if I'm from LA.
We'll let you have that, I guess.
Prior to law school, I went to Humboldt State University that was in Northern California. Have a sociology degree, and then law school, and then practicing in various iterations of a law firm.
Okay. And what year did you graduate from law school?
97.
And was that from Seattle University Law School?
Yes, ma'am.
And why did you choose the Northwest?
Don't judge me, but being from LA, sunny and 75 got boring to me.
Okay.
I enjoy the seasons and the cooler weather.
Are you married?
I am.
And what was the year of your marriage?
See, now this is why I didn't want this on YouTube. We're married in 98.
And do you have any children?
I have 2 wonderful children, yes, a son and a daughter.
Can you tell us just a little bit about your children, what their ages and what they're doing?
My daughter very recently graduated from Western and is still living in Bellingham, bartender, a sommelier, and just doing everything that life has to offer for her. And my son is a senior at Ballard High School and is an actor and is enjoying theater. And my wife is also an actress and a writer.
And has your wife done any professional acting outside the home?
She has. Hopefully she doesn't act too much in the home.
That was a different way of asking.
But yeah, no, she's a playwright. I mean, she's had recent works produced at Seattle Public Theater that she's written and starred in, and so yeah, she's had multiple plays on a lot of different stages here in the Northwest, and she's been in a couple of small films as well and some commercial work.
Was there one recently at the Bathhouse Theater?
There was, yeah.
Can you tell us about that?
Yeah, there's a show called The Park, and it's wonderful. I understand I'm biased judge when it comes to that, but it was a wonderful play, and did very well at the box office.
And to critical reviews?
Yeah, she got some good reviews in the Seattle Times and elsewhere.
In the Seattle Times and elsewhere? Yes.
Yes.
So why did you want to become a pro tem judge in the beginning?
I ran for Superior Court in 2012, and one of the questions that I never had a satisfactory answer to is, what kind of judicial experience I have or experience as a third-party neutral decision maker. And I realized, there are some folks who make great judges, but they're lousy lawyers, or there's some folks who are great lawyers, but they make lousy judges. And I realized that, I guess I didn't know. So I figured, lacking judicial experience, I'd try to go out and get some. And so I started talking to people about the process of becoming a pro tem judge and applied, went through a training, and really enjoyed it. It was a huge learning curve. A lot of mistakes made at the beginning, just in terms of how things progress. But based on feedback I got from attorneys and other judges, and even just random comments from litigants, they seemed to think I was doing a good job. So, and I think word got back to the court managers and some of the other elected judges, because the volume of my pro tem work started building and building and building to where it is, or at least where it was, as of February of 2023.
So as of February 2023, was it essentially full-time?
Yeah, I'd have to look at my calendar. It varies, but pro tem assignments are you're either hired for a half day, an AM assignment, or full day, AM and PM, or just a PM assignment. And so I would say it's not unusual for me to have where I'm at least have one assignment, like perhaps a half a day, like for all 5 days of the week. I am performing judicial roles, some days all day, some days just a half a day, AM or PM.
Okay.
But yeah, it was essentially full.
So what courts have you pro tem'd in overall during the time that you've been a pro tem judge?
All told, Seattle Municipal Court, Bothell Municipal Court, Kirkland Municipal Court, Mercer Island Municipal Court, Everett Municipal Court, Snohomish County District Court, all 4 divisions, and King County District Court, all courthouses in all divisions. And I think that's about it.
And just so we're clear, how many years has been how many years have you served as a pro tem in any capacity in any of those courts?
Since 2013, essentially.
And what are at the time when all of this started, right before that, what was your intention with respect to your future serving as a pro tem or as an elected judge or in private practice?
Well, initially it was to essentially fill out my resume for potentially running for judge again. One feature of becoming a full-time judge, whether by appointment or election, is if you're full-time, you can't practice law. And I do love practicing law. And so, you know, I'll say that if tomorrow Governor Inslee's office called and said they wanted to appoint me to Superior Court, I'm not going to say no, but it became less of a, I stopped really striving for a full-time appointment, and I kind of like the balance of having one foot in each world, you know, doing some advocacy as an attorney, being able to practice law, which is my first passion, but then also performing judicial functions. And I think that being a pro tem judge has made me a better lawyer. And I think being a practicing lawyer keeps me, has helped me be a good judicial officer because I see both perspectives.
Why did you become a lawyer?
That's a huge question. We didn't rehearse these questions. You know, there's something, you know, in the sort of David and Goliath view of the world, there is something very equalizing about the law. It's probably just a general disdain for bullies. I like that no matter who you are, if you have a claim against somebody else, no matter who they are, it's going to be adjudicated in a fair way. Everybody gets a fair, you know, shake. And there's something very attractive about that to me, that, you know, you can have somebody who's physically bigger and stronger and maybe has more money. They have more resources available to, you know, force their way upon somebody or force their will in any given situation. And I just like the idea that the law was the great equalizer.
So with respect to other activities you've done as a lawyer, have you served on any boards or committees?
I served on the State Bar Association Character and Fitness Board and ultimately served as chair of that. And mindful that I'm under oath and I'm just trying to be precise, I don't recall how many years that was. I believe it was a 3-year appointment. And so the second year was vice chair, and then third year was chair of that committee. And so they look at people who have been flagged by the Bar Association, who, you know, people who have applied to sit for the bar who have some issue in their background that has caused a red flag. Also, attorneys who have been suspended or disbarred who are applying for readmission would have to go through the Character and Fitness Board. Ultimately, we would make a recommendation to the Supreme Court, which would have the final say over admission.
So fair to say that you were looking at, when you say red flags, you're looking at ethical issues that might prevent somebody from being able to sit for the bar.
Yes.
And as chair of that committee, what were your duties?
To look at the voluminous evidence that was supported either by or submitted by either the Bar Disciplinary Council or by the Respondents Council, you know, hearing evidence, swearing in witnesses, I think just largely along the lines of what Judge Evans is doing in this hearing, ruling on admissibility, although there weren't really as many evidentiary objections.
And go ahead.
No, my impression is that it was more of a it was more exploratory rather than prosecutorial. You know, we were just trying to figure out if somebody had, you know, it's a vague standard to begin with, character and fitness, and so just trying to look at the holistic view of somebody to, you know, is this somebody you'd be comfortable putting money in their trust account for safekeeping, that sort of thing.
Were you a gatekeeper in a way?
I guess so. I mean, I was part of the gate, but you know, the Supreme Court has the final say.
Absolutely. And how did you receive that appointment to the committee, then ultimately to be its chair?
I don't recall. I mean, there was an application process. I spoke with the Bar Council. I don't recall the specifics of the process, but once I was on the board, just as a member. You know, as the first year drew to a close and they had to decide who to have, you know, they need to, you know, there's an outgoing group of folks and an incoming group of folks. And so the second year, or at least the second to last year that I was there, I was vice chair and then chair, and that was based on the input of the other board members. They voted to have me be the chair.
How big was the board, if you recall?
I'm sorry, it
Ask
was,
you that. Okay.
it maybe, I mean, it was probably around 20.
So I'm just ballpark, that's great. Now, you have also volunteered in any capacity in the legal field.
I have volunteered in multiple capacities, most recently, and you know, as currently, the Finney Ridge Legal Clinic is a legal clinic administered by the King County Bar Association, where you know, a minimum couple nights a month, sometimes more if people need substitutions or coverage, basically between 7 p.m. and 9 p.m. on a Tuesday night, depending on, yeah, they're always Tuesdays, and they're 2 hours, and you do it. Used to be in person, and then during the pandemic and continuing after the pandemic, they've continued doing those remotely, usually by phone, where you call somebody, you know, you have to anonymize your phone number so that it doesn't show up on their caller ID, so that they don't, you know, you're really supposed to go on first names and stuff like that. It's not, if you impression with somebody and you help them a lot, it's not uncommon for them to say, well, can I hire you as my lawyer, or can I, and that's not what that is for. And so, you know, it's all just first name basis with blocked phone numbers, and just, you know, here's your half hour with an attorney. And usually that's not enough time to solve a problem, but it's enough time to figure out a game plan for folks. And so these are almost universally low income or no income individuals who would otherwise not have access to an attorney.
And what kind of legal matters do you see? I mean,
Everything. Yeah, I mean, a lot of them are correlated with poverty. You know, there's a fair amount of landlord tenant, although most of those I think get routed to the Housing Justice Project in King County, particularly with some changes in the law. But just people, you know, I mean, it really can range from anything. Somebody getting fired and they're not sure whether it was wrongful termination or not. And you can have a discussion about at-will employment and that sort of thing. Sometimes, you know, a neighbor who's engaged in conduct that's troublesome, and there's an interplay with landlord-tenant law and protection orders and things like that. It's really, there's no pattern or rhyme or reason to it. It's the kind of just everyday legal matters that come up that a lot of people don't have the funds to have an attorney deal with.
Okay, and so for how many years have you volunteered at the Finney Legal Clinic?
Don't recall specifically. It's been, you know, it's been a long time, more than 5 years.
Let me ask you just a few more things, background about yourself. Can you tell the commission about your sense of humor?
I don't know. You know, this is not a humorous proceeding, and nothing that I've heard today about my actions I would regard as humorous or reflective of that. In general, if I had to, I don't know. I think humor is an important part of an otherwise tragic existence that we all have. If you can't laugh at things, then, you know, life becomes less meaningful, I think. That would be kind of an umbrella philosophy, and I probably have a reputation as being a little irreverent and, you know, the person who breaks the ice at times. You know, I'm not a class clown, but I think irreverent. That's, you know,
we heard that you have a Batman belt.
I do.
Where did you get it?
I'm wearing it right now. And belt buckle that, you know, in situations where I have to wear a suit and tie, it's just my one way of trying to retain you know, like they can make me put on a suit and tie, but they can't take away the Batman belt buckle. So, and it also has helped, you know, there are people who might not know me by name, but they know me by sight. And just to give an example, like up in Snohomish County at the Everett Courthouse, some of the guards there, they might not know my first and last name. A lot of them know me, you know, by my first name, but if they can't quite place the face and I'm going through the security line, they see the Batman belt buckle and it's almost like, you know, they're like, oh, it's him, you know, it's the belt buckle guy, so let him through, you know, that.
And that was not rehearsed for you to wear today, is that right?
That was no, I didn't know you were going to ask.
Now, you know, there's been a lot in this case, you know, about whether or not you have been forthright. And have you been forthright through all of these proceedings?
I have been nothing but cooperative and forthright, and, you know, I'm doing my best here. This whole thing has been a source of embarrassment to me, because it's taking probably the dumbest thing I've done and it's amplifying it as like the centerpiece of, you know, to paraphrase Mike Tyson the other night, you know, like about legacy. It's not that I care about that, but it's just, you know, I'm not somebody who has famous cases under his belt. My accomplishments aren't things that have been in the newspaper mostly. And so to just have this kind of embarrassing, stupid incident become, you know, the defining feature of my life has been a source of sadness and embarrassment. I'm also sad because I adored most of the people that I worked with at King County and District Court. And question, I'm sorry.
Have you been forthright throughout all these proceedings?
Yes.
And were you forthright back at the time of this quote unquote incident?
Yes, when Kevin Whitley first contacted me, he was very insistent that he said he needed to talk to me about my use of parking. And he was very insistent that I come down and see him in person. And I remember I was sitting in Linwood at the moment that I returned a call of his or responded to an email, but I called him. And he said, we're not going to talk about this on the phone. We have to do this in person. You need to come to me in downtown Seattle. And don't talk to anybody about this. And I did set up time very promptly after that call to come down and meet with him in person. Actually, very much adjacent to the Goat Hill Garage is where his office was.
So did that mean that you didn't talk to Judge Robertson?
On the day that Kevin Whitley first contacted me, I didn't know that there had been meetings at the executive committee or anything like that. Judge Robertson had sent me an email earlier that day. I was included in a group email asking about if anybody could cover a particular calendar for her. After I got this call from Whitley, I essentially had a dual purpose of calling. You know, I did reach out to Judge Robertson, basically to, you know, I figured this is what this was about, and I felt like if I had wronged anybody in this misguided attempt at, you know, irreverence, humor, joking around, whatever, just outside the box, you know, stupidity. I thought that she was the one I needed to talk to. Also just part of, you know, very much part of the judicial canons about, you know, like disclosing things, you know, trying to make things right as soon as.
Right.
And so I called her, and it honestly was to make sure that she had coverage for this jail calendar that she had reached out to a bunch of folks about. And then also I was going to probably bring up the parking situation. When I called her, within 30 seconds or so, I got an immediate call from Kevin Whitley saying, I understand you're trying to call Judge Robertson, you know, essentially you'll be fired if you do that again. You are instructed in no uncertain terms not to communicate with anybody about this. And I think I wrote back a terse email to him saying, look, I had other reasons I was calling this person. You know, I mean, I didn't know who Kevin Whitley was. as a pro tem judge. I mean, I'd never answered to anybody at HR before, but this is like an HR guy calling me, and then I asked him respectfully to please to at least have the courtesy of spelling my last name correctly, which he refused to do after that. But I did meet with him.
And after you met with him, did you speak with Judge Robertson again?
No, I sent her an email after that meeting because it was clear that this was getting escalated in a way that,
right.
I didn't have full insight into. So it was more important to me, even though Kevin Whitley had said, if you communicate with anybody about this, you're going to get fired. At that point, I had enough pro tem work at Snohomish County District Court. I had also started working at King County Superior Court, which, is a different set of folks that would be scheduling me. And so I was kind of done with King County District Court, and I made the decision to resign. And it was important to me. I think the most important factor was I just wanted to communicate to Judge Robertson what had happened, why it had happened, to apologize, and to just say, like, look, because I didn't know what she was being told about this. It seemed like she was being told I did something a lot more nefarious than I did.
So you resigned from King County District Court as a pro tem. You weren't asked to leave.
Correct.
Oh. And you've already explained, why you did that. Let's backtrack now to your time as a pro tem prior to this claimed incident. What was your understanding about who you were employed by?
I mean, I was a pro tem for King County District Court. Got a W-2 from King County Finance. Anybody, this statement by Mr. Whitley and then Judge O'Toole, and it's the first time I ever heard anybody make a distinction between a pro tem on the one hand versus employee on the other hand. It was, my understanding is, you're either, if you do any sort of endeavor for somebody else, you're either a volunteer, an independent contractor, or an employee, just as a matter of basic law.
Right.
I'm not an employment lawyer, but that's my understanding of the categories.
So which one were you?
For King County District Court, I was an employee. I received a W-2. It had deductions in it. And there's nothing that, there are other courts, for example, Bothell Municipal Court pays just a flat rate, which they, and then I get a 1099 at the end of the year as an independent contractor.
Okay.
So they don't take taxes out and that sort of thing. With King County, it was, it was never even a source of ambiguity for me. There was no question that I was an employee of King County District Court, and King County District Court is a part of King County. They have the same logos, it's
Same executive, Dow Constantine?
absolutely. We're different branches, there's different branches of
Sure.
government and there's different departments, but no, I don't think anybody other than maybe Dow Constantine himself just works for the county. You can say I work for the county, but
Right.
that means like the transit department or the courts or the whatever, land use.
So, and just so we're clear, when you pro tem'd, you were in the King County Courthouse at 3rd and James, is that right?
Yeah, whenever I served in West Division, that's
Right, then the West Division is what we just heard.
Yep.
From Judge Hirakawa.
Yep.
That's where you were as well.
Yes, ma'am.
Okay. And that, just so we're clear, is King County District Court.
That is King County District Court.
It's not Snohomish County, it's not Thurston County, Pierce County, it's King County District Court.
That's correct. And that is not the only courthouse where I served. I did a lot in Redmond. That would be the East Division.
Of King County.
King County District Court, East
Okay.
Division.
Mhm. Others?
King County, there's an Issaquah Courthouse. I think that's part of the East. And then there's there's the Kent Regional Justice Center, or the Malang Regional Justice Center. It was renamed. That's the Kent RJC in Kent. And
Those
then
are all county courts, is that right?
King County
King
District
County.
Court. The Kent Regional Justice Center also houses the Superior Court. So King County is the only court, I believe, in Washington that it's the only Superior Court with 2 divisions. And so that would be in Kent and downtown.
And so, during this time, you're a King County employee, you understand yourself to be a King County employee, you have a W-2, etc. Had you ever seen any kind of written policy that said you weren't entitled to benefits like an employee discount in the Goat Hill Garage?
Absolutely not. If I had any indication that this was not a benefit to which I was entitled, that would have been the end of it.
And in the course of discovering this case, of course, as I said in opening, we asked CJC counsel for any written policy that said you wouldn't have been entitled to that. There isn't one.
Your Honor, counsel's testifying.
Is that consistent with your memory?
Well, why don't you rephrase it, omitting any alleged statements from counsel?
Yes, I can ask if you've reviewed the discovery in this case, indicating that there's no written policy and there wasn't one during
You're-
time period. Just a minute, I wasn't done.
So I already ruled, I already said, just go ahead and rephrase without reference to disciplinary counsel's comment.
All right, thank you. Are you aware of any policy, written policy that existed at any time during your tenancy as a pro tem judge in King County that said you were not entitled to an employee discount in the Goat Hill garage?
No.
And are you aware that any exists or existed?
I think that the minute if they had called Matt York or I guess he's not the presiding judge anymore. If the presiding judge were to stand on a tabletop and say pro tems don't get discounted parking, I mean that, and if I was there to hear it, I mean that would be the policy. It's not anything that was ever told to me. It's not we got emails frequently about, you know, do this, do that, don't do this, don't do that. It seemed like if it was an issue, there was, I mean, yeah, there would have been something sent out to say, hey, just a reminder.
So to answer my question.
Sorry.
Okay, you're not aware of, sometimes you talk too much.
I do
And I
talk way
do
too much.
But let me just ask you again. Were you aware of any policy, any written policy that existed during the time you were pro tem judge in King County that said you were not entitled to a discount in the garage?
Not aware of anything that disentitled me to a discount.
Had you been aware of such a policy, would you have attempted to get the discount?
No, of course not.
Why not?
Because that would be wrong. That would be, you know, that would be getting a benefit that I'm not entitled to. That's not how I live my life.
So at the time of this alleged incident, did you believe you were entitled to that benefit of a discount?
Yes, very much.
Let's go back then to dealing with the attendant and your conversations about being entitled to the discount. First of all, do you remember how this conversation first started with the attendant in the garage?
To the best of my memory, the first time that I parked at Goat Hill Garage, because I had received emails from Lori, the West Division manager, frequently just indicating, you know, talking about the Goat Hill Garage, and it seemed like it would be a favorable place to park if you were an employee, and because they didn't send out emails about other garages elsewhere in downtown Seattle. And so I think the first time I parked there was, I think it was January of 2023, and I thought, and I gave the guy my ticket, and he said, okay, that'll be $30. And I just commented like, wow, that's expensive. It was more expensive than I had anticipated. I mean, I had the money, I was going to pay for it, but it didn't seem like a deal to me. And so he said, oh, well, are you a King County employee? And I said, yeah, I work for the district court. And he said, do you have a W-2? He asked me if I had a W-2, or no, he asked me if I had a pay stub, pardon me. And I said, no, I don't. And I think it was in that conversation that I showed him like my name placard.
And so let me stop you there. Name placard, would that be the placard that appears on the bench when you're presiding?
Yeah.
And so you showed him that?
Yep.
And do you have it with you?
Might actually, but I mean, I don't. If you want to see it, I think I do have it.
Sure, does it say?
It's one of the things I carry. That is just this.
Can't believe you have it. Okay, hold on.
I know.
David, okay. If you could hold it up for the camera so everyone can see it. It says David Razumna, Judge Pro Tem.
Yeah. So I think I showed him, I mean, that was a little bit easier for me to get to in the backpack at the time, but I think I just, you know, I was like, well, I've got this, and he's like, no, but the message was, he never distinguished between, well, if you're a pro tem judge, you don't get this, or if you're a part-time employee, you don't get this, or it was just, do you have a pay stub? Do you have something to show that you're affiliated with the district court?
So you showed him that?
That didn't work. I paid him, you know, I think when I pull up, I gave him like my debit. You know, this is just how I think most people, this is what most people
Sure.
do when they park and they're leaving a parking garage is you hand them the ticket and your debit card or your credit card. And so, I mean, I was going to be paying whatever was charged of me, but it was, you know, so yeah, when he said that, that's not going to get you the discount. I was like, okay.
So was that friendly, the conversation?
Yeah. I mean, yeah, it wasn't hostile. It was just, you know, I understood that. I mean, I deal with a lot of people every day. He
Right.
obviously sees a lot of faces, and the message that I got from him was, how do I know you're not just a lawyer that was at the courthouse or somebody else, you know, not a lawyer, just like a litigant, whatever.
Okay.
It's just trying to, you know, scam the commission. So it was just a matter of how do I corroborate the fact that I'm a King County employee.
By the way, did you ever see like a sticker or a notice that said that that stated any requirements for getting a discount? Did you see anything like that in the garage or in the booth or anything?
There was a sign that said, be prepared. It's something like, be prepared to show your badge, or you have to have your badge to, you know, it's not something that you would swipe, but it was just, I think that's probably the easiest way as a policy matter to, you know, just like the easiest thing is just show them your badge. But that's the only, you know, other than that, it said, I mean, it acknowledged that there's a King County employee discount, and I don't think anybody disputes that.
All right, and you didn't have a badge as a pro tem?
That's correct. The only badge I would ever have with me coming home would be if I had worked all day and I was scheduled to be there the very next morning. There's an access badge that, you know, I would just take with me because nobody else is going to use it in the meantime, and I would be using it the next morning. Otherwise, if there was going to be you know, if it was a Monday and I wasn't going to be pro temming again until Wednesday at that courthouse, I would turn in the badge, but it's not something that has my picture on it or anything.
So to the best of your recollection, what was the next time that you showed him something or talked about being entitled to the employee discount by virtue of being a pro tem judge?
I really don't recall the sequence of events. I know that there was one occasion I was in a loaner car. I do have my own judicial robe, which I usually keep in the back of my car. This was this huge pickup truck that I was driving at the time because it was a loaner from a dealership. And so by happenstance, I happen to have my robe just in the back seat of the cab and easy grabbing distance. And it was sort of, I mean, I realized that didn't prove anything because I could be part of a church choir or something, you know, but it was like, it's a, you know, it's a robe. It's like, you know, and he would sort of smile and say, no, that's not going to do it. And, you know, and I would, you know, I would get charged $30.
And just so we're clear, you never did get charged less than $30 during all this, is that right?
Correct.
So you never did get a discount, correct?
Correct.
So then at some point, we get to the claimed incident in this case where you've got a piece of paper with stamps on it. Was that a letter per se?
I mean, it is what it is. It's a piece of paper that, yeah, that I created. I wouldn't call it a letter. It was just a sentence.
Can we pull up 201, please? Let's just take a moment to pull that up. I know we've seen it before, but I want to ask you a couple questions about it. Showing you what's been admitted as Exhibit 201. First of all, do you recognize that?
Yes.
And what is it?
It's a document that I created that I've been very candid about having done. I created it at the courthouse before I left.
And is 201 a complete copy of what you created back at that time?
No.
How is it not complete?
I had other stamps on the page that are not depicted.
And we heard with another witness today about this fold near the ends, or excuse me, near the bottom. Could we make that bigger, Karina? Is that possible again? You see that, you can see kind of a,
Yeah, the horizontal fold.
yeah. And there's also a vertical fold, or no?
There are several vertical folds.
Okay. So did you fold that piece of paper out?
Yes.
And so tell us how you folded it out.
Folded it in half.
Wait a minute, before you move on, you fold it in half, top to bottom or side to
Top to
side?
bottom in half, long ways, and then in half again, and then in half again. And this is where I'd have to actually use a piece of, I think, one
Use
more
a piece
time,
of
but it's so that it would fit into a press.
With the court's permission, if I could ask my client to demonstrate with a piece of paper what he did.
That's fine.
Thank you. Can you hold it up so people can see though too what you're doing?
Okay, well, I just fold it in half. Fold it in half again. Fold it in half again. Press.
So when you folded it up like that, you put it in your pocket, was that before you showed it to the attendant?
Yeah, yes, I did that before I left the courthouse.
Okay, thanks. And this piece of paper that you just folded up for the commission, is this the same size as the piece of paper?
It looks 8.5 by 11 letter size. Yeah.
So it wasn't like a full legal pad length.
It wasn't. Legal would be 8.5 by 14. It was 8.5 by 11.
Okay. And so so what we're basically seeing here is the top, what, third of what you had? Approximately?
Sure. Yeah.
You can take that down, please. So if you can just hold this piece of paper up again, maybe put an X as to where that ends, the last stamp that we're seeing on 201.
I mean, what we're seeing on 201 is the text up here. I'm sorry, text, and then there's the Robertson stamp and the circle stamp, the seal stamp, and then there were others that were obviously toward the bottom.
Okay. And when you say there were others, and actually we can make this an exhibit, I suppose, for the record, that would be the next in order, but I can do that at the end of the proceedings today. So the other stamps that were on there, you've been asked how many, it's been difficult to say exactly, but there were multiple, I think you've said, was that the word you used?
Yeah, I mean, Kevin Whitley from King County, when he said he doesn't care about those stamps, never asked me any questions about them.
Okay.
So it was really, yeah, that dispute about the number of stamps didn't really come about till later.
Till later, like in these proceedings?
Yes.
Okay, with Mr. Taylor at all?
Well,
Or before?
including with Taylor, but also with Mr. Twitty.
Okay. So let's go back then to, well, before we go to actually to the creation of the document, did you ever intend for this to be an official document of any kind?
No, I told the gentleman, again, this was in the context of me just trying to corroborate the fact that I was an employee of King County District Court as a judge pro tem. I wrote down the truthful statement. I wish to God I never used any court, I went about this the wrong way. I admit that. It was a mistake. It was a lapse in judgment. My intention was to corroborate the fact that I had access to things that other folks would not have had access to. If I were just a litigant visiting the courthouse, would not have access to a judge's date/signature stamp. I would not have access to the court seal. So it was just a way of saying, hey, in that sense, I don't blame Mr. Whitley for not caring about my personal stamps, because those weren't the ones intended to convey the impression of formality. And one of the stamps said Judge Pro Tem. There's a Commissioner Pro Tem stamp. These aren't huge stamps. And it was the Rebecca Robertson and the court seal stamp are the ones that have, I think, caused the problem.
So you said were any of these stamps your stamp?
Yeah, yes, not the two that are visible in the picture.
But I'm talking about all the stamps, so let's talk about all of them.
Yeah, in my backpack, there was, I would typically carry around several stamps. I don't recall which stamps I put on there, but the universe of possibilities is limited. So I had a Commissioner Pro Tem stamp. It's printed out in one line, relatively small font. It's meant to fit into the on protection orders and other types of orders. Under where you sign, there's a space that says print name, and so that was a commonly used stamp for my commissioner work in Superior Court. It wouldn't, it's not something that would take up a huge amount of space. I had a David Razumna Judge Pro Tem where it says David Razumna in larger font, and then smaller font Judge Pro Tem that encompasses 2 lines, but not a large stamp.
So I wanted you also just to show the members of the commission, the presiding judge, how big those stamps were, because they're pretty small, right?
And they're not as big as the 2 that are visible in the picture.
Just something that's darker.
I have a dark pen.
Do you? Oh, you do so much more organized now. And again, with the court's permission, if I could ask my client to show how big those stamps were, because that appears to be an issue here in terms of how many would fit on that piece of paper.
Fine.
Get a folded up piece of paper.
Yeah.
I mean, maybe I could put it on there.
So we'll go with the,
Or not. I mean, here, this is from my memory. The David Razumna Judge Pro Tem stamp is currently located in Everett because clerks needed that. I signed documents electronically up there. And so the conformed copy stamp has just stayed up there. That's why I do not have it physically with me.
Okay.
So just,
That's good.
yeah, so like the Judge Pro Tem, that one has 2 lines where it has my name a little bit larger, and then under that it says mirrored. And then the Commissioner Pro Tem stamp over here is more straight, flat, 1 line, and it's meant to fit into a particular area. I had an address stamp that was probably roughly the same size as the Judge Pro Tem stamp. And I can bring in, I could bring in templates, but I don't even recall which other stamps they were. So I'm not going to testify like, oh, this one was here and this is what it looked like.
But so when we look at the top of 201, we've already gone on at length about what's on 201, but the remainder of the piece of paper had these smaller stamps, it sounds like.
Yes.
To the best of your memory.
Yes, to the best of my memory.
As you put the stamps onto the piece of paper, what was going through your mind?
So this is where I find it very difficult to articulate my thought process, because it was fundamentally not a well thought out plan. This was a stupid action on my part, and I regret it. If you're asking what my thought process was at the time, beyond just my stated purpose of, how do I corroborate, that maybe this will convince the guy that I'm not just trying to, get a $10 discount for no reason, that I have some affiliation with the court. This was not, the other thing is it was not intended to look like Judge Robertson had physically signed this document. It was very faded ink. It was just, no reasonable person would look at it and say a human being affixed their signature to this. It didn't look like a formal court document. It wasn't taken that way. I told the parking attendant as much when I handed it to him. And even Miss De Los Santos, I think she said she wanted to take a picture of it to cover her ass, so that if it turned out I was supposed to get a discount, she'd have a reason to say, well, here, he gave me this stupid thing, so that's why I didn't give him the discount. It was.
But she only took a picture of part of it. Do you know what
Yeah,
that was?
No, I don't.
And do you know, was that, by the way, there was some testimony that it was to be given back to you, this piece of paper in its original form. Was it ever given back to you?
So again, even though I've placed a lot of people under oath, I have taken people's deposition testimony. This is only the 2nd time I have testified under oath, and I'm just trying to be cautious. Okay, I can't say 100%, like I'm not going to swear up and down that I did not get it back. I do not recall getting it back. I don't believe I got it back. I keep my car very clean. There wouldn't have just been stray papers laying around. And, I would have remembered if he had handed it back. And to my memory, he did not. So I have I was also led to believe that Gina De Los Santos emailed Heather Dean and then the next day sent her a picture of this thing. That sort of led me to think, well, maybe she still had the document. I did hear her testimony that she had just took a picture there in the moment when she was talking to the parking attendant that I've been dealing with. So beyond, I don't know what they talked about. I don't know what perception she got from the parking attendant.
Any reason at all to understand, is there any reason at all that you can think of that someone would just take a picture of part of that piece of paper and omit everything else, all of your other stamps?
I think she was taking a picture of the text, and the two stamps that were placed most proximate to the text were the ones that, were doing the heavy lifting in that document. Those were the ones that would tend to corroborate, like, well, he has some sort of access to this stuff. Maybe he is an employee of King County District Court.
Okay.
Yeah, well, that's it.
So you were, when you created this, you were in chambers. Whose chambers were you in?
Rebecca Robertson.
And where in the hallway is that chambers and courtroom? On the west side, perhaps.
East side.
Or east side.
I don't even remember, honestly, because there are courtrooms on both sides. It's been a while. I'm sorry, your question is where?
So you were in chambers.
Mm-hmm.
So you've been pro temping for her that day. And so where did you find the stamps? Aside from the ones that were yours?
Yeah, they were the one that had the date on it and her signature and her printed name was just on her desk. And the one that the court seal stamp, I think it was either by the printer, which would be closer to the clerk's area, or elevated on the judge's bench, but I think it was in the clerk's area. But it was out in the open. It was just sitting there. It wasn't, I didn't have to open drawers or anything like that. It was just there.
And so once you put the stamps on things, you folded it up like you showed and went out to the garage. Did you know the name of this attendant?
Nope. And they refused to give it to us.
And when you say they refused to give it to us, you mean that disciplinary counsel?
I don't know. I think the Goat Hill Garage. I understand he's not employed there anymore. He was the one that I dealt with.
Can you describe him, just generally? What you remember about him?
Like physically or like demeanor? I mean,
demeanor and physically.
He was a smaller fellow, African-American gentleman. Seemed that English was not his first language, although I had no reason to think he didn't understand English, but he spoke with an accent, I believe, and kind of an energetic guy. He was doing like little counter push-ups, sometimes when I would walk by or I noticed that. That's something that sticks out.
Okay.
Yeah, I mean, friendly, and we weren't friends, but it was just like a parking guy that you see.
Were all of your interactions cordial with him?
Sure, yeah.
And were any of them where you used your sense of humor?
Well, unfortunately, it went horribly awry. Again, I didn't mean this as a joke, like somebody would look at it and start laughing hysterically. What I think earlier when I used the word joke, that was probably not the right terminology. It was meant in a lighthearted manner.
Okay, and let's go to the best of your memory of what you said to him with this piece of paper. What do you remember saying to him when you showed him the piece of paper?
Like roll down the window. Hey, it's like it's me again, and look what I made for you.
Let me stop you there. So you rolled down the window and you said, look what I made for you.
Yeah, I mean, something like that. And how else would I have access to all these stamps?
How else would I have access to all these stamps? And so was that basically lighthearted? And I mean, joke's not the right word, but you're saying, look what I made for you, man. I couldn't have made this unless I had access to these stamps.
I took it as me explaining to him that this is not something real. It is something that corroborates the fact that I have access to these stamps as only an employee would, as somebody who's affiliated with the court would. Again, I find it very difficult to walk that line between trying to explain something stupid that I did that I regret, I'm not trying to justify it. I'm not trying to say this is why it all makes sense and this is why it was a smart plan on my part, like it was a mistake. It was wrong. And, been doing everything I can to take responsibility for that.
How long have you been doing that for?
Trying to take responsibility. Well, since the moment the guy from HR called, me trying to reach out to Rebecca Robertson, who I haven't spoken with, we were work friends, we weren't social friends, but we had a very good working relationship. And so I feel horrible that, we parted ways with her, having this, this bad feeling toward me. I saw a little bit of that in her testimony. I think she felt bad that, I like this guy, I liked her, and I have nothing but respect for her.
So when you said, look what I made for you, I could make this if I wasn't, pro tem judge or judge. How did he react?
He looked at it like, like this still isn't going to do it, sort of the way he reacted to the rope.
Okay. So, and did you insist on, at that point, getting the discount once he had that reaction?
No, I didn't. He already had my card and the ticket, and it was either going to work or it wasn't. But, this wasn't just a matter of saving $10. If you think about it mathematically, if you're working there every day of the week, which there wasn't a time when 5 days a week, for the entire month where I'd be there, but you'd be either paying $600 a month for parking, which is quite a bit, or you'd be paying $400 with the discount. And, this wasn't like it was, I just figured once he understood that I was an employee, I was there enough that he would, maybe just recognize my face, like, oh, it's that guy, Again, I'm not saying it was a genius, level plan. It was just like, yeah, I guess once he knows me, then hopefully I don't have to go through this rigmarole each time.
So did he take the piece of paper with the stamps all over it?
Yes, from me, like when I handed it to him, yeah.
Okay, so he takes it, and you didn't say give that back to me or anything like that?
No.
Why not?
Why would I? I don't know. I handed it to him, and I did not say give it back to me.
Well, I guess I'm asking it because if you'd done something, presumably fraudulent, and you were trying to pass something off that you shouldn't have, you would say give that back to me. You didn't want the evidence to go any further. But you didn't do that, right?
Reading.
Sustained.
Why didn't you ask for it back?
I didn't think it was something that was inculpatory. I didn't think I had done anything fraudulent, or, this wasn't something where I forged a judge's signature. There's nothing in that, yeah. I don't know. It was, whatever wrong there was, it had already occurred, which is that, I should not have used the stamps. I probably should have found some other way to, I probably should have gone to a judge and said, or court management and say, will you write a letter verifying that I'm employed as a pro tem judge here?
Yeah, you could have done that with anybody, sounds like.
Yeah.
And Judge Hirakawa, you heard his testimony.
He would have signed a letter. Sure.
Okay, and you heard his testimony. Do you agree with what he testified here too today?
Of course. The notion that I was not an employee, either of King County or King County District Court, just blew me away. It was the first indication ever that it's like Matt York's letter to me, after I had resigned, but after they finished their investigation. That was the first indication that somehow pro tems aren't regarded as employees, or that there's some confusion as to whether we're employees. We're low on the totem pole employees, but we're employees,
And was that an issue raised also with Mr. Twitty and others in connection with this case, whether you were an employee?
Well, they raised it. They said that that's what they were being told, that the management, that like.
Your Honor, this is hearsay, and also gets into 408.
Sustained as to hearsay.
Is it fair to say there's been confusion expressed to you about whether or not you were an employee for King County? In these proceedings?
Yeah, within these proceedings, there seems to be quite a bit of confusion as to my status as an employee.
Is there any confusion in your mind about whether or not you were an employee of King County during the time you pro tem there?
No.
None whatsoever?
None whatsoever. I mean, let me qualify. I mean, at this point, knowing that apparently there are folks within the district court system about to take a contrary view, I understand now that it's a topic of debate apparently, but you know, yeah, there's no doubt in my mind that that's what's on the paychecks, it's what's on the W-2s. It's what's in the pro tem training where it identifies that we are employees, contrary to what might have been said earlier.
Did you ever have occasion to park in the Hill Garage in connection with your Superior Court position?
Yes.
And tell us about that, please.
I don't recall exactly when I started working for Superior Court, but it was kind of all around the same time, January, February. They do fully validate parking for pro tem commissioners. And by validated, I don't mean that they put a stamp on there that entitles you to a discount. It means they stamp your parking ticket and then you you just give that and you don't have to pay anything. So it's fully paid parking. That wasn't my intention here with this. I wasn't trying to get free parking. I was just trying to get the employee discount.
During the time, did this attendant ever recognize you during those times?
I think he recognized me as the guy that keeps saying he's an employee. I don't know what that is.
Did he ever chuckle kind of when you came through with the Superior Court?
One time I came with, there was one time where he still asked me he said, hey, do you have ID? You know, and like, well, it's, it is fully validated, and, and he didn't charge me, but it was, I don't know. I don't know if you'd call that, again, a joke, might be making it more grand than it was, but I thought he was being lighthearted to me back, like, oh, like he's pretending to give me a hard time about if I have, how do I prove that I'm an employee? But even though he knew full well that in this case I had validated parking. That's probably me speculating into what was in his mind.
Do you have any way of knowing what he said to Ms. Del Santos?
No.
You don't know one way or the other if he said anything at all to her about your interactions?
I have no idea what he said.
Anything at all about whether you were kidding and having a lighthearted conversation about, look what I created for you,
I don't know what he said. I can tell you that today was the first time I ever saw Ms. De Los Santos's face. That I've ever seen her. I've never met her, never seen her. I had no idea who she was.
How did you get along with Judge York?
Not great. He disliked me. I don't know what you want me to say about that.
Well, I'm just asking about the weasel comment. Was that about him or someone else? And did you originate the weasel?
No, in the text exchange I had with Greg Hirakawa, he referred to Judge York with using a term that included the word weasel. And I was basically just using that. I was just piggybacking onto the phraseology that he had used.
Okay. Because we heard quite a bit about that earlier in your testimony. It was conducted by CJC counsel. So that wasn't your term, was it?
No, Judge Hirakawa referred to Matt York as a dick weasel in the preceding text, and in the subsequent text I said, by the way, the weasel, like i.e. the one that you just referred to.
No. And obviously these were private emails between.
They were text messages, yes, and my intention was to submit redacted versions, and I'm not throwing you, Ann, under the bus again. But I'm just, I feel bad because it's probably, I'm sorry to Judge Hirakawa that, if there's anything that he found embarrassing, I don't know whether he did or not, but if this was something he would rather not have been publicly stated, I feel bad about that.
And it is my fault. I'm the one that disseminated that to show some of the conversations you had with your colleagues way back when you first met with the commission before the statement of charges. And did you in fact meet with the commission, with Ms. Connor and Mr. Twitty?
Yeah.
And with,
408, Your Honor.
I didn't hear it, Your Honor.
She said
408.
It's not offered,
So
Your Honor.
I'll allow that particular question. You can renew an objection if it goes further. Over.
Yes, I met with them in Olympia for a couple hours with you at my side.
Okay, so we're all down there in Olympia before the statement of charges was filed.
Yeah.
And you were cooperative that time?
I've always tried to be cooperative from the
And-
very beginning with both HR at King County District Court and with the CJC.
Up until even to today, is that right?
I mean, first time I ever saw a suggestion that I wasn't cooperative was Paul Taylor's trial brief, where he said I've been uncooperative.
And can you think of anything that you've done that would indicate you've been uncooperative?
I have always immediately availed myself, including submitting to a deposition immediately upon Paul Taylor's request. I didn't request a, I didn't say, well, make the presiding officer order it or anything like that. I was happy to go down and meet with Reiko and Kurt. I mean, yeah, this is, and not only just cooperative in terms of availing myself, but also just trying to say, look, I realize what I did was wrong here. I'm sorry, and could we, sorry, it's not, it shouldn't necessarily be a life-altering mistake, but it's not something I've tried to justify or explain away. I've tried to take responsibility.
And are you truly sorry?
I am, of course. Yeah, I mean, I'm not just sorry for the consequences that I've suffered because of this, that's like, oh, I'm sorry I got caught. But I mean, I do feel bad. I feel horrible that somebody like Rebecca Robertson is, she's left with a bad taste in her mouth, like, oh, Razumna did something nefarious. Yeah, that bothers me. It saddens me. It's not reflective of who I am. It doesn't reflect what my intention was. I don't know what else to say. I mean, yeah, I feel genuine remorse. I don't know how else to express that.
Now, has this caused you considerable stress?
Yes. Yes, it's professional, personal embarrassment, stress. It's been costly. It's been, spent quite a deal of time thinking about this. I took an ethics class over the summer, which Mr. Taylor kind of made fun of, like, oh, he might have taken an ethics class, but who cares? That was done, I was glad that I took it. I actually felt like I, learned something. I enjoyed the whole experience thoroughly.
And is that something that Ms. Connor recommended to you?
Yes.
Now, looking at some of the correspondence that you had in writing, were there any, I'm not going to go through every single exhibit, but to ask you, to the best of your memory, conversations about the Goat Hill Garage, for example, being closed on Saturdays?
Yeah, so whenever I was scheduled for Saturday jail calendar, I would get, and these are the emails that are, probably should have just compiled them all in one stack, but they start at, here, they start at 304 and onward, where Lori Holzapfel would send an email copied to God knows who, but it'd be an email to me saying, good morning, David, we have you scheduled to cover the jail calendar on such and such a date. It starts at this time. They identify who, which particular clerk is going to be working, and they have their contact information. And she always said, please note the Goat Hill Garage is closed on Saturdays. That was just sort of one additional piece of information that I had in my head that, the Goat Hill Garage is a favorable place to park if you're an employee of the King County District Court, including an employee who is employed as a pro tem, because they are sending this to me saying the Goat Hill Garage is closed. They don't say the Columbia Tower Garage is closed or any other garage is closed. So that was just one other piece of background information that every time I did the Saturday jail calendar, they would always point out, remind me that the Goat Hill Garage is closed on Saturday.
We offered 304.
307.
When you say offer 3 and 4, you're moving for its admission.
I'm sorry, Your Honor, I'm reading right here.
Oh, my apologies. When you said you're offering 304, are you moving to admit?
Exactly, Your Honor.
Okay.
No objection.
304 is admitted.
Thank you. Should we do through 309 or
Yeah,
through 308?
I'm just going next in order, 305, 306.
Okay,
sure. Want to do them?
Yeah, that's fine. Let's go ahead. I'm gonna look at 305 now.
Yeah, so we can go through these quickly, but 305 is a similar.
Yeah, that was a September 30th email sent Wednesday at 1:30 by Lori, the court manager, confirming that I was covering the jail calendar in a few days on October 3rd, 2020. And again, good morning, David. Thank you for covering the Seattle jail calendar. She says what time it starts. She identifies Philip and Flo, who will be the clerks. She reminds me, please note the Goat Hill Garage is closed on Saturdays, but Flo will let you know what public parking is in your area. And then she says what the working hours are for the jail calendar that day. So it follows a format, but these are not form emails. They're not identical. It has new information on each one.
Thank you. So would it be fair to say that 305 through 309 are similar?
Those are similar examples.
We move to 305 through 309, Your Honor.
No objection.
Okay, so exhibits 304, 305, 306, 307, 308, 309 are admitted.
Thank you. Just take a moment, Your Honor.
While you're taking that moment, let's take a little stand break. It's about 4:25. I just need to move a little bit to get the blood flow a little bit. So if anybody wants to join me, feel free. Okay. Well, looks like a couple people, let's double check with our panel members how far they stepped away. That's just, hopefully it's just a stand break and not a walk away break, but some may have stepped away. So let's just double check. Yeah, looks like most are here. Just one member, we'll just wait for him to return. I'm not sure where the other panel member is. It may behoove us just to maybe just take a more formal break, and that would give him some time to return, and he may be engaged in some activities that can't come right back. So why don't we just take a 4-minute break? We'll be back at 4:30, and that probably should give him time to come back.
Okay.
All right, let's plan on coming back here in just a few moments. We'll go ahead and get started again.
On 6 right now. What is this you sent me, Nick? Did you ever get it offered back?
Okay, looks like both sets of counsel are present. I see Mr. Gross. I heard Ms. Bremner's voice, so I'm assuming she's nearby.
Yeah, I'm back. You can hear me. I'm here.
Great. And Judge Resumed is here. And then we're just missing just one panel member. So I really appreciate everybody's conscientiousness and with the breaks and your flexibility. That's really great. All right, looks like all of our panel members are here. So we'll turn the time back to Ms. Bremner. Ms. Bremner.
Thank you, Your Honor. Judge Rizuma, did you ever get a sticker for validation for parking in the Goat Hill garage?
I never used it, but I did receive it. I wasn't parked at the Goat Hill, but there was a clerk who was passing out validation sticker. I think the ones that Judge Shirakawa was alluding to. Just kind of, it was like a Friday afternoon, and he was like, "Hey, anybody need validation? Anybody?" And he was just handing it out. And
Where were you when you got the sticker?
I was in the clerk's area of the third floor of the King County Courthouse.
Okay, and they knew you were a pro town.
Yeah,
Okay.
yeah.
So the next thing I want to ask you about is Exhibit 302, but starting at Resumna, ending in 06, all the way through the end of that exhibit. So could you cue that up, please? It's entitled Pro Tem Policy. Okay, do you recognize the document before you, ending in 06?
Yes.
What is it?
It's a page taken from the PowerPoint presentation at the training.
Which training?
The Pro Tem, King County Pro Tem training.
And it says Pro Tem Policy, considered to be temporary employees.
Correct.
Appointed by the court's exec committee, and et cetera, in terms of the policy. And then the next 2 pages are what?
That is the formal King County District Court Pro Tem policy. And if you look at the top right, it says it was issued May 4th, 2021. And the one that it superseded had similar language as what's in here about temporary employee status. Pro Tem judges are appointed by the King County District Court for a specified term, but it identifies us as being temporary employees.
Keyword employees.
Yes,
right?
yeah, and so this is something that I had sent to Kurt Twitty at the commission because he had received information. He told me he received information that we're not employees or that the court doesn't regard pro tem judges as employees. So I sent him this. I was like, well, here's the training material. And then that, we didn't revisit it.
And if we go to the end of that exhibit, what is that? If you can pull it up, please.
Next page is it's going to be my W-2s. There we go. And I did redact my social security number. And then the big white box that you see there, I had some notes that I'd written to Ann, and I just superimposed a white box there. So that's what that was intended to cover, was just so I'm not submitting work product to the commission.
Can we look up at the top left, if we can make it bigger, please, Karina? On the W-2, employer's name, address, and zip code. What does it say there?
It's King County Finance. And it's the 401 Fifth Avenue, 2nd floor. It identifies David Rizumna as the employee.
Okay. So we offer or move to admit exhibit number 302, but just the pages ending in 06 until the end of the exhibit.
No objection.
Exhibit 302, all pages mentioned are admitted.
Thank you, Your Honor. And I have nothing further at this time.
Okay. Cross-examination?
Sure. Your judge or Mr. Whitley's testimony about employees who are temporary and don't get benefits. Do you recall that testimony?
Yes.
And you were a temporary employee, as we've just seen from 302?
Yes.
And you didn't get benefits, true?
I didn't get health insurance, dental, that sort of thing. That is true.
You didn't get any benefits, did you?
I didn't have any expectation of getting those types of benefits like retirement, dental, health insurance.
All right, I want to go back to February 16th of 2023. You had been dealing with the parking attendant. English was not his first language, did I hear you say?
That's probably me being over my seat. I believe he had an accent. I assume that means it's not his first language.
Okay. And you thought you were entitled to a discount for parking?
Well, he did too. I mean, he said employees.
No, I'm sorry, I'm asking about you.
Yes, I believe that I was entitled to the employee discount afforded to all King County employees.
Okay, and the first time you you showed him the plaque that we saw?
I don't recall if that was the first time, but it may have been. I think that was when he had asked me if I had a pay stub I could show him.
Okay, you showed him a plaque and that didn't work, right?
Right.
Did you go to HR or the court administrator at that point to try and clarify things?
No.
Okay.
And
Then the
there's a
next,
reason for that, if you want me to explain.
no, that's all right. The next time you didn't try your plaque, you tried your robe, right?
I don't recall if it was the next time sequentially, but yeah, on one of those occasions, I grabbed my robe.
Okay, and that didn't work, did it?
No.
And did you go to HR or the court administrator after that effort failed?
No.
So the next time then you tried your plaque, you tried your robe. The next time then is when you tried to, or when you created the letter, right?
Yeah, again, see, I'm not certain of the sequence, but that's generally, yeah, that's accurate.
And you told us this morning, if I recall right, that you intentionally put Judge Robertson's stamp and the court seal right under the text. Remember that?
I think I said proximate to the text, but yeah, that was the idea.
Okay. And those, you said this afternoon, those were the heavy lifters, right?
That's something, yeah. They did the heavy lifting, something like that.
Heavy lifters, meaning they had the most import, right?
Those were the important ones, yes.
Okay. And you put those heavy lifters there to try to kind of push the ball over the goal line and finally get that $10 discount?
I did it to help corroborate my status as an employee by having access to stamps that a member of the public would not otherwise have.
And get the $10 discount?
Oh, yes, that was the object. I mean, yes, that was.
Okay. Have you previously taken the position that instead of heavy lifters and the like, that this whole thing was a farcical document adorned with multiple random stamps?
I think even the partial picture that you have been displaying today makes it clear that this is not an official court document. It's not a pleading. It's not a court order. And it obviously was not taken that way by the parking attendant or by Ms. De Los Santos.
I'm sorry, I think I probably asked a bad question. I thought I asked, have you previously taken the position that instead of heavy lifters and the like, that this was a farcical document adorned with multiple random stamps?
I know that I've used that phrase. Yes, it was either in my email to Judge Robertson or in one of my letters to the CJC prior to the statement of charges.
Well, no, actually, it was in your answer to the statement of charges. After you were charged, you told the commission that this was a farcical document adorned with multiple random stamps. Did you not?
Sorry, am I in the answer to the statement of charges?
Yes.
Yeah, I might have. Let me, if I could just confirm. No offense, Paul. Just, trust but verify. Where in the answer to statement of charges?
If we could have up Exhibit 202, paragraph 1.6 on page 3.
Yes, that's part of that sentence. Respondent did not present the document as an official court document and explicitly stated it was a document of respondent's own making. In other words, respondent created what he intended to be a farcical document adorned with multiple random stamps, all in an effort to corroborate his truthful assertion that respondent was a pro tem judge with the district court.
Farcical document adorned with multiple random stamps. But now you say you intentionally, in this farcical document with multiple random stamps, you intentionally put the heavy lifters first, right?
You're saying I now say, I mean, that the stamps are where they are, but yes.
Okay. And you repeatedly, in your answer to the statement of charges, not before the statement of charges, referred to it as a farcical document, yes?
Yes. I stand by that.
And you talked about you've repeatedly tried to accept responsibility for what you did. Did I get that right?
Yeah, your question is if I have repeatedly said that I have tried to take responsibility?
Yeah.
Yeah, I mean, I have repeatedly tried to take responsibility, yes.
Isn't it true that you were upset then when the matter was referred to the CJC?
Was I upset that it was referred to the CJC?
Yes.
Objection 408.
Objections noted, overruled. He can answer.
Yes, I think any judicial officer would be upset if a matter is referred to the CJC.
So
you can be upset about something that you regret. These are not mutually exclusive. I regretted what happened. I was also very upset that it's going to become a CJC thing.
well, in fact, you were bothered that Judge York was pursuing the matter, right?
I don't know if he's the one that filed the CJC complaint. He filed a bar complaint against me, and that was upsetting. It was dismissed, the bar complaint, and then he filed the CJC complaint. As far, that's I'm surmising that. And yeah, it's upsetting. Because by that time I had already resigned. I'd already explained my, it's possible to maybe fire somebody without destroying their life or allowing them to resign. And, okay, he suffered a consequence here. Judge York, I believe, also contacted the Snohomish County bench and got me suspended for a while. Again, I don't have proof, but that's my belief. That's what I meant by pursuing it, is he seemed like he had it in for me.
By the way, you talked about how this was on plain paper.
It was on plain paper, yes.
Okay, and then not on bonded letterhead.
It was not on bonded letterhead.
And Judge Robertson didn't have any bonded letterhead in her chambers, did she?
Don't recall.
Well, why don't you take a look at your deposition, page 28, lines 19 and 20.
I'm sorry, lines 19 to 20?
19 and 20, yes.
Okay.
Because Judge Robertson didn't have bonded letterhead that I knew of. Do you see that?
That's exactly what I just said to you just now. Not that I'm aware of. I don't know if she has letterhead, bonded letterhead.
I don't have anything further. Thank you, Your Honor.
All right, thank you. Redirect, Ms. Bremner.
No, thank you, Your Honor.
Okay. All right, thank you, Judge Rozuma. It's 4:45.
Panel members.
Do we have, I don't know if any panel members have questions.
Oh, thank you. I'll turn to the panel members. If you have questions, you could certainly let us know and you could pose those. Yes, Commissioner Ashby Scott.
Thank you. Hello, Judge.
Hello, I'm not seeing you. Let me just adjust the view on my
I've got it on gallery.
Okay, I see you now.
Okay.
Thank you.
I heard that you mentioned that the other pictures, or excuse me, the other stamps on the page were not in the picture. And you talk about some of the other stamps that were not pictured on that. Do you recall or do you know if your stamp, the couple of stamps that you mentioned that were on that page, do you know if they were self-inking stamps or not?
That's no, that's fine. The so they were all self-inking. The one that says David Razumna, Judge Pro Tem, is where the stamp impression actually in a cylinder gets, it flips around and it stamps the page and then it flips up. So that was like a physically larger stamp. The Commissioner Pro Tem one, I think it's called a self-inking stamp, but I don't think it's one where there was a rotating mechanism. I think you just apply the pressure and then ink just kind of, new ink just absorbs into the sponge part of the stamp. And the address stamp is the same as the Commissioner Pro Tem one, where there's ink that is in it that is automatically fed, but I don't believe that has that mechanism that rotates the stamp physically.
Thank you.
Thank you.
All right, let me just follow up before I ask Commissioner Briggs her question. Does that raise any questions for either counsel? Ms. Bremner?
No, thank you, Your Honor.
No, Your Honor.
Okay, thank you. Commissioner Briggs, you had a question? Oh, looks like you're muted.
I apologize. Have I got the hang of this now?
You do.
Goodness, I'm sorry. Mr. Taylor, a question for you, please. Could you please tell us if the letter that we've talked a lot about today showed any evidence whatsoever of being either cut or torn? Or is it your belief that what we are seeing is was its original size?
I'm sorry, Your Honor, was that question directed at me or Judge Razumna?
If it was directed at Mr. Taylor, I would put a little deflection mechanism to aim it towards Judge Razumna. Commissioner Briggs, is that accurate?
It was directed to Mr. Taylor, please.
Okay, so Mr. Taylor isn't going to answer a question, so I won't allow him to answer that question. But if you wanted to pose the question to Judge Razumna, you could do that.
Yeah, no, the document that I handed to the parking attendant was a fully intact 8.5 by 11 piece of paper. I don't know what they did with it subsequent. I don't know its condition when De Los Santos took a picture of it. I mean, I hope that answers your question. I'm not the one who did that.
Thank you.
Does that
I wish I had taken a more fulsome picture of it.
Does that question and the response prompt any questions from you, Ms. Bremner?
No, it doesn't. Thank you, Your Honor.
Mr. Taylor?
No, Your Honor, thank you.
Okay, all right, thank you. Commissioner Hadeen has a question. Go ahead.
Yes, Judge Razumna, can you tell us how did you create the document? Was it on a typewriter or a computer or some other fashion?
The computer, and I used Microsoft Notepad, not the full version of Word. It was just the quickest thing to pull up. And it has less functionality than Microsoft Word. I just typed up the sentence and hit print.
Thank you.
Does that raise any issues for you, Ms. Bremner?
No, thank you, Your Honor.
Okay, Mr. Taylor?
No, thank you.
All right, thank you. Any other panel member questions? All right, very good. Thank you. Before we kind of move on to a next witness, I just want to pause for a little bit and just get a feel for where we are in the process, recognizing it's about 4:50, 10 to the hour, and with the expectation that we may be finishing within the morning hours tomorrow. So I just want to touch base with Ms. Bremner and Mr. Gross to if you can just give me an overview of additional witnesses that are forthcoming and general timeframes expected.
We have no further witnesses, Your Honor.
Okay. All right. And are you resting at this time?
Yes, we are.
Okay.
Respondent rest. Thank you.
All right. Thank you. And then, Mr. Taylor, do you anticipate any rebuttal witnesses testifying tomorrow?
No, Your Honor.
Okay. So at this point, let me just touch base with the parties regarding any exhibits, and we could have handled this in one or two ways. One, we could handle it right now. We could utilize the time until 5 to address any kind of tidy up activities, or we could address those tomorrow morning when had a little more time to look at things. So just kind of curious what your preference is.
I'm not sure we have anything on our end, at least, that needs tidying. We've got in the exhibits we needed.
Okay, thank you.
And we agree for our side, Your Honor.
Okay. All right, so with that, I guess at this point, our plan would be to reconvene tomorrow morning at 9 a.m. with the expectation that there would be a closing argument presented by disciplinary counsel, then respondent counsel, and then we would begin deliberations thereafter. Is any concerns with that plan from any of the parties?
No, Your Honor.
Yeah, I'll forward that.
If I just have a moment here.
Yeah, so we just want to confirm that Mr. Cooper will be taking down the live chat as soon as the stream is over, because obviously the behavior, as you can imagine, has continued.
Okay, Mr. Cooper, are you on the line? And did you hear that request?
Yes, I heard the request, and I'll do so.
Okay, that's great. I appreciate your help, Mr. Cooper. And just an expression of thanks to Ms. Rekab for your great help and assistance. Really appreciate the seamless service that you provided today. Ms. Callner, do you have any comments?
No, thank you.
Okay, great, thanks.
Oh, excuse me. I would just remind the panel that as final argument has not yet been presented, please refrain from discussing the merits of this case with other panel members or anyone else.
Yeah, I'll echo that also. No discussion, no research, nothing, no exploration of anything raised during the hearing today. I appreciate everybody's really dedicated and focused effort today. Much appreciated, and really speaks well of everybody here involved. So at this point, we'll recess for the evening, and we'll start promptly tomorrow at 9 a.m. If you could, I think the Zoom is can open up as early as 8:30 if you want to join that early, but no later than 8:45. That would be appreciated. So 8:45 at the latest. Brownie points if you're logged on at 8:30. Great. All right. Thanks, everybody. Have a good evening.
Thank you, Judge.
Thank you, Your Honor.